Good morning. Good morning. Good morning. And I have to think as the gavel drops, they just notified everybody that I'm live. They are a Discord server and they always announce when I create a live, when I'm going live. They do that for a lot of the true crime YouTubers, and I appreciate them so much. My um, subscriber count has gone up. Still not there yet, but it has gone up tremendously since I have partnered with them. So please go check them out. They have documents from legal documents from all of the trials that are going on, ones that I'm covering, ones that other people are covering, ones that are just law and crime and court TV are covering. They're great. They have wonderful people over there, wonderful mods. They're great. Go check them out. So today is closing arguments. So let me put up my warning banner because this is likely to get into some very sensitive, disturbing testimony. And there will be victim blaming. However, in this case, I don't think it's unwarranted, to tell you the truth. Um, my opinion on this case. Do not start. We just got started. What the heck? Thursday, y'all. Thursday. Thursday. Oh, yeah. This prosecutor. Now, this prosecutor did not upset me as much as the prosecutor in the Ashley Benefield case. That woman was just, she was a mean girl. I mean, she bullied that poor lady. And I know that a lot of people disagree with me on that case. That's a good split. That's I don't know percentage wise the split on that one, but I know that seems like I've talked to just as many people that say I don't believe her. I think she wanted him gone. I think I've talked to as many people that think that as think that she was in fear for her life and she did what she had to do. Um, so I get it. That one I get. This one, and I don't know. There may be people that disagree with me on this one too, but the prosecutor made it seem like he dragged her by the hair into the house. Like as soon as she got there, like he went to the car and grabbed her by the hair and drug her in the house. And that's not what happened according to the witnesses. So it seemed to me like the prosecution embellished what actually happened. And that's just my take on it. So, I have a bad habit of saying, but I could be wrong. I'm going to quit saying that because that's just a bad thing to speak over yourself. I quit saying that because that's my opinion. It doesn't make it wrong. That's my opinion. Um, I think he embellished his his um version of the story of the events. So let's see if he embellishes his closing argument. Dang! I forgot to share screen again. I scrapbook. I think I'm gonna get the Cricut out and make me a nice, pretty scrapbook page that says "Share screen, Debbie," and like frame it and put it right here. Hang on, Belle. I'm coming. She's barking at the door. I swear I could teach her to use a doorbell. And she has to go out one door and come in another.
Good morning, ladies and gentlemen.
What are you
In this
doing?
case, as I mentioned yesterday,
Yay! Oh, wait. I should turn my camera off.
I'm sorry, was there an issue, Miss Samaro? Oh, not in the chat. Okay.
Oh, she's at the other door now because I didn't get to the front door fast enough.
All right. As I mentioned at the end of the day yesterday, both the state and the defendant have rested their cases. The attorneys will now have the opportunity, if they wish, to make a closing argument. Please remember that what the attorneys say is not evidence, nor is it your instruction on the law. However, do pay close attention to what they have to say. Their arguments are intended to aid you in understanding this case. Each side will have equal opportunity, but the state is entitled to divide its argument between an opening and a rebuttal after the defendant has given a closing argument. Does the state wish to give a closing argument?
I do, Your Honor.
You may proceed.
Ladies and gentlemen, the brutality and the carnage that Colin Griffith unloaded on his mom on September 8th of 2024 is as real as it gets. First, I'd like to thank you for not only being here, but for your attention. When you came to jury selection, you had no idea what type of case you might encounter. Would it be a petty theft, a DUI? But what you ultimately heard and sat on was a first-degree murder case with a second count of kidnapping. So to hear and see what you had to go through is not something that jurors see every day. And most certainly most people never think about or see. But you've heard and seen the evidence. And later this morning into the afternoon, you will be doing what you came here to do. And that is to dispense the ultimate form of justice. Not because I'm asking you to do this or suggesting you do this, but based upon the facts and the evidence, the defendant sits there, a guilty person who stabbed his own mother in the neck and then watched her bleed out in front of him. The lady that brought him into this world here on earth. But see, at the end of this, he has to watch you come back through those doors. And he has to stand and he has to listen to the verdict. And that verdict is out of my control. It's out of their control. It is 100% in your control. And I have faith and confidence based upon what you heard and saw that you will do the right thing and you will hold him accountable for the fury he unleashed on his mom. Because the cold hard facts and the reality is quite unthinkable when you really think about it. The reality of what that person did to his mom
It's unthinkable when you really think about it. I'm sorry, that just struck me as funny. It's unthinkable when you really think about it. He's not a wordsmith, is he? Sorry.
She left this world knowing that the person that took her out was the son that she gave everything to. When you're in the quietness and the privacy of the jury room, I want you to take a close look at that knife. And remember, each inch that knife went flying through Kathy Griffith's neck, through each part of her human anatomy that Dr. Graham described. Because the reality of it, for what the defendants accomplished, which is exactly what he wanted to do for so long, on the wall. The defendant knew what he wanted to do, and it was just a matter of time. Why? Why did he have such deep-seated hatred for his mom? The lady that was just concerned about him making it to Domino's to work his 4:00 shift on Sunday.
Hush.
That's all that she wanted. They can say whatever they want about Kathy Griffith. It's all right. I'm not afraid. You shouldn't be afraid either. Because on Sunday, September 8th, Kathy Griffith did no harm.
Look up here.
Meant no harm to her son, Colin Griffith. She had one objective only, that cost her her life.
Hi.
And
Say hi.
I don't know if it's sad or if it's admirable, but she knew and was willing to die and knew she would die at the hands of her son just to spend some more time with him. We heard from Detective Lacey Zenoniani that Kathy Griffith literally said she knew she would die, but as long as it meant that she could spend some more time with her son, it was worth it to her. And what thanks did Kathy Griffith get from her son?
Whoop, whoop, whoop. Oh, no.
What thanks did she get?
She got
got
mic. We got it on the
a
mic.
foot-long butcher knife rammed into her neck.
On the mic.
And you heard the pathway of destruction.
Get off the keyboard.
Feeling everything through her neck, through those neck muscles.
Yes. It's all Judy's fault. Can you please? You have gotten salmon on my mic, dear. Yuck.
Gaping open wound in her neck complements of her son. Thanks, Colin Griffith. Appreciate that. Carrying us laundry, buying him Starbucks, taking him to the movies, buying him things, getting him a phone, a computer. Now, yes, these are things that you would hope a mom would do, but not all moms do that. Whatever issues Kathy had, she didn't lack for love of her son. She wasn't there to do him harm on September 8th. Her motives were quite simple. Her motives were for Colin Griffith to return to her household by 10 a.m. Sunday. That's all she wanted. She wanted her son, who she was dusting off his domino shoes and making sure that he had a clean uniform, to be home in time to go to work. That's all she wanted. The clock was ticking. Once he turned 18, she knew he was gone. He wanted nothing to do with her. He had already killed somebody in Oklahoma, and she knew what was going to happen to her. But despite that, all that she wanted was every single minute she could have with her son. Well, she got to spend the last seconds of her life with her son as he watched down, as she gushed blood out of her open, gaping wound. The death was not instantaneous. She bled internally. She bled externally. She was fighting to get up. You see her arm finally comes underneath the island. And there comes a certain point, ladies and gentlemen, where that last drop of blood came out of her, where she took her last breath and she died and left this earth knowing that her son butchered her. And that's the reality of it. You take a look at that knife and you'll know what it went through, who it went through, who was holding it, what their intention was, and what they wanted to do. Operation Kill Mom accomplished. That's exactly what Colin Griffith did.
Oh my God. Dude. Operation Kill Mom.
It's a little PowerPoint here for some things to look for you to remember when you deliver. September 8th, 2024, Kathy Griffith was murdered by Colin Griffith. That's as simple as it gets. But going back the year earlier, the first person the defendant killed before he killed Kathy Griffith, he killed that person when he shot that person 2 times with a handgun. the recordings of you admitting to killing, and then she wrote the person's name, the Ring camera, are all going to Bob, Susie, Amanda, and Chris at 3 p.m. today. Plus the recovered audio from Chuck's iCloud where you told your dad you hated me and I was an evil bitch are being sent too. Let's stop for a minute. The defendant called and thinks his mom was an evil bitch. That has just so much malice and hatred, once again, to the lady that was.
Oh my God. How many teenagers has called their mother an evil bitch? Seriously. Seriously. I don't think that's uncommon. And I'm sure of those teenagers that have called their parents evil or any other word, they've not killed them. I don't like this case.
Trying to do everything she could. I mean, God, we saw Ring videos. She's cleaning all the time. She's doing laundry. She makes sure that his house is stocked with food, computers, cell phones. She's giving him a credit card to go to Starbucks to buy sandwiches and drinks, taking him to the movies, anything and everything to make him happy. And you know what kind of thanks she got. Thanks to Colin Griffith, stand-up guy that he is. And then what did she expect from him? Did she expect for him to be remodeling the house or doing all this work? No. She wanted minimal things. She wanted respect as any mother deserved. She wanted the defendant to pick up a damn finger and do some chores, to weed whack the backyard. Was it 10 acres of property that she wanted him to go outside in the 90-degree weather and push a lawnmower? No. It was a.
There were many people that told him or told her not to go over there. Her mom, Lacey, that detective, there was somebody else. I don't remember who it was. So there were 3 or 4 people that told her not to go over there. And she went anyway. And she had just left him alone. And the part about she was getting his Domino's uniform ready and she wanted him to come back home so he wouldn't be late for work. I don't remember hearing that anywhere in the trial at all. I just remember her wanting him home because she wanted him home. She kept saying he wasn't supposed to be at his grandmother's house. It's in a different county and he wasn't allowed to be there because of his bond conditions, which was not true. He was allowed to be there. She was his grandmother was his other guardian. So like he's saying stuff in his closing that I don't remember from the trial. Which I don't know why they're not objecting so they can preserve it for appeal, but whatever. Because I don't remember that being said in the trial, unless I missed it.
A nice, modest backyard that she wanted the defendant to take care of some business, like the man to. But if it interfered, God forbid, with him playing video games or him taking his walk, then piss on his mom. That was 100% his attitude. He didn't want to be bothered. She wanted him to put up a bookshelf. The defendant didn't want to do it. She wanted him to clean up the room because there were a bunch of ants and cockroaches that were crawling around Colin Griffith's candy bags, but it might interfere with him getting some fresh air. So he just blew her off. Day after day, time after time, the defendant wanted to do nothing but what he wanted to do. And you know what?
Yeah, I know you can't hear. connection to my audio again.
That she is an evil bitch. This is what he's saying about his own mom, who brought him into this world, his own flesh and blood. And that's what he thinks of. Kathy continues on. My dad is sending me his recordings of you telling him how you planned my murder back in February. Audio, video, email, text, and phone records are all being sent. So day of Kathy Griffith's life. The defendant's life would go on. I'm going to beat his ass. I'm going to stab him. I'm going to shoot him. I'm going to do any of that stuff. She wanted to go over there and bring him back. She didn't even want to have to go drive 2.5 hours over there. It would have been real simple if the defendant just came home. But once again, that's beside the point, because the reality is he didn't come home. He didn't want to come home. That's the way life is sometimes. But she wanted to accomplish one thing, to have the defendant come home, not to do him harm. And she did nothing to him. No violence, no threats, nothing. That was it. She even told her mom, one of the last conversations was when she got over there, if he refused to come, then she would call the police. So there's Kathy wearing the exact clothes that she changed into that she would die in. She was a big fan of coffee. The shirt she was wearing said something about coffee or die, kind of like the motto, live free or die. So there's Kathy, unsuspecting of what would happen a few short hours later, with her black t-shirt and her jean shorts and her black Under Armour flip-flops that she would be killed in. She picked up her Kate Spade bag, purse, backpack, put it over her shoulder. Interestingly enough, if you call one of the ladies, I don't recall, told her she threw her and she went out of the house. It appears that she carried her bag. The same bag, ladies and gentlemen, and she was holding when the defendant attacked her and stabbed her in the neck, the same bag that got blood all over it, holding her bag over her shoulder, and her keys and everything else that fell on the ground when the defendant attacked her. Does that sound like somebody, a lady who's attacking the defendant with their bag over their shoulder, holding their car keys and their charger? Of course not, because it didn't happen that way. And then this was it. You all remember when the door closed. In retrospect, it's quite easy. Clean. Kathy went off with her bag over her shoulder. A stocked fridge, stocked snacks, clean. Doesn't look like there's a thing out of place. Keeping a clean, safe environment for Colin. Did Kathy have issues she had to endure? Did that mean she should be stabbed and left to bleed out by her own son? Of course not. That's why he needs to be held responsible. So this fancy overhead picture. What is the importance of this? Well, now I'm going to talk a little bit about the jury instructions. I'm not going to go into a bunch of jury instructions. You're going to hear those. They're very important. They're long, but I'm going to hit you with two quick things: the first degree murder and the kidnapping. I want you to look at this picture here. This is where Colin Griffith murdered his mom with premeditation and intent. This is where Colin Griffith stabbed his mom and killed her. You see the mulch, you see the entryway, you see the carport. Now you'll recall that Miss Sally Bell, the lady getting ready for church, lived right here. Nancy Jones lived here. Nancy Jones had a more obstructed view just because of the sheer angle of it. This corner here, so the defendant reached out, grab Kathy, and pull her in. Now, Sally Bell had a much clearer view. Sally Bell, time is important, okay? Time is important. You guys like a good timeline, and you have a pretty good timeline. Sally Bell goes to church religiously, no pun intended. She gets ready, she leaves roughly a little before 5 o'clock. Every Sunday, her and her husband get ready, they go to church. The defendant wasn't going to church on Sunday, he was getting ready to murder his mom.
Oh my
So
God.
Bell, she sees the defendant after Kathy comes over, and is Kathy mad? Is she happy? Of course she's not happy. That doesn't mean she's being violent, and she wasn't violent. She was moving her hands. Sally made it clear. It wasn't threatening or violent or physical. He
wasn't getting ready to murder his mom. He didn't even know she was coming over there.
was animated, moving her hands as she was talking. And she wanted her son to come home. That's it. Nothing more, nothing less. So Sally saw and heard, she saw the defendant grab his own mom. Remember, this isn't a stranger, which would be bad enough. He grabbed his own mom by the hair. He thinks she's an evil witch. He wants to kill her. He's told people he's going to kill her. He's battered her and attacked her before on November 14th in Port Charlotte. And now he's just doing the same thing again. And his mom paid the price. But you know what? He's going to pay the price when you come back with a guilty verdict. He is going to pay the price because of your verdict. And he grabbed his mom by the hair, and she said, stop, you're hurting me, let go. This is his mom begging and pleading for her own son to stop pulling her hair. Who does that? He does that, and he did it. So what happens? Who's doing violence to who? I ask you that. Who is being violent to who? The mom is not being violent in any way, shape, or form to her son. She did nothing to him. Nothing to him. But good old Colin Griffith grabs his mom and he yanks her, he pulls her, he drags her. Who cares what verb you want to use? The point of the story is that he pulled her and dragged her into the house. She didn't have a choice because her hair was being pulled and her head and her body was being dragged into the house. Do that because he was about to unleash and quench his bloodlust. His mom. He was going to accomplish what he wanted to do for whatever it was, weeks, months, a year. And his bloodlust was going to be quenched at the price and at the cost of his mom and her dignity and her life. So why did he bring her inside? Well, it's quite clear why he brought her inside: to unleash additional violence on her. He wanted to isolate her. He didn't want witnesses to what he was about to do. Okay? That was roughly around 5 o'clock. Now, I want to tell you something. The 911 call was at 6:14, okay? That is an hour and 15 minutes. I'm going to tell you something. They weren't talking or hanging out for an hour. It was What was he doing for that 15 minutes after he killed him? Connect the dots, do the math. But as soon as he pulled her inside, it was just the continuation of the beginning of the end. So for kidnapping, I'm going to start with count two. Count two, kidnapping. This is what I have to prove. 3 elements. Colin Griffith forcibly or secretly or by threat confined or abducted or imprisoned Catherine Griffith against her will. That's exactly what he did. He forcibly grabbed her by the hair and pulled her inside.
Kidnapping is not if you enjoy being taken somewhere. It's if you're taken against your will. I've gone lots of places I didn't enjoy going, but I did it because I had to. It doesn't mean I was kidnapped. Like I said, this guy's not a wordsmith. You need to work on your openings and closings, dude.
When, as she said in one of the videos, when he already beat her ass on a number of occasions, forcibly did those things against her will. So now Kathy knows what's going to happen. Maybe she doesn't know she's about to get killed, but she knows the violence that's about to happen. Because now the defendant has her all alone with no eyes to see, no neighbors to help, and he has her all alone. He's a lot bigger than her. He's a lot stronger than her. He weighs a lot more. He's younger than her. And she was alone. Now, this is no stranger to her. She shouldn't have had to have been afraid of her own son. But now the reality is he's dragged her in by the hair.
He wasn't afraid.
She's begging for him to let go. But does he care? No. And he amps it up even more. He yanks her and pulls her so hard that, as we recall, in the mulch here is one of her AirPods. Boom. They go inside. She would, you know what? She never came out of that house again. Thanks to Colin Griffith. This is the last time that she would enter any place. And this is the pathway to further destruction. This is literally the trail to her death at the hands and the knife. He yanked her by the hair. She didn't stand a chance. He dragged her, pulled her, get out at the source, use whatever words you want to use.
I'm just gonna. Oh, maybe I don't have to reload it. I was gonna reload it, but it came back. But she wasn't afraid of him. The witnesses say she walked up the steps. He didn't drag her in the house. She walked up the steps. He was pulling her hair, but she walked up the steps. She was not afraid of him. Yeah, she could have called 911. She threatened to call 911 when she was on the phone with him. She told him she was going to call 911 or call one of the cops on their case, and she didn't. Well, actually, she did earlier talk to Lacey, and she told her not to go over there, and she didn't listen. So many ways this could have been avoided.
And he brought her, boom, through the living room. Her other AirPod falls out. This is the violence and the force of AirPod case.
Oh my God, you can sneeze and those things will fall out of your head. A strong breeze can blow those things out of your ears. For crying out loud. That is ridiculous.
And we know where this is headed. We know the path that this is headed. That house is immaculate. That is evidence. Chapman keeps an immaculate house. Kathy Griffith, her daughter, keeps an immaculate house. There's no signs of this. There's no desire to fight. All the size to his deep in her neck that it literally came out the other side of her neck. That, ladies and gentlemen, is Colin Griffith. Colin Griffith dragged his mom. Griffith, in his mind, now we're moving on. Well, I suppose before we move on to kidnapping, we've already hit the first one. Second one, Colin Griffith had no lawful authority to do so. Of course, he had no lawful authority to do so. You don't have lawful authority to batter somebody, to grab them by the hair against their will and yank them into a house so you can abuse them and violate them and destroy them more. Element 2 is proven beyond a reasonable doubt. And third,
It's not.
Colin Griffith acted with intent to inflict bodily harm upon or to terrorize Catherine Griffith or to commit or facilitate the commission of any murder. That's a lot of words, but you'll take your time when you have the jury instructions. What did Colin Griffith do? He acted with the intent to harm Kathy Griffith, to physically destroy Kathy Griffith, to terrorize Kathy Griffith, and to kill Kathy Griffith. That third element's proved every which way possible. Because of that, ladies and gentlemen, the defendant is guilty of kidnapping. So when you deliberate and when you talk about the evidence and the law, and when you discuss amongst yourselves, and when you do the analysis, I submit to you that I have proven through the evidence that the defendant is guilty of kidnapping. But only if it could end there. Only if it could end there. Life would have gone on for Kathy Griffith. But it couldn't end there because of the defendant's conscious decisions. Because of his actions, it couldn't end there. Life could have gone on, but it didn't for Catherine Griffith.
Did you guys lose sound from the court? Because everything looks good on my end, but it said having trouble connecting, but everything's working fine. So I don't know what's going on. Yeah, that is really dangerous if she's driving with her AirPods in. That would be stupid. Oh, okay. He said in opening that she'd like to have them in and listen to music all the time. I wouldn't think that included the driving, especially if she's driving alone. What would be the purpose? And he wasn't sitting there waiting for her to get there so he could kill her. He was ignoring her because he didn't want to deal with her and her crap. And something that just because said, I wanted to comment on it and I didn't star it. Oh, there it is. He's a teenager, right? So she's outside yelling at him, flailing her arms everywhere, throwing his clothes in his car. He's probably being like, Mom, come in the house, come in the house, come in the house. Because he's embarrassed. I would be. Who knows what neighbors are out there watching? So he just grabbed her any way he could and took her back in the house. That's a possibility. But like I said yesterday, and just because agreed with me, this case is full of supposition. There's no way to know what actually happened. There's just no way.
Because of what the defendant wanted to accomplish and what he didn't stop doing until he had accomplished it. And then to figure out, dang, everything that happened next. So we move on to first degree murder. That, once again, these aren't abstract concepts. This is the reality. That defendant reached the butcher block and pulled out a knife.
The knife
It
was
probably
in the
made that
drawer.
sound when that metal comes out of the wooden butcher block.
It was in a
Well,
drawer.
Kathy didn't have her AirPods in, so she can hear crystal clear. And that knife comes sliding out of that butcher block.
It was in a butcher block.
And Kathy would have known at that point.
Oh my God. Oh my God. Justified that it was. I wish I had downloaded the dumbass clip. I found it, but I didn't download it yet because my internet is glitchy. I can't wait till Thursday. I'm gonna download that dumbass clip though. I did find it. The one of Red saying dumbass. It would have been perfect right there because he's a dumbass.
What the defendant had told her, what the defendant had told law enforcement, that he would kill her and stab her. That's how it was going to end for her. Picture doesn't quite do it justice. I'm not going to stand up here and hold the knife because you're going to look at it. And so Kathy gets stabbed in the neck with such force. You know the pathway. You know everything that happened. You heard from Dr. Garavin how many countless stabbing cases he's worked. Never has it been an accident or somebody falling on a knife. The force that knife took, the things that it cut through, the open, gaping wound, her bleeding out to the last drop is gone. So, back on September 8th, 2024, after Kathy struggled to get up, struggled to do whatever somebody who's just about to die tries to do, knowing that their son just ensured their death. Mind you, this was at about 5 o'clock, ladies and gentlemen, because that's when Sally Bell saw the defendant yank his mom in by the hair. 5 o'clock. Yet it takes an hour and 14 minutes for the defendant to call 911. Yeah, it did. You're going to hear two clips. One is just the very intro. It establishes the time. It establishes the first words out of the defendant's mouth. Then you're going to hear the defendant's contradictory, absurd attempt at blaming Kathy Griffith for this. For first-degree murder, I have to prove three things. Catherine Griffith is dead. That's an understatement. Number two, the death was caused by the criminal act
That's not an understatement.
of Colin Griffith. It was a homicide by Colin Griffith, stabbing his mom in the neck and watching her and letting her and being happy that she bled out and died. And three, there was a premeditated killing of Catherine Griffith. Ladies and gentlemen, when the defendant dragged her inside and dragged her to the back of the house, to the kitchen, when he think about it, any step of the way, he could have thought to himself, you know what? This is messed up. I shouldn't be doing this. I can't be doing this. Yeah, I want to kill her, but this is my mom. You know what? Dang, I'm going to stop. I'm not going to do this. He had time to reflect. But his reflection was it Colin 1 or Colin 2? We'll get to that a little later. But his reflection was, yeah, I am going to kill, I am going to stab this evil bitch. And that's not me saying it. That's the defendant's own words. He showed his intentions by his actions and by his words and what he said he was going to do. He was going to kill that evil bitch, his own mom. And so he did. So Kathy Griffith is laid out on the floor, has taken her last breath, has bled out her last drop of blood. Catherine Griffith has been murdered by Colin Griffith. The crime is over. The defendant is guilty of first-degree murder. Now, not to complicate things, but there's another way that I can prove first-degree murder. And I submit to you, I've proved it both ways. It's my burden, of course, to prove the crimes beyond a reasonable doubt. But there's two different ways that I can prove first-degree murder. Both end with the same result, which is guilty of first-degree murder. The other way that I'm not going to spend a lot of time on, but it's called first-degree felony murder. I've already shown you, ladies and gentlemen, why the defendant is guilty of premeditated first-degree murder and why the defendant is guilty of kidnapping. So when you go back and deliberate and when you fill out the verdict form, while it might not be easy and nothing is ever happy about sitting on a murder trial, but you'll know that you did the right thing based upon the evidence and based upon justice. So the defendant's guilty of first-degree murder, premeditated, and kidnapping. Another way that a prosecutor can prove first-degree murder is first-degree felony murder. And I'm going to tell you this first, little insight. In order to convict the defendant of first-degree felony murder, it is not necessary for the state to prove that Colin Griffith had a premeditated design or intent to kill. When you run through the three elements, Catherine Griffith is dead. That's number one. Number two, while engaged in the commission of a kidnapping, Colin Griffith caused the death of Catherine Griffith. And three, Colin Griffith was the person who actually killed Colin Griffith. Her own flesh and blood brutalized her. We'll go to the 911 call, probably an hour or so after he had already murdered his mom.
I know that was a slip of the tongue, but it was funny.
18/14/11, 2nd September 8, 2024.
911, what's the address of the emergency?
Hampton, Florida. I don't know the fucking, I don't know the secret.
Now, clip two. What I want you to notice about clip two, ladies and gentlemen, is that the 911 operator asks a very clear, simple question. Listen, what caused the bleeding? And you're going to hear and see, and you probably remember that the defendant didn't respond for many, many seconds, maybe 6 seconds. He didn't respond. And the 911 operator said more emphatically, listen, what caused the bleeding? And then the defendant gave two diametrically opposed different explanations because he wasn't going to tell the truth about what happened. And he was certainly going to try to escape from the charges and blame his mom when he is the person that murdered his own mom. So the first thing he says is, she got into a fight. What do you mean she got into a fight? Like he's trying to distance himself from what actually happened. She got into a fight and she lunged at me with a knife and she fell on it. So that's his first explanation. He's painting a picture that his mom lunged at him with a knife, tripped, and somehow fell on the knife. That's preposterous. Not being disrespectful, but that's preposterous when you think about common sense and you think about physics and when you think about reality. That just didn't happen. The evidence is to the contrary, but that's his first statement, that she lunged at him with this knife and tripped and she somehow falls on the knife. That didn't happen. Then the 911 operator says, where is the knife right now? And who did she get in a fight with? And then the defendant says something completely different because it's not the truth. The truth doesn't change. The truth is that the defendant stabbed his mom right in the neck, and then it ripped through and came out the other side. That's reality of what happened. And then the defendant changes his story. He thinks he's helping himself by elaborating or trying to prove to himself what happened or prove to others. And then he changes his story. Instead of her lunging at him and falling on the knife, now he says, she came at me and we got into a fight for a long time. Then she got on top of me and fell on it. Twisted it back, whatever that means.
That's not a different story.
So listen, what caused the bleeding? Listen, what caused the bleeding?
She got so tight and she was getting into the knife and she fell on it.
Where is the knife?
We got so tight for a long time. Then she got on top of me and fell on it. She's back.
Colin Griffith murdered his mom, ladies and gentlemen. This is a picture of Griffith with that murdered her son. This is a picture next to the same person that she knew was going to kill her. Yet she was willing to suffer and pay the ultimate price, that was her life, at the hands of her son in order to spend a little more time with him before she left this earth. So that person, Kathy Griffith, live, full of life, smiling and happy, turned to this person, bleeding out on her mom's kitchen floor with her good old son standing by to watch her bleed out. And there's her Kate Spade backpack purse that was over her shoulder. Once again, you saw it over her shoulder in the video. You also heard from Nancy Jones that when Kathy went up to the house, she had a bag over her shoulder. And that bag got drenched in blood as it literally spurted out of the huge gaping hole in her neck, compliments of her son. When fire rescue shows up and law enforcement shows up, they say they can literally see through her neck. They can see into the organs in her neck. And that is the end result of Colin Griffith's hatred and violence towards his mom. A gaping hole from that knife. And we saw that as she's getting stabbed, she doesn't stand a chance. She to the ground, her purse crashes to the ground, falling off of her shoulder. Her charging cords fall to the ground. She struggles to get up. You can see things she's grabbing onto.
And of course, I have to get up, and it crashes while I'm up. Well, I'm glad that Judy got her pet fix in before she has to leave for cruise.
And when you come back through those doors, you should come back with nothing short of pure 100% justice. And that's finding the defendant guilty as charged of both counts for what he did to his mom on September 8th, 2024.
Dang it.
Approach off the record briefly.
I am so fed up with this crap. Stupid stream. Okay, I'm going to share my screen again because once again it muted it. I don't know why it does that. Yeah, it is possible that he did do it. But the problem is, we don't know. Nobody knows. Because nobody was there. It could have been total self defense. She could have fallen on the knife, like he said. And how do they know he didn't call 911 as soon as it happened?
Ms. Thornhill?
Good morning, everyone. The state would like you to focus on the emotion and the drama rather than on the actual facts. You can't ignore the facts in this case. What's your job as jurors? It's to decide whether the state has proved beyond a reasonable doubt that Colin kidnapped and murdered his mother, and that her death was not excusable or justified. That's your job.
Why do I have a
They
big
start with the presumption of innocence, as the judge will remind you again when he reads the instructions. Unless and until the state can overcome that presumption with evidence beyond and to the exclusion of a reasonable doubt. Not words that they may say, characterizations of how things might have happened, but actual facts. We can offer facts are and what they mean, and whether the state has used those facts to prove beyond a reasonable doubt that Colin is guilty of anything. So the state offered a number of witnesses. You guys have been presented through all of the witnesses and all of the exhibits. You all took notes, and the exhibits will all be back there in the jury room with you. So you can look at any number of them. You can look at all the text messages that were admitted into evidence, even if they weren't all played on the screen. You can listen to things. You can watch the Ring video. That will be up to you. Those are facts. The witnesses. In a move that you might find surprising, I'm not going to argue to you that the state's witnesses were unreliable or that you shouldn't believe them, with one exception. Most of the witnesses were pretty straightforward in answering the questions. Like I said, it's up to you to decide how to interpret what they said. But the one exception, and it might not even matter in the long run to your inquiry, your decision, because for the most part, what the witnesses told you isn't in dispute. And that one exception is Robert Willantis.
Right.
I may have seemed harsh with him when I questioned him, and I apologize for that. I wouldn't wish the death of a child on anyone ever. But Mr. Willantis wanted you to believe that he was very close with Kathy and with Colin, and that he was close enough with Colin that Colin confided in him several months before Kathy died. So, how close was Robert Wolantis with Colin and Kathy? He was not invited to Kathy's celebration of life. He didn't even know that she hadn't been buried. If you recall him going on and on about how funerals are for those left behind. And that's not to say that, it's not to say anything bad about Mr. Wolantis, but it's something you can consider in evaluating the credibility of his testimony. He went on one trip with Kathy a few years ago that Susan paid for. He talked to Colin on the phone a total of 3 times, unless you believe there was this second mysterious phone that Mr. Wolantis claimed that he talked to Colin all the time on for either every week or every other week. There's no evidence of that. Susan told you about a phone that she got for Colin when Kathy had kicked him out one of the several times that she bought for him to use because he'd been kicked out without his phone. It was active for a couple of weeks. It's another thing you can consider in deciding whether you think Robert Wolantis was reliable. You also have to consider whether Robert Wolantis was trying to make himself seem more intimately connected with his daughter's life and his grandson's life. And now with Kathy's death. He was the one who called Polk County Sheriff's Office. He was not the go-to family member that the detectives wanted to speak to get information. They didn't seek him out. He reached out to them. And he reached out to them only weeks after Kathy died. Not right away, not, oh my goodness, my daughter died. I have this important information that may help in the investigation. No, it wasn't until after he watched Grady Judd's press conference that was extremely detailed in describing the wound that Kathy suffered and how she died that Mr. Wolantis called the sheriff's office.
And Grady took liberties, as always.
You can consider that in determining whether you think his testimony is reliable.
Sheriff Judd, but he does take liberties.
You can also consider the language he used in describing what Colin said to him, allegedly, about wanting to slit his mother's throat and watch the blood and life seep from her. You've heard Colin's words several times on the 911 call, on the Ring videos. That sound like something Colin would say, or a way he would describe anything that he says? Or does that sound like Mr. Wolantis putting words in Colin's mouth? Say, even if you've Mr. Wolantis, which I urge you not to believe what he said, he claimed Colin told, but even if you do, that does not prove beyond a reasonable doubt that Colin murdered his mother. And you have to remember that too. That's what the state has to prove to you. So dealing with that one witness, let's move on to the charges against Colin. The kidnapping. The state has to prove to you beyond a reasonable doubt that Colin, by force, threat, or secrecy, confined, abducted, or imprisoned.
Well, it won't let me show your comment, Judy, but You didn't crash it this time. It's not you, it's me. If I had just left it alone, it would have kept going fine. It didn't crash it, it just took the audio away again. I don't know why it keeps doing that. Ah. If I hadn't paused it to comment, it would have just kept going fine. And it frustrates me because I'll see people, like I'll have 6 people. I mean, I don't get a lot of live viewers. I get viewers later, on replay, but I'll have like 6 viewers and then it'll crash. And when I get back, I have like 3. And I'm like, my channel might grow if StreamYard didn't if StreamYard would cooperate with my internet. I might have a channel. But I noticed I have an extra subscription this morning, so I must be doing something right. I just can't wait till Thursday. That's just all.
And at the
Well, I can't
time,
wait.
he supposedly did any of those things. At that time, terrorize her. Okay. So what did the state present to? They presented the witnesses, the neighbors, Sally Bell and Nancy K. Jones. The photos of they lived. And you heard them say that Kathy was the one being aggressive right when she arrived. She whipped the car out of the driveway to pull it up against the curb or the grass. She slammed her car door. She slung her backpack over her back, and she marched up to the door and went inside. Went inside that house of her own accord. When she comes back out of the house, she's throwing things into Colin's car, and you can see in the photo of the interior of his car, there's clothes thrown in the back, and there's his computer and his phone on the front seat. And she's yelling and gesturing and stomping around, and then she goes back up to where Colin is standing in the doorway. Because remember, neither of those witnesses told you he was ever anywhere other than in the doorway. Not in the mulch where an AirPod was found, but in the doorway around the corner. So Kathy comes up to him. She's making a scene. Obviously a scene that's loud enough, noticeable enough that the neighbors are looking to see what's going on.
I unmuted. Really? I unmuted it. It said that I was muted, and I clicked the mute button, and it said I was unmuted. What I said was, because you said not sure this is important enough for closing. So what I said was that maybe not, but if that's something that the jury is going to get hung up on, it is good to mention it, because if there are jurors that say, but his grandfather says, then they're going to remember what she said, and then they can be like, yeah, but his attorney said, and then they're going to maybe realize why the grandfather's not credible. That's all I said, because it may not be important. But if she hits the other important things, and maybe because she said the less important thing first, they'll remember it. Like if she said the less important thing towards the end of her closing, then they might not remember it. I don't know. But I think that maybe not important, but I don't think it's a bad thing that she threw it in there. Makes sense? I don't know.
She's already drawn their notice. And as she's on the carport floor and Colin's standing in the doorway, and and she's still gesturing. He puts his hand, and the witnesses differ, on her neck area, on her shoulder, by her ponytail, and they said pulled her inside. Not dragged, not grabbed her by the ponytail. More like, and this is something you can decide, more like an ushering, like, oh crap, you're causing a scene, like you know Kathy can, seeing it in the state's own evidence. Let's bring this inside so that we don't get the wrath of the neighbors up or cause attention to be drawn even more to our argument.
That's what I just said.
That's a more reasonable interpretation of those facts. It's reasonable to interpret that Colin was embarrassed by his mom and didn't want to air their dirty laundry in the carport. Now, she did say, let go, you're hurting me. Okay, that's a fact. That she said that is not in dispute. But you can't just accept a statement by anyone, but let alone by Kathy at face value. Okay, so she claims, you're hurting me, let go. Does she pull away from him? Nope. Witnesses never said anything about that. Did she try and stay at the bottom of the steps where she was gesturing at him? No, the witnesses didn't say. They said that her feet actually moved up. That indicates a willingness to go inside. That's a reasonable interpretation of what those witnesses told you. Did she say, I don't want to go back inside? No. No. Did she grab onto Colin in some way to get him to let go of her? Wouldn't have either called 911. Kay Jones would have called Susan because remember, she was house sitting. Colin was allowed to be there, that he had arrived the day before, his car hadn't moved. If either of them thought that Kathy was actually being harmed or being forced to do something against her will, don't you think, as the good neighbors that they were, they would have alerted someone? They didn't, because Kathy's saying she was being hurt and let me go, and they don't know her. But I think you can interpret that statement from Kathy, knowing what you know about Kathy, as being just one of the many things that she claimed happened. That when she said Susan, or in a text to Colin, there are a lot, so I'm sorry if I don't remember exactly where it came from. She said, I'm scared, Colin, you battered me, or you hit me, or you beat me before you left on Saturday. Remember the ring videos in every room in the house except the bathroom. And for the most part, she and Colin are on ring video. The state has given you some ring video. The defense has given you some additional ring video to sort of fill it out a little bit better. On none of that ring video is Colin ever touching her. So isn't it reasonable that even though she claimed Colin hit her, beat her, struck her before he left the house on September 7th, and there's no proof of that, that her saying, hurt me, let go, And the reason I asked him about this is because I wanted it to be clear that it was permissible for Colin to be at Susan's house. It was permissible to his probation officer, who he emailed. It was permissible to the courts. You saw the pink paper that Kathy tried to make a big deal out of that said Colin may go to visit his grandmother out of county. Just notify the probation officer. 51, the capacity, there was nothing anywhere where anyone's except for Kathy's at Susan. Unless Kathy's pissed at her mom because Colin is at her house and hasn't come home as quickly as she did. She also wrote Susan in her text saying, HOA hates you. I'm ready, Susan's dog, to have a dog back, and that's a violation. Kathy's mad enough at Susan at this point that who knows, maybe she was trying to get Susan in trouble with her homeowners association by causing a bigger scene than it actually was. I'm not saying that that's for sure what happened. I'm giving you reasonable interpretations of Kathy's behavior. But the bottom line is that there's no evidence that Kathy did anything against her will that day. And certainly no evidence beyond a reasonable doubt that she went back into the house that she'd already been in on her own, despite Colin touching her neck, her hair, her ponytail. She was not being dragged. She was not being forced. Plus, once she's in the house, the state has one theory of what may have happened. I'm going to propose some other, I would argue, more reasonable ones. When she's inside the house, she has access to her phone, right? She has access to car keys. The doors are unlocked. You heard Susan say that the doors are kept unlocked. And then you heard Colin say on the 911 call when law enforcement first arrived and they're knocking on the door saying sheriff's office, he says, come in, the door's unlocked. There's no evidence that Kathy was kept in that house against her will. None. In fact, to the contrary, Colin would have been probably really happy if Kathy had left. No one wanted her to have come there. And knowing what you know about Kathy, don't you think it's reasonable that if she had been forced to go back inside against her will, that she wouldn't have fought tooth and nail to avoid doing what she didn't want to do? Remember, this is somebody that the state's own witness, Detective Zanoniani, said it's either her way or the highway. So, knowing what you know about Kathy, if she was being forced to do something against her will, it's reasonable she would have fought it, right? The state himself said it doesn't look like there was a long drawn out fight throughout the house. If Kathy didn't want to be back in that house, how did her flip-flops make it all the way to the kitchen? If Kathy didn't want to be back in that house, she would have been flailing like she had been doing just talking to Colin before. And if she had been forced to go back into that house and then forced to go to the kitchen and forced not to leave, the house wouldn't have been in as pristine a condition as you saw. The plant would have been knocked over. Something would have been amiss. Didn't have any evidence from the medical examiner either to say she had any scalp wounds or anything indicating that she had been pulled by the hair. Not to mention the fact that, is it reasonable to you that Colin, despite what the prosecutor says, even though there's no evidence of how tall he is, how much he weighs, you've seen him in court, you've seen a picture of him shirtless. If you believe that Colin could have made his mother do anything physically, I don't know what else to tell you. I'm not going to be able to convince you of anything. And if you think that Colin was dragging her by the hair, as the state seems to want you to believe, throughout that house, how come her flip-flops didn't come off right at the front door? Colin didn't make Kathy do anything. Oh, but the AirPods, the one in the mulch, that proves that Colin made Kathy do something against her will. BS. No witness ever saw Colin in the mulch. They never saw him anywhere other than the doorway. But they saw Kathy march her way up from her car to the doorway. Isn't it reasonable that as she's pissed off at Colin, comes in hot and angry, that it fell out while she was just being herself? Same with the ones in the house. Once again, if Colin was ever forcing her to do anything physically against her will, and that AirPod came out because of something he did, you think she would have just been like, okay, I'm going to let you keep dragging me, instead of flailing about and, like I said, knocking something amiss in the house? No, that's not reasonable, because none of that ever happened. There was no kidnapping, period. The felony murder count, which is also first-degree murder. If you were to find Colin guilty of that, that would mean you have to find beyond a reasonable doubt that he kidnapped Kathy and that during that kidnapping, he caused her death. So I've already told you all the reasons why I think the state has utterly failed to prove a kidnapping. But even if you did find that, because I don't want to presume that you're going to find anything. I'm here to make suggestions, not to tell you how to do your job, like the prosecutor was trying to do. That hour and 15 minutes between when the neighbor saw Colin usher his mother inside as she's making a scene and when he called 911 distraught, you would have to believe that Colin forced Kathy to stay in that house that entire hour and 15 minutes and was inflicting some bodily harm or terrorizing her that whole time. That's not reasonable. There was no kidnapping, and this was no felony murder. This was self-defense. So the state wants you to believe that this was a premeditated murder. In order to do that, once again, they have to prove beyond a reasonable doubt that Colin intended to kill her, and beyond a reasonable doubt that he was not acting in self-defense. That's what you would have to find. You heard a lot of outrage from the prosecutor in his closing statement. And this is an awful situation. But there was no outrage about how Kathy had behaved, how Kathy had treated her son, how she had treated other people. And I'm not saying you have to have outrage at that. You've heard a lot of unfavorable things about Kathy. And I am not going to go through every single one because you took notes, you heard and saw, you heard from the state's own witnesses, those things. Susan confirmed them. But remember, the incidents that you heard about Kathy being violent in the past or making things up in the past were all corroborated, either by police reports, DCF reports that Detective Zanoniani had reviewed, or by witnesses, by Susan. I was not presenting those to you to just bash Kathy, to make her look like a horrible person. To the contrary, I was doing my job because the law says, and the judge will tell you, that you have to consider prior acts of violence, prior acts of aggression, a reputation for dangerous and violent behavior in deciding whether Colin was reasonable in defending himself against his mom on September 8th. I'm not going to read the instruction in detail because, like I said, the judge will do that for you. But the law requires you to consider what Colin knew about his mom to decide whether you think he acted reasonably in defending himself. You have to decide the reasonableness of Colin's actions in light of all of those things. In light of the fact that she had pulled a gun on him before, in light of the fact that she had threatened to kill other people before, in light of the fact that she had attacked other people before with weapons. Some of these things in front of Colin. So it's not even just hearing about it, it's witnessing it. He knew all those things about her. He knew what she was capable of when she was angry. He knew all of this, and it was in his mind when she came to him on September 8th. Colin also knew that Kathy would sometimes make things up to hurt other people, such as he knew that she claimed someone strangled her. She even claimed that she had video of it, but when the police reviewed it, it showed you she was strangling herself. He knew that she had called DCF on her own brother, got them involved in an investigation that was baseless. He knew that his mom claimed to do everybody else's schoolwork, including her own mother's dissertation for her PhD. He knew this about his mother. And luckily, those threats and made-up stories that Kathy had told in the past didn't ever result in any serious consequences for those people. But Kathy had never suffered the consequences of making those stories up either. And what happens when you don't suffer consequences? You continue the behavior. And sometimes she was actually even believed when she made things up. One glaring example. The day that she pulled the gun on Colin, threatened to shoot him or herself, and then handed him the gun and said, "Just shoot me," Colin immediately tells his teacher or professor, who talks to the school resource officer, who gets the deputies involved. The deputies go to Kathy at her house, and Kathy says, "No, I never pulled a gun." "What? He's just being a brat. He was failing classes, so I disciplined him by taking away his phone and his AirPods." And they believed her. Okay. Now, at the time, maybe that wasn't so astonishing. But remember what Susan told you. Susan told you that Kathy admitted to her that she had actually pulled a gun on Colin. So Kathy lied to the police. She also lied about him failing his classes. That was never true. And convinced them that Colin was just being a brat. Despite the fact that Colin had given a detailed account of what his mother did to him with her gun, they didn't believe him. They believed that he was just being a brat. I am not trying to make him look like an angel and Kathy look like the devil. You heard him on the ring.
Well, now I crashed it. 3 words. I typed 3 words. Also,
Video and how he talked to his mom. Disrespectful. Absolutely. But that doesn't make him a murderer. Also, look at his role model. That kids kind of do what they know. Their parents are their role models. Their parents teach them by not only talking to them, but by their own behavior. They cussed back and forth at each other. Is it an ideal parental-child relationship? No, but that's how they existed. You heard Kathy cussing at a number of people, including her mom, and cussing and claiming Colin had put a lid on her cup too tight and that it caused her to cut her hand. Did you see a cut on that video? Did you see her trying to stop any bleeding? No. Another example of her making things up. So even though Colin could be a brat and disrespectful to his mom, but what 17-year-old isn't at times, you cannot ignore the fact that Kathy told her mom, yeah, I lied to the police. I actually did pull a gun. You cannot ignore that fact. And it was in response to his mother pulling a gun on him that making these statements that the state has conveniently termed threats, but without wanting you to consider all of the words in those statements. And that was the same incident where Kathy lied to the police about not pulling a gun on Colin. Remember, he ends up Baker acted because he begins people in authority ignored Kathy's well-documented history of violence towards others. They ignored her well-documented history of aggression and volatility and impulsivity. They ignored the fact that she owned a gun. They ignored the things she had done to her ex-husband. They ignored that she had stabbed him. Reports and DCF reports. They just ignored it. And these are just the documented episodes that we know about of Kathy being violent towards others. You saw how she acted on her own Ring video, right? And this is her knowing she's being recorded. So if that's how she behaves when she knows she's being recorded, think about what she might do when she's not being recorded. Colin with a belt in front of her own mother. And when Susan tried to intervene, she tried to claim that law enforcement had sanctioned. Just told her, you heard from
I love it when you bring out the musical references. Oh, this is aggravating me, guys. And I don't know how much we missed, or you missed, I guess. Spike, honey, I put you in the bed. Why'd you get down? I know, Spike, your life is just so hard.
the day before Kathy died. You've seen the Ring video. You saw that she and Colin had an argument about putting up the bookshelf. You saw that her reaction to that was to kick him out, which she lied about later too. She claims on the phone with her mom on the Ring video, I never kicked him out. I never kicked him out. I never kicked him out. Watch the Ring video again. Listen to her words. Get out and don't come back, even if you're bawling your eyes out. Beyond that, give me your house keys. She He took his keys to get back into the house that he lived in. You can't see it in the States Ring video that they played, but I admitted a defense exhibit that we only played a short clip from, but it's longer. You can watch it if you don't trust me or don't believe me. But in that clip that the state has argued that the text that Kathy sent Colin, threatening all sorts of things, because she threatened all sorts of things that were not true, right? Won't go through all of them. But that this text confessing to planning a murder in Oklahoma, that provides a motive for Colin to want to kill his mom. Okay. First of all, you have to believe that the threat was true. Given what you know about Kathy, given the fact that no one's seen any ring videos of any such nature, and given the fact that Colin has never been charged with anything in Oklahoma, and given the fact that her deadline of 3 p.m. when she was going to supposedly send these to all these people had long passed before she got to Colin, isn't it reasonable to think this is just another thing that she made up? Because if those things existed, they'd be out there. They would have been in front of you. And don't you think Colin knew that that was an empty threat? Knew that no such recordings existed? So this big motive that the state wants you to believe in, also BS. It's just another one of her delusional lies. Something else she made up, like she made up things all the time, and that the state's own evidence proves to you. Then you have to think, even if you believe that the threat was true or real beyond a reasonable doubt, you have to believe that Colin somehow made her come to him so that he could kill her. And that's just absurd. Kathy made the choice to go to where he was. And let's face it, Colin had been trying to escape his mother for quite some time. for at least a year that we know of, since September of 2023, when he got put in the Baker Act facility for something his mom did and lied about, when he said, "I don't feel safe." And that's what he was trying to do on September 8th when she kicked him out. I mean, on September 7th when she kicked him out. He was trying to escape her. Think about this. All the times that you've heard about Colin saying, "I don't feel safe. If my mom attacks me, I'll defend myself. If she comes at me, if she pulls a gun on me, if she punches me, I'll defend myself." Remember, Colin told people that he would rather be in the Baker Act facility than at home with his mother. He told people in authority he would rather be in jail than at home with his mother. He told people in authority he would rather be in foster care than at home with his mother. And the state wants you to believe that Colin's just a brat who didn't like the discipline he got, so he murdered his mom. That's also absurd. Because, as the state has pointed out many times, Colin had what they think is a great life with mom, right? So he gets to go on trips, absolutely got to go on trips. He lives in a clean, nice, organized home with plenty of food. Yes. He has a phone, he has an Xbox, he has a computer, he gets to go to college. Don't you think Colin, as smart as he was to be able to graduate early, would know that if he actually were to be placed in the Baker Act facility instead of going home with his mom where he didn't feel safe, or remain in jail instead of going home with his mom with whom he didn't feel safe, or went into foster care instead of going home with his mom with whom he didn't feel safe, he would get none of those wonderful things. None of them. He would not have a phone. He would not have an Xbox. He would not go on trips all over the country or the world. And yet he still said, "Please re-Baker Act me. Please don't send me home from jail with my mom. Please, I'd rather go to foster care." These are the things you know and that the state has proved. Colin was trying to escape his mom because he was scared. He was scared of what she would do to him, and if she attacked him, what he would do in response. So, knowing all that, let's talk about September 8th. Kathy went to where Colin was. Isn't it reasonable to believe, because let's be clear, the state has offered no proof, zero proof of what actually happened in Susan's house on September 8th? None. Zero proof does not equal proof beyond a reasonable doubt. But isn't it reasonable to believe that Kathy, in her anger, her desperation to make Colin come home, that she picked up a knife and threatened him with it, which is in total conformance with how she's acted in the past? Absolutely, it's reasonable. The state wants you to think, despite any proof, that Colin dragged his mother to the kitchen, somehow kept her there against her will, either by beating her or holding her by the ponytail, and then somehow managed to get a knife out of the butcher block while still holding on to Kathy, such that she couldn't get away, to start this fight over the knife.
Okay, she said butcher block too. What's that about? Because the grandma testified it was in a drawer. What was that about, Judy? What did she say? I just now noticed that. And I don't know when you Yeah, because you're always on delay for some reason, which I hate just as much as you hate. But I don't know what she said whenever you typed that. And this comment, yes, I am in favor of time limits as well. But in this case, I am so afraid that this kid is going to get convicted. And I know I said that my problem with this case was the fact that he killed his dad. But as I sit here right now thinking about this, the jury does not know that he killed his dad. They're not allowed to know that he killed his dad. They're only allowed to know that he did kill someone and he was not charged with anything. And we don't know what happened. We have two different stories, and there's no way to know which one is true, and that is reasonable doubt because it could be self defense or it could be what the prosecution says it is, and I don't believe that. Oh, the dad situation, the killing? What dad situation? How did I miss that? Probably because I was focused on my baby boy, who is now laying under the table. He just wanted attention. He didn't want back in the bed. That's probably why I missed it. But that I need to get a hold of that document that Ada K was reading on her channel. It was the divorce papers. And the divorce papers said that she had threatened to call his school in Oklahoma to tell lies on him to get him taken away from his dad. I wouldn't put anything past this woman, though. I really wouldn't. Like I said, my mom was bad. One time, my mom was not near as bad as this lady. Not near as bad. But at one time, um, I was going to go with a church group. I don't know if Disney World still does this or not, but they used to have, it was called Night of Joy, and they had it in September every year, and they had Christian concerts. It was kind of like grad night, if you remember grad night. I don't even know if they still have grad night there. Um, where it was you got in at a later time. They made everybody else get out of the park. So it was a special event and you wore like an armband and they had concerts all over the park of Christian artists, and then the rides were open so you could ride the rides too, and the lines were much shorter because it was a special event. Um and I went every year, but this was probably my first time going, and I was a teenager, and my mom did not want me to go. My mom used to, she had dreams, and she swore that some of her dreams came true. They didn't, but things would happen, and she would make her dreams like fit whatever happened to say, oh, this is the ending of my dream. She would always say, this is the ending of my dream. So I was going to go on this Disney trip with the church group, the youth group at church. And my mom had a dream that one of the boats on one of the rides came off the track thingy and a bunch of people got hurt. And I think that was just her anxiety of letting me go caused her to have that dream. So then she decided that she didn't want me to go. And she was in the kitchen cutting onions, and it made her cry. So then she came to me. I was in the living room. I don't know what I was doing, watch TV, I guess. And she came in there and she's crying. And she's like, Debbie, please, please don't go to Disney World. I don't want you to go to Disney World. I'll worry about you and you'll get hurt. And I was like, okay, Mom, I'm sorry. I won't go. If you're really going to worry about me that much, I won't go. I'll stay home. And I went to give her a hug and I smelled the onions. I went, Mom, you're cutting onions. Stop. And then she laughed. And I was like, no, I'm going. Just for that, I'm going. So I lived under a mom like that, but nowhere near as this bad. Nowhere near this bad. So I feel for this kid. I know what it's like. I know a fraction of what it's like, and that was bad enough. Okay, I'm sorry. I know. I keep telling you guys personal stories about my mom because of this trial, but I've lived it. Not this bad, but I hurt for this kid. I like so hurt for this kid. And if he gets convicted and goes to prison with his impulse control problems, he's gonna end up killing somebody in prison. And his life is ruined if he goes to prison. He's done. Oh, another question I have, because I forgot to look at his legal documents. Judy, you might know the answer to this. Um, did they take the death penalty off the table? I hope they did. Um, I've not heard anybody say anything about the death penalty. And so if he gets convicted, then they'll have the penalty phase if they didn't take it off the table. But I haven't heard any mention of it at all. But that doesn't necessarily mean anything. So if any of you guys know, please, because that's what I'm worried about now. I mean, I'm still worried that they might convict him, but now I'm worried if they convict him that he's going to get the death penalty.
That's absurd. And it certainly hasn't been proved beyond a reasonable doubt. That's while still holding, and then somehow managed to get a knife out of the butcher block while still holding such that she couldn't get away to start this fight over the knife. That's absurd. And it certainly hasn't been proved beyond a reasonable doubt. Isn't it more reasonable, given everything you know, that Kathy picked up the knife, threatened Colin with it, and he defended himself, as he's been saying he would do for a year? Isn't it also reasonable that Kathy knew what the outcome was going to be when she picked up a knife and threatened Colin with it? You've heard of suicide. Isn't it reasonable to think that Kathy committed suicide by son?
Oh,
she had never been able to successfully commit suicide before, despite her many attempts. Isn't it reasonable that she pulled a knife on Colin, knowing that if she attacked him, that he would defend himself, and that the end result might be that she died? I'm not saying that that's what was in her mind, because we don't know what was in her mind.
There's a reasonable doubt, right?
I'm saying that it's a reasonable possibility given everything you know about her. It's also a reasonable possibility, a reasonable interpretation, that she attacked Colin with the knife. He has wounds. Dr. Garavan talked to you a little bit about mutual combat and how a struggle over a weapon can result in both people with wounds, which is what you see here. Exactly what you see here. You also, most of you in jury selection mentioned that self-defense is a right that each of us has. And those of you who own guns said that they keep them nearby, often for protection. And I said, protection from what? You said, if someone comes into my house and attacks me, I can protect myself and my family. So isn't it reasonable that that's what Colin did here? When Kathy came into the house where he was living for all intents and purposes at that point, and that she attacked him with a knife, that he defended himself, as was his right. The state has proved at no level, let alone beyond a reasonable doubt, that Colin picked up the knife and attacked Kathy with it. That means you have to try and figure out, if there's no evidence of exactly what happened, you have to think about what was reasonable. And it makes way more sense, given what you know, that Kathy attacked Colin and he defended himself. They've tried to get you to believe that Colin was rage-filled and hate-filled, and all of these malicious thoughts were geared towards his mom. If you believe that beyond a reasonable doubt, don't you think there'd be more than just one wound on Kathy? Sorry, she had two wounds. She had the neck wound and she had the hand wound. Those could have happened at the same time. You don't know whose hands were on what part of the knife during this struggle. If Colin was so rage-filled and had such hatred for his mom, don't you expect that there would be 5, 10, 20 stab wounds? That's something you can consider too.
That's a good point. Jason Chin stabbed his girlfriend 60 times.
So the state played parts of the 911 call again for you, and they want you to believe that that proves beyond a reasonable doubt that Colin murdered his mother and wasn't just defending himself. You can believe or disbelieve what Colin said. If you don't believe what Colin said, that still doesn't mean that the state has proved beyond a reasonable doubt that he murdered his mother. Remember that. Also consider that Colin said there was a long fight and she fell on the knife. Knowing his history, don't you think he of not being believed by people in authority repeatedly, that yeah, he may have not told the entire truth because he was scared. That doesn't make him a murderer. Especially because when he went to the people who were supposed to protect him, law enforcement, doctors, DCF, and said, my mom attacked me with a gun. My mom pulled a gun on me. I don't feel safe. I'm afraid. I'll defend myself. Don't you think he, and then believing her when she says absolutely never happened, he's just being a brat. Don't you think he might be a little scared when he's talking to a 911 operator? Not to mention the possible shock because of what he had been through in a struggle over a knife with his own mom. And let's not forget the one wound to Kathy's neck. State state wants you to believe that it was some vicious, forceful, rage-filled wound. But remember what Dr. Garavan said? He said that it actually doesn't take much force to go through the soft tissue in the neck. The biggest point of resistance is the skin itself. And that resistance is even less if the knife has a pointy triangular tip, which is what we have here. So, knowing that it wouldn't take much force to inflict that wound, knowing that Kathy has been violent in the past, knowing that she has threatened people in the past, knowing that she has attacked other people, isn't it reasonable that she pulled the knife on Colin, he defended himself, and there was a long fight over the knife? The messiness of that confined space between the island and the cabinet and the stove supports that there was a struggle over a knife. And don't you think it's reasonable that during a struggle over a knife in that confined area, and who knows what positions anybody was in, state sure can't prove any, that gravity may have played a part in that little bit of force that was necessary to cause that wound? As I said, these are interpretations based on what you do know. But don't forget, I don't have to prove exactly what happened. It's the state's responsibility to prove to you beyond a reasonable doubt that Colin did not act in self-defense. So let's talk about what the state may have proved beyond a reasonable doubt. One, by way of stipulation from us, that there was no foreign DNA under Kathy's fingernails. Okay, that's something you have to accept as true. What weight to give it is up to you. But so what does that mean? That means she never scratched Colin with her fingernails. That's it. Or at least not on the fingernails that they took the swabs from. So why is that important, or why should you consider that? Well, you would expect she would have scratched him with her fingernails if she was actually being dragged into the house or across the living room into the kitchen and being held against her will. No DNA, no scratches. That means no struggle with just her fingernails. So that piece of evidence does not establish anything beyond a reasonable doubt as far as whether Colin is guilty. You know why else she wouldn't have to scratch him at all? Is if she had control of the knife. Because she doesn't need to scratch him and defend herself with her fingernails because she had the knife first. That actually supports that she pulled the knife on Colin first. They've also proved beyond a reasonable doubt that Kathy had bruises all over her body. Okay. Keep in mind that the lighting in the morgue, when pictures are being taken for evidentiary purposes, are a lot different than pictures you take with your cell phone. There has been zero proof of how Kathy got those bruises. Dr. Garavan can't date them. He said they could have come from innocuous activities like doing chores around the house, like you saw Kathy doing on the night of the 7th. Certainly no evidence to show that Colin somehow inflicted those. So even though they've proved that there are bruises, they have not proved how those bruises occurred. So essentially meaningless. Or another possibility, reasonable interpretation, is that she got bruises while they were struggling over the knife. The state has also proved beyond a reasonable doubt that Colin had blood on him. So what? He had wounds. He performed life-saving CPR on his mother at the instruction of the 911 operator. He held towels in his own shirt to her to try and stop the bleeding. You saw the bloody towels. It also supports that there was a struggle over the knife. It does not support that Colin murdered his mother. The blood on his eyeglasses frame, I hope that was clear when I was asking the crime scene tech that if somebody's holding towels and doing CPR and in this confined space, that they might adjust their glasses and get blood on it that way. But what about the blood on the backpack? Does that prove Colin's a murderer? Absolutely not. Remember I asked the question about the Colin's phone being in the car and that Kathy's phone could have been in her backpack and that was Kathy's phone that was used to call 911. So blood being on the backpack doesn't prove Colin's a murderer either. It may prove that Colin, after he tried to stem the bleeding before he called 911, had to go look for the phone to call 911. Or that in their struggle over the knife, before he called 911 in that confined space, that's how the blood got on him. The other thing that the state has proved beyond a reasonable doubt is that Colin has said over and over and over and over and over and over, I don't feel safe with my mom. I'm afraid she'll attack me. I'm afraid she'll hurt me and I'll have to defend myself. They've tried to skew the statements to make it sound like he just walks around going, I'm going to kill my mother, not if she does something to me first. So I want you to think about this. If Colin really wanted to kill his mother and that he wasn't acting in self-defense, why on earth would he have telegraphed this to every person in authority at any chance he got?
Yeah, good point. This kid asked.
He told people in authority
and did
that if she attacked him, he would defend himself because he was scared. He was scared of what she would do, much like Susan said she was scared of what Kathy would do. You can also consider that if he, for months, if not longer, wanted to just kill his mom, and this is a little sick, he could have done it that would not have implicated himself, especially after he has told people in authority, if she attacks me, I'm going to defend myself and I might kill her. One of the many cruises they went on could have pushed her off the cruise ship, could have slipped some of her medication, legal or otherwise, into one of her many drinks, could have shot her. If he was as forcefully strong over Kathy as the state wants you to believe he was, he could have forced her into the bathroom in their own home where there were no ring cameras and slit her wrists in the bathtub. And in any of those scenarios, he wouldn't have had to rely on her coming to him, her driving. He didn't want to kill her. You heard him on the body-worn camera footage. I don't want to kill her, but if she attacks me, I will defend myself. The state has proved nothing of significance beyond a reasonable doubt to you, except that Colin and his mom had a very disturbed relationship. And also perhaps that they never should have been living together. You heard about other family members who were periodically estranged from Kathy. These are all adults with their own lives.
My husband's ex does that.
Colin, who also clearly wanted to separate himself from his mother, was still a kid without the agency or the autonomy to really sever any connection with her. Right? He's telling people, I don't feel safe. I don't want to go back with my mom. And yet they kept making him do that. It's kind of like someone saying, say, a zoo worker or a circus worker that's responsible for taking care of a lion in a cage. Don't make me go back in that cage with that lion. It's bared its fangs at me. It's reared up at me. But luckily, every time I was able to get out before it attacked me and caused me harm. And the zookeepers and the circus people kept saying, he'll be fine. He'll be fine. Go back in the cage. Go back in the cage. And closing the door behind him. Doesn't mean that the lion is in attack mode all the time. The lion could be majestic and charming to audiences and cute even sometimes. Could seem calm, like you'd want to pet it. But it was, after all, a violent being. And just because the poor zoo or circus worker was forced to go back into that cage time and time again, when the lion finally managed to attack him and he couldn't get out, you can't blame the person who was forced into that cage over and over and over for defending himself. Each one of the authority figures that Colin begged to take him away from his mother ignored him, failed to protect him. They had the power to make the if part of Colin's statements that he might harm his mom not come true. And they didn't. So, been through a lot. Gonna give you one final thought. Remember again that Colin is presumed innocent. Okay? Unless until Dave can prove beyond a real doubt with evidence and that he kidnapped and murdered his mother. So that's like saying you have to start with seeing the vase in black. That's the presumption of innocence. In order for the state to overcome that presumption of innocence, they have to provide you with facts such that you can only see the faces, such that you don't see the vase anymore. If you can see both the faces and the vase, that's reasonable doubt. The state has in no way come close to proving to you beyond a reasonable doubt that only the faces exist. They have failed to prove beyond a reasonable doubt that Colin did anything other than defend himself against his mother, and that what he was afraid would happen actually happened. Your verdict has to be not guilty. Thank you.
Thank you, Ms. Wagner. We're going to take one more 10-minute recess. I think you need to finish making your lunch selections because we'll hear from the state in rebuttal, and then I'll go directly into the instructions. So we'll take 10 minutes.
All right, please.
they haven't done jury instructions yet. I was gonna say, I've got the hiccups, y'all. I was gonna say that I accidentally skipped them because they usually read
It will
jury
be in a 10-minute
instructions
recess.
before closing, right? Oh, Joy, rebuttal. Oh. Wait. We're taking a break. Okay. Maybe I can get rid of my hiccups. Well, no, the break is when I don't need to have hiccups because that's when I have to talk to y'all. So, ugh. So Judy and I were just talking about this case, and we're both kind of on the fence. We would both probably end up making this a hung jury. But the literal definition of reasonable doubt is what we have. So I guess technically we would have to what's the lesser included? What's the lesser included? Well, I guess we're fixing to find out when they read the jury instructions. I should have been paying better attention during the charging conference. With the charging conference, though, a lot of that was just the standard jury instructions, so we didn't actually hear what they were. Guys, I need to make my watermark bigger. It's a teeny tiny dot down there. You can hardly see it. I don't know how to do that kind of stuff. Stupid hiccups. Because three things. Why am I? We can fast forward. I started. Could have done it, and we don't know which it is. So that's reasonable doubt, right? Doubt. Judy, you and your marshmallows. I love it. Is that a Judy thing or a northern thing? In the South, we say good gravy. Oh, good gravy. Or in my family, we say good gravy, Marie. I don't know if that's a family thing or a Southern thing. Marie is a family name. I have a great Aunt Marie that I've never met. My mom's middle name is Marie, and my cousin's middle name is Marie, and I think I have some other cousins with middle names that are Marie because Marie's a family name. And we say good gravy Marie, and I don't know if Marie is because of the Maries in our family or if that's part of the state.
Thank you, Judge. Ladies and gentlemen, you're about 6 minutes away from hearing the jury instructions. It's going to be a lot shorter than the first time around. And we're going to finish up with the rest of the PowerPoint. Those two photos there as you heard Dr. Garavan say, are consistent with defensive wounds. Open, gaping, fresh defensive wounds. Kathy doing what she could with her bare hand
Wounds.
to try to prevent that knife from going through her neck. Remember, the defendant, his hands were pristine. No cuts, no bruises, no stab wounds, nothing. Because Kathy never had that knife. So how did this happy, smiling young lady turn into those last photographs you saw?
A couple quick yes or no questions I almost forgot before we go. And do you think he's capable of killing you?
Yes.
She was quite aware that he was capable of killing her.
Okay. All right, well, thank you for your time.
Now, how did the defendant act when his mom did something as simple as take away his Xbox and his phone to try to instill some discipline action?
You stood up and said, okay, let's do it. Let's do it. Yes, you did. I was there.
I was saying, no, I'm not a psychopath. I'm not just a murderer.
Why does she think he's a psychopath and a murderer? Sometimes when you protest too much, you're scared of the reality.
I'll say it to you like this, if you want to know. Colin 1 is, I guess, he's who just wants to survive, help people, and do good things in the world. And Colin 2 is the one that protects Colin 1 in situations where he can't escape from. And Colin 2 is the one that killed someone. Because what's it going to come down to next time?
I don't think you're a pussy. I think that you are capable of killing your mother, but I don't think that you will.
No, why would I?
Colin, I will let you get to that. Do you think Colin will let you get to that? I can't hear you, sir. Why, Colin? You're strong and individual. Why would you submit in a roundabout way to Colin? When we talk about,
It's the strongest version of me.
Ladies and gentlemen, the defendant knows the strongest version of him is the one that kills and murders.
So how is the situation with you and mom right now? Things calm down?
No,
you guys
no,
able
no,
to
sir.
get along? Where are we at?
No, sir, it's not good. She thinks that I guess out of her, I don't. She thinks that I'm like psychotic, like literally psychopath, sociopath, something like that. I don't know exactly where she's at. She thinks I'm gonna kill her.
She's 100% on the money.
Okay, what about you doing something?
And state of fight or flight, and I don't. He's gonna do something.
Oh, he acted all right. This is what the defendant said to his own grandpa, Robert Walland, whose daughter was brutalized by the defendant. My grandson was very aggravated at his grandmother and his mother. He said, I am so tired of these two bitches. I'm disgusted. He said, my mom, I keep thinking over and over, I want to slit her throat. I want her to bleed out. I want to smell the blood. I want to feel the blood. I want to feel the life in the blood leaving her body. That's exactly what he did. And that's just not Robert Walland saying. Look back at the text message that Kathy sent to her son, my dad is sending me his recordings of you telling him how you planned my murder back in February. So that just corroborates what you should already know, that Robert told his daughter was coming her way. And what was coming her way was exactly what the defendant said he wanted to do with her. And that, ladies and gentlemen, is exactly what he wanted to do as he left his mom with that gaping hole, just as he said he would. So the talk is done. Now it's time for action. When you go back in that jury room and deliberate, come back, dispense justice in the up way.
No, we don't have any of those recordings. Not that I heard. Just his testimony.
All right, members of the jury, thank you for your attention during the trial. Please pay attention to the instructions you're about to receive. Now, if you've been taking notes, you're welcome to continue doing so. But before you make that decision, be advised you will receive a written version of these instructions. Colin Griffith, the defendant in this case, has been accused of the crimes of first-degree murder and kidnapping. Murder in the first degree includes the lesser crimes of murder in the second degree and manslaughter, all of which are unlawful. However, a killing that was excusable or that was committed by the justifiable use of deadly force is lawful. If you find that Catherine Griffith was killed by Colin Griffith, you will then consider the circumstances surrounding the killing in deciding if the killing was first-degree murder or was second-degree murder or manslaughter, or whether the killing was excusable or resulted from the justifiable use of deadly force. The killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time of the killing. The killing of a human being is excusable and therefore lawful under any one of the following three circumstances. 1, when the killing is committed by accident and misfortune in doing any lawful act by lawful means with usual ordinary caution and without any unlawful intent. Or 2, when the killing occurs by accident and misfortune in the heat of passion upon any sudden and sufficient provocation. Or 3, when the killing is committed by accident and misfortune resulting from a sudden combat, if a dangerous weapon is not used and the killing is not done in a cruel and unusual manner. A dangerous weapon is any object that will likely cause death or great bodily harm if used in the ordinary and usual manner contemplated by its design and construction. Great bodily harm means great, as distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. I will now instruct you on the circumstances that must be proved before Colin Griffith may be found guilty of first-degree murder or any lesser included crime. Now, there are two ways a person may commit first-degree murder. One is known as first-degree premeditated murder, and the other is known as first-degree felony murder. To prove the crime of first-degree premeditated murder, the state must prove the following three elements beyond a reasonable doubt. First, that Catherine Griffith is dead. Second, that the death was caused by the criminal act of Colin Griffith. And third, that there was a premeditated killing of Catherine Griffith. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. Killing with premeditation is killing after consciously deciding to do so. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. However, the period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. The question of premeditation is a question of fact to be determined by you from the evidence. It will be sufficient proof of premeditation if the circumstances of the killing and the conduct of the accused convince you beyond a reasonable doubt of the existence of premeditation at the time of the killing. To prove the crime of first-degree felony murder, the state must prove the following three elements beyond a reasonable doubt. First, that Catherine Griffith is dead. Second, that while engaged in the commission of kidnapping, Colin Griffith caused the death of Catherine Griffith. And third, that Colin Griffith was the person who actually killed Catherine Griffith. In order to convict the defendant of first-degree felony murder, it is not necessary for the state to prove that Colin Griffith had a premeditated design or intent to kill. To prove the crime of kidnapping, the state must prove the following three elements beyond a reasonable doubt. First, that Colin Griffith forcibly, secretly, or by threat confined, abducted, or imprisoned Catherine Griffith against her will. Second, that Colin Griffith had no lawful authority to do so. And third, that Colin Griffith acted with intent to inflict bodily harm upon or to terrorize Catherine Griffith, or commit or facilitate the commission of any murder. In order to be kidnapping, the confinement, abduction, or imprisonment, A, must not be slight, inconsequential, or merely incidental to the murder. B, must not be of the kind inherent in the nature of the murder. And C, must have some significance independent of the murder, in that it makes the murder substantially easier of commission or substantially lessens the risk of detection. Secretly means the defendant intended to isolate or insulate Catherine Griffith from meaningful contact or meaningful communication with the public. Now, in considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crimes of which he's been accused, there may be evidence of other acts that would constitute a lesser included crime or crimes. Therefore, if you decide that the main accusation has not been proven beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crime. The lesser crimes indicated in the definition of first-degree murder, as I've said, are second-degree murder and manslaughter. The lesser crime indicated in the definition of kidnapping is false imprisonment. To prove the crime of second-degree murder, the state must prove the following three elements beyond a reasonable doubt. First, that Catherine Griffith is dead. Second, that the death was caused by the criminal act of Colin Griffith. And third, that there was an unlawful killing of Catherine Griffith by an act imminently dangerous to another and demonstrating a depraved mind with without regard for human life. Again, an act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is imminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that, one, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and two, is done from ill will, hatred, spite, or an evil intent, and three, is of such a nature that the act itself indicates an indifference to human life. In order to convict of second-degree murder, it is not necessary for the state to prove Colin Griffith had an intent to cause death. To prove the crime of manslaughter as a lesser included crime in count 1, the state must prove the following two elements beyond a reasonable doubt. First, that Catherine Griffith is dead. And second, that Colin Griffith intentionally committed an act or acts that caused the death of Catherine Griffith. Now, every person has a duty to act reasonably toward others. If there is a violation of that duty without any conscious intention to harm, that violation is called negligence. Colin Griffith cannot be guilty of manslaughter by committing a merely negligent act, or if the killing was either justifiable or excusable homicide, as I have previously instructed you. In order to convict of manslaughter by act, it is not necessary for the state to prove that Colin Griffith had an intent to cause death, only an intent to commit an act that was not merely negligent, justified, or excusable, and which caused death. To prove the crime of false imprisonment as a lesser included offense in count 2, the state must prove the following two elements beyond a reasonable doubt. First, that Colin Griffith forcibly, secretly, or by threat confined, abducted, imprisoned, or restrained Catherine Griffith against her will. And second, that Colin Griffith had no lawful authority to do so. Again, secretly means Colin Griffith intended to isolate or insulate Catherine Griffith from meaningful contact or meaningful communication with the public. It is a defense to the crime of first-degree murder and all of the lesser included crimes of first-degree murder if the actions of Colin Griffith constituted the justifiable use of deadly force. Deadly force means force likely to cause death or great bodily harm. Again, great bodily harm means great, as distinguished from slight, trivial, minor, or moderate harm. Colin Griffith does not have the burden of proving that he was justified in using deadly force. Instead, for you to find the defendant guilty, the state must prove beyond a reasonable doubt the defendant was not justified in using deadly force. The law on justifiable use of deadly force is as follows. Colin Griffith was justified in using deadly force if he reasonably believed that such force was necessary to prevent imminent death or great bodily harm to himself. Colin Griffith had no duty to retreat before using deadly force. If Colin Griffith was in a residence in which he had a right to be, he had no duty to retreat and had the right to stand his ground and use force, including deadly force, if he reasonably believed that such conduct was necessary to prevent imminent death or great bodily harm to himself. The use of deadly force is justifiable if Colin Griffith reasonably believed that the force was necessary to prevent imminent death or great bodily harm to himself while resisting any attempt to murder him or commit an aggravated battery or aggravated assault upon him. In deciding whether Colin Griffith was justified in the use of deadly force, you must consider the circumstances at the time the force was used. The danger need not have been actual. However, to justify the use of deadly force, the appearance of imminent danger must have been so real that the defendant actually believed the use of deadly force was necessary. Moreover, to justify the use of deadly force, a reasonably cautious and prudent person under the same circumstances would have believed the use of deadly force was necessary. Residence means a dwelling in which a person resides, either temporarily or permanently, or is visiting as an invited guest. However, the use of deadly force is not justified if you find that the defendant was attempting to commit, committing, or escaping after the commission of kidnapping. If you find that Colin Griffith, who, because of prior threats or difficulties with Catherine Griffith, had reasonable grounds to believe that he was in danger of death or great bodily harm at the hands of Catherine Griffith, you may consider this fact in determining whether the actions of Colin Griffith were those of a reasonable person. If you find that at the time of the alleged first-degree murder or any lesser-included offense, Colin Griffith knew that Catherine Griffith had committed an act or acts of violence, you may consider that fact in determining whether Colin Griffith reasonably believed it was necessary for him to use deadly force. If you find that Catherine Griffith had a reputation of being a violent and dangerous person, and that her reputation was known to Colin Griffith, you may consider this fact in determining whether the actions of Colin Griffith were those of a reasonable person in dealing with an individual of that reputation. If you find that Catherine Griffith had a reputation of being a violent and dangerous person, you may consider this fact in determining whether she was the initial aggressor. In considering the issue of self-defense, you may take into account the relative physical abilities and capacities of Colin Griffith and Catherine Griffith. Now, if you find that Colin Griffith committed second-degree murder or manslaughter, and you also find beyond a reasonable doubt that during the commission of the crime, he personally carried, displayed, used, threatened to use, or attempted to use a weapon, you should find him guilty of second-degree murder with a weapon or manslaughter with a weapon. A weapon is defined as any object readily capable of inflicting bodily harm if used in the ordinary manner contemplated by its design and construction. If you find that Colin Griffith committed second-degree murder or manslaughter, but you are not convinced beyond a reasonable doubt that he personally carried, displayed, used, threatened to use, or attempted to use a weapon, then you should find him guilty only of second-degree murder or manslaughter. The defendant has entered a plea of not guilty. This means you must presume or believe that the defendant is innocent. This presumption stays with the defendant as to each material allegation in the indictment through each stage of the trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed and that the defendant is the person who committed the crime. The defendant, on the other hand, is not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. Proof beyond a reasonable doubt does not mean proof beyond all doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if, after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced during the trial and to it alone that you're to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence itself, a conflict in the evidence, or a lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. It is up to you as the jury to decide what evidence. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some other things you should consider are as follows. Did the witness seem to have an opportunity to see and know the things about which the witness testified? Did the witness seem to have an accurate memory? Was the witness honest and straightforward in answering the attorney's questions? Did the witness have some interest in how the case should be decided? Did the witness's testimony agree with the other testimony and other evidence in the case? Did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? Now, the fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Also, expert witnesses are like other witnesses, with one exception. The law permits an expert witness to give his or her opinion.
Did they have
However,
witnesses?
an expert's opinion is reliable only when given on a subject about which you believe him or her to be an expert. Like any other witness, a juror may believe or disbelieve all or any part of an expert witness's testimony. It is entirely proper for a lawyer to speak with a witness about what testimony a witness would give if called to the court or discussing his or her testimony with a lawyer. You may rely upon your own conclusions about the credibility of any witness. As I've said, a juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. The Constitution requires the state to defendant to disprove anything, nor is the defendant required to prove his innocence. It is up to the state to prove guilt by evidence. The defendant exercised a fundamental right by choosing not to become a witness in this case. You must be influenced by his decision in any way. No juror should ever be concerned that the defendant did or did not take the witness stand in testimony in the case. A statement claimed to have been made by the defendant outside of court has been placed before you. Such a statement should always be considered with caution and weighed with great care to make certain that it was freely and voluntarily made. If you conclude that the defendant made the statement, you must also determine from the evidence whether the defendant's statement was freely and voluntarily made. You should consider the total circumstances, including, but not limited to, whether, when the defendant made the statement, he had been threatened to get him to make the statement, and whether anyone had promised him anything to get him to make the statement. If you conclude the defendant made the out-of-court statement, but that it was not freely and voluntarily made, you should disregard it. The following are some general rules that will apply to your deliberations, and you must follow these rules in order to return a lawful verdict. First, you must follow the law, as I am now spelling it out for you in deciding your verdict. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the laws in this case. All of us are depending upon you to make a wise and legal decision. This case must only be decided upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of the exhibits and evidence and these instructions. This case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. And remember, the lawyers are not on trial. Your feelings about them must not influence your decision in any way. Your duty is to determine if the defendant has been proven guilty or not in accord with the law. It is my job to determine what an appropriate sentence would be if the defendant is found guilty. Whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. And your verdict must not be influenced by feelings of prejudice, bias, or sympathy. It must be based on the evidence and the law contained in these instructions. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that makes you think I prefer one verdict over the other. You may find the defendant guilty as charged or guilty of such lesser included crimes as the evidence may justify, or not guilty. If you return a verdict of guilty, it should be for the highest offense on the verdict form for each count that has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then of course your verdict must be not guilty. Now, if you return a verdict of guilty to the charge of first-degree murder, it is not necessary that all of you agree the state proved first-degree felony murder. Instead, the state proved either first-degree premeditated murder or first-degree felony murder. Remember, the verdict must be unanimous. Each of you must agree to the same verdict. Only one verdict may be returned as to each crime charged. It must be in writing, and for your convenience, the necessary verdict form has been prepared. It is fairly straightforward, but the law requires that I show it to you, explain it, and read it into the record. And this is it. It is 2 pages long. At the top of the first page is what we call the caption. That gives you the information about where it reads. in the Circuit Court of the 10th Judicial Circuit of Florida in and for Polk County, with the case number 53 2024 CF 8410A000XX, and the division assignment underneath F9. You'll then note the names of the parties pitted against each other. State of Florida, plaintiff versus Colin Griffith, defendant. It is entitled, not surprisingly, verdict. It then begins, and you'll notice count one is on page 1. We, the jury, find as follows as to the defendant in this case. As to count 1, you'll notice a parenthetical there which reads select only one. That's a simple reminder that you can only have one verdict for each count. There are 4 choices underneath marked A through D. Read on your verdict. That can be a check, Ecker, and singular. A, the defendant is guilty of first-degree murder as charged in the indictment. B, the defendant is guilty of second-degree murder, a lesser included offense. A lesser included offense. D, the defendant is not guilty. And then at the top of page 2, a reminder to select only one. 3 choices for count 2 marked A through C. A, the defendant is guilty of kidnapping as charged in the indictment. B, the defendant is guilty of false imprisonment, a lesser included offense. C, the defendant is not guilty. Now, C, the defendant is not guilty. Now, you found the defendant guilty of either first-degree murder or second-degree murder. You'll notice this next section called special findings, and there's a question, depending on your verdict in count 1, there are 2 potential questions here. But the first question you would only answer if you found the defendant guilty of first-degree murder or second-degree murder. And that question is, 1, did the defendant actually kill Catherine Griffith? The reminder again to select only one. These findings also have to be unanimous, and the reasonable doubt standard applies as well to these findings. So did the defendant actually kill Catherine Griffith? Two choices, yes or no. Then the second question for count one, and this is if you find the defendant guilty of second-degree murder or manslaughter. And that question is, during the commission of the offense, did the defendant personally carry, display, use, threaten to use, or attempt to use a weapon? Again, select only one, yes or no. So, if you find the defendant guilty of first-degree murder, you would only answer question one. If you find the defendant guilty of second-degree murder, you would answer both questions. If you find the defendant guilty of manslaughter, you would only answer the second question. If you find the defendant not guilty, do not answer either question. It concludes, so say we all, this blank day of February 2025, and then there's a place for the foreperson signature and underneath to print his or her name. Now, a separate crime is charged in each count of the indictment, and although they have been tried together, each crime and the evidence applicable to it must be considered separately and a separate verdict rendered as to each. Now, a finding of guilty or not guilty as to one crime must not affect your verdict as to the other crime charged, except, as I'm about to explain to you in the instruction regarding legally interlocking counts. The crime of first-degree felony murder, charged in count one, is linked to count two, kidnapping, and that the crime charged in count two, kidnapping, is an element of the first-degree felony murder charged in count one. You should first consider the evidence applicable to count two. If you find that the crime charged in count two, kidnapping, has not been proven beyond all reasonable doubt, you must find the defendant not guilty of first-degree felony murder in count one. If, on the other hand, you find that the crime charged in count two, kidnapping, has been proven beyond a reasonable doubt, you must then consider the evidence applicable to first-degree felony murder charged in count one. Now, a guilty verdict on count two, kidnapping, does not require a guilty verdict on the charge of first-degree felony murder in count one. You should find the defendant guilty on the charge of first-degree felony murder in count one only if you find all the elements of the crime, including the essential elements contained in the crime charged in count two, kidnapping, were proven beyond a reasonable doubt. However, the alternative crime of first-degree premeditated murder in count one is not linked to any other count in the indictment. A finding of guilty or not guilty as to count two must not affect your verdict as to the first-degree premeditated murder in count one. In just a few moments, Mr. Hertel will take you to the jury room. The first thing that you should do is select a foreperson who will preside over your deliberations, much like the chair at a meeting. It is that person's main function to see to it that your discussions are carried out in an organized fashion and to make certain that each of you has a fair opportunity to be heard. It is that person's job, as I've said, to sign and date the verdict form when you have agreed on your verdicts and to bring the verdict form to the courtroom when deliberations have concluded. During deliberations, jurors must communicate only with one another and only when all jurors are present in the jury room. That means if someone steps into the restroom, all discussions about the case must stop until that person returns. You are not to communicate with anyone outside the jury about this case until you have reached a verdict. Remember, you must not talk about this case in person or through the telephone, in writing, or by use of an electronic device, or by any use of electronic media. Do not contact anyone to assist you during deliberations, and know that these rules will continue to apply until you are discharged at the very end of the case. If you become aware of any violation of these instructions, or any other instruction I have given you during your service, you must tell me by giving a note to the bailiff. Now, many of you have cell phones, perhaps other types of electronic devices with you. The law does not permit those things to go to the jury room with you during deliberations. Mr. Hertel will be collecting those things from you. They will be securely stored away in an evidence closet. No one will have access to them. And they will be returned to you promptly upon your discharge. Or if your deliberations aren't concluded today, you will be given them for the overnight recess. I would ask that you put those things on silent or vibrate. I do have other business to conduct in the courtroom. It would be distracting if your cell phones are ringing over there in the closet. If you need to communicate with me during deliberations, please do that in writing by sending a note through the bailiff. Now, if at the time you send such communication you have taken a vote, please do not disclose the nature of your vote to us. That has nothing to do with any of our functions. It is your private affair. If you have questions, I will have to talk with the lawyers about your questions before I answer, if I'm able to answer. That could take some time. If you are able to continue deliberating while you await my answer, you may certainly do so. If I am able to answer a question and the answer is simple, I will very likely respond in writing on the same piece of paper that you sent to me. If that happens, please keep that piece of paper with the evidence. It must be filed in the court file at the conclusion of the case. If the answer is more complex, you may be brought back into the courtroom for some additional oral instruction. During the trial, several exhibits were received in evidence. You may examine whatever exhibits you think will assist you during your deliberations. They will all be sent back to the jury room with you when you begin to deliberate. In closing, let me remind you, it is important that you follow the law as I have just spelled it out for you in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For centuries, we have agreed to live by the Constitution and the law. No juror has the right to violate the rules that we all share. Any objections to the instructions as orally given, or any additional instructions requested by the state?
No, Your Honor.
By the defense?
No, sir.
All right. Before I identify our alternate jurors, which is my least favorite part of the trial, and send you back to deliberate, I want to know if any of you are aware of any violation, or if any of you have been exposed to any information, anything that might impact your ability to continue serving fairly and impartially. If something you're supposed to make me aware of has not been brought to my attention, please raise your hand. All right. There are no hands raised. You all know your juror numbers, correct? Juror number 1981288, 1981110, and 1980802, the three ladies on the far end of the back row. You are our alternate jurors. You will not be going back to deliberate. There are a few things I would like to say to you before I discharge you. So if you would stay behind in the courtroom with us, the bailiff will make sure that some lunch is set aside for you to take with you. You're welcome to do that. So if you'd stay behind with us for just a moment. For the rest of you, we will send back the written instructions, the verdict form, and the evidence to you in just a moment. You may now retire to consider your verdict.
All rise, please. Anybody else have?
I don't know, that confused me too. If StreamYard will cooperate, thank you. Who's drinking rum? Not me.
Ladies, I'm not sure how you feel. Oftentimes, the alternate is quite disappointed to find out they've devoted so much of their time to the system and then don't get to do really the most important job of the juror back in the jury room. Many alternates are quite relieved to find out they don't have to go through that process.
I would be in this.
Wherever you fall on that spectrum, I hope that you understand that you have performed a vital service by being here across the nation every day in state and federal court, in criminal and civil cases alike. Alternate jurors are selected, many times more than one, such as in this case, and more often than you might think, the alternate or alternates are called upon to take the seat of someone who is excused for one reason or the other during the case. That is especially true and happens frequently in cases covered by the media. This case has received significant media attention, national media attention, and the danger that a friend or family member spouts something off about what they saw on the news that rings a bell with you, or folks just approaching you, trying to talk to you. The danger is quite real that I'm prejudiced during the trial. So that's why we have multiple jurors. Also, the fact that it was over a week-long trial. So I want to make sure that you understand what a vital service you've performed by being here. And here's why it's important. If something had happened to those who are now back there deliberating, and I did not have an alternate or sufficient number of alternates to replace those folks, and the parties could not agree to proceed with fewer jurors than they're entitled to under the law, in this case 12, my hands would have been tied. I would have had no choice but to scrap everything, send everyone on their way, and start all over on another day. And you know just what an expensive proposition that is for everyone involved, your fellow jurors, and the community of taxpayers. So you have indeed performed a vital service. I've been telling you, you cannot talk about this case or look things up. You are completely released from both of those orders. You can talk to anybody you want to, including the people here. They can't approach you, but if you had questions or comments, you can approach them. You're welcome to stay and see what happens. Want to make sure that you get some lunch, but you are also equally free to forget about this case, refuse to talk to anyone, and be on your way. That's going to be up to you. On behalf of the entire 10th Circuit and all assembled here, I humbly thank you for your service. You are now discharged. I think we need to wait on the bailiff because he's going to take you out this back door. So give us just a minute.
guys. Okay, we're gonna do some Googling. Now that just because said it, I do realize what you were talking about, Judy. Yeah. Felony murder is murder committed while, or not while, but during the commission of a felony. So if, for instance, let's say you're gonna rob, I don't see how it applies in this case. Anyway, there was a case where this young guy, I don't think he was a teenager anymore. I think he was technically, I mean, he might have still been a teenager, but he was an adult. So like 18, 19, he might have been in his early 20s. He killed his grandfather, and it was self-defense, but it was like not at the time self-defense. It's like it was an abusive situation, and he had a sibling. I don't remember if it was a brother or a sister, a younger sibling, and their grandfather had custody of them, and he was abusive, so he killed his grandfather. Imperfect self-defense, yes. And he killed him, but he had money in his wallet that he stole. And it was, I forgot how much money was in there, but because he robbed him during the commission of the manslaughter or whatever, it became a felony. It became felony murder because of that. So, but in this case, isn't first degree premeditated murder already felony murder? What is that? Felony murder? No? I don't know. I heard that story a long time ago, so I probably didn't tell it right. Felony murder is a legal doctrine that allows people to be charged with murder for a death that occurs during the commission of a dangerous felony, even if they didn't intend to kill the victim. Okay. So, if he kidnapped her, but then she died, okay. The felony murder rule applies to dangerous. Hang on, let me make this show more. The felony murder rule applies to dangerous felonies such as arson, burglary, kidnapping, robbery, and essay. If you are a getaway driver for a bank robbery and someone gets killed during the bank robbery, you can be convicted of felony red rum for that person's death because you're involved with the felony of a bank robbery. Right. So if he kidnapped her and it was an accident, then that would make it felony murder, even though it was an accident, if they get the kidnapping. That's why they tied on the kidnapping. Oh my God. That's why they. Oh. That is why. That's why they added on the kidnapping. Because he said it was an accident. The case that I was talking about, the imperfect self-defense, I don't know if that was a Florida case. I don't remember. That was an old case that I heard about a long time ago, and I don't remember the specifics. I just remember that the kid got in trouble because he stole the wallet, the grandfather's wallet. But that wasn't imperfect self-defense. He killed him because of abuse, and but just because it's right, that doesn't fit in with the felony murder definition. So I don't know why on whatever podcast or true crime show or whatever I saw that on, that doesn't fit with the. Oh, the rum talk. Okay, I get it. I was like, why do you keep talking about rum? um, so I guess that's why they did, because, like I said, that prosecutor, and I don't know, maybe it's me, maybe I pictured it wrong from his description, but to me, the description was, you've never heard, whoa, whoa, whoa. You have never heard the term red rum? Okay, boy, I gotta educate you. There's a Stephen King movie. Well, it's not a Stephen King movie. Stephen King wrote a book called The Shining. And in that book, it became a movie directed by Stanley Kubrick. It's a classic horror film. And there's a little boy in it. And he keeps seeing the word red rum. And that word backwards is a word that YouTube does not like. So, yes, there's also a mini series. And the mini series is much better because it goes along with the book much better than the movie. If you just take the movie by itself and not compare it to the book, it's an excellent movie. But if you want it to match up with the book, you need to watch the miniseries. But if you take the miniseries alone and the movie alone, the miniseries is better. That's just my opinion. What is that? Watcher in the Woods. I think I've seen. But a long time ago. Where are you going? I don't think I would want to fly right now. And I'm not afraid of flying. But right now, Aruba? Dang. You're going to Aruba? Judy's going all over the place. Dominican Republic, Virgin Islands. Y'all, I'm jealous. No fair. Well, I do live in Florida, so I guess I can't complain too much. The person that can just drive to a theme park and stay for the day whenever she wants to. And some people, it's like a once in a lifetime trip. So, I have seen that movie, but it's been so long I don't remember. No, it wasn't that one. I think it was Something Wicked This Way Comes. Yeah. I don't know. Great. Now I'm going to have to watch it. So, anyways, I think that is why they added the kidnapping charge. I think the prosecutor was like, oh, he pulled her hair. Oh, stop. Yeah, I think. See, this is why I think I've seen it because I do remember that Betty Davis was in it. Yep, Betty Davis. There she is. Oh, it's a Disney movie. Oh, cool. I wonder if it's on Disney Plus. Oh, and look at that. It's right in there with people also search for Something Wicked This Way Comes. So yeah, that's why I get them mixed up because they must be similar movies. Jason Robards, Jonathan Price. Oh, look, Dark Disney. Is that a Disney movie too? That's a Disney movie too. Well, no wonder I got them mixed up. Well, I wonder. Hey, Arno. Oh, it's not on Disney Plus thing. You have trial transcripts? What trials? And where did you get them? Do you have to pay for them? I'll have to pay for them, right? Yeah, I used to love that song too. Although when I was a kid, I barely knew who Betty Davis was. When I got older and started to appreciate classic movies more. Um, how long do you think we should wait? Because the last trial, the Jason Chin trial, I went, I left it open, like I closed the live feed. I mean, the live stream, my live stream. I closed it, but I left the court feed up, and then I went to cook dinner, and the I was watching. What was I watching? I don't remember. I was watching something. I had just put the casserole in the oven, and it wasn't even. It was like a half an hour time, and it wasn't even done cooking yet. And the verdict came in, and I was sitting there watching something, and I heard noise, and I was like, and I was like, um, where's that noise coming from? Because I didn't expect the verdict already. So I thought, so I thought, what? I thought it had to be a question. So I sat down and I think I texted somebody and asked if it was a jury question or verdict. And no verdict. So then I got right back on. I was like, I shouldn't have stopped the live feed. It was like 45 minutes or something like that from when they started deliberating. Oh, there's a court TV case file website. Oh, I gotta find that website. Well, I don't know what to do. See, if it's just documents and stuff. Jason Chin, yeah, you missed that one too. AJ stole you from me. I'm mad at her. She stole you. Stole you away. And I was going to make you a mod, but you were a mod on hers already. Jason Chin, I have a playlist. He unalived his girlfriend. He eat 60 times. 60. You forgot Judy, Ardo. How did I find AJ? AJ's daughter was on Ada K's channel, and I found Ada K through Recovery Addict. Stab. We say eek eek. Because we're trying to not tick off YouTube since I'm so close to monetization. We're trying to keep things as YouTube friendly as possible. So we say eek, 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 eek. What's that from? Psycho? Yeah. Yeah, that's from Psycho. So Red Rum and eek, eek. One of my favorite horror movies. Next I'll be going. That's Friday the 13th. Oh man, my hair. I do this every time I get it cut. Every time I get it cut, I like it for about a week, and then I'm like, what did I do? I wanted to be all one length again. I'm tired of the layers already. I need to be 500, Ardo. I just need 139 more. I just want to be 500. That's all. Just want 500. That's all. So Jason Chin, he did that to his girlfriend, and then he dismembered. Did he dismember her? No. He shackled her so that she would fold and put her in a suitcase, and then took the suitcase out and dumped it not in the river, by the Tennessee River, and then suitcase. Then went back to his apartment after going and getting cleaning supplies from the Walmart murder aisle. And he also went to, was it CVS too, guys? Or Walgreens? It was one of those to get more cleaning supplies. Then he went back to his apartment, got her car, drove it to some condominiums place, abandoned it there, then took an Uber back to his apartment, and then cleaned up the apartment. And he thought he was being swift. He took his, no, her SIM card out of her phone and put it in his. Or I'm getting that mixed up. Yeah. So it would look like it would ping that it looked like her phone. So, and then she, at the time that it was happening, sent a text to her mom telling her mom where she was. She was 22 and he was 24. And it was right before Thanksgiving of 22. So she knew she was in trouble. She sent a text to her mom. Her mom knew she was with friends. And then he was texting her mom with her phone to tell her mom that she was going to be with her friends for Thanksgiving or something. And then he put her SIM card into his phone so it would make it look like her phone was pinging off of places. And they never found her phone, but when they arrested him, they found the SIM card from her phone in his backpack. So he tried to cover his tracks. So that's consciousness of guilt right there. So I forgot what he said. What did he say the reason was? Why he did it. I forgot what he said why he did it. But what happened was they were just hanging out, and I guess they'd been smoking some weed and drinking some wine, apparently. And she went in the kitchen, and his phone was there, and they had met on a dating app, and I guess that dating app was still on his phone, and there were girls still texting him and stuff, and she found out and confronted him, and so that was it. And he had creepy pictures on his wall. You know, like you see in true crime documentaries or both CVS and Walgreens. Okay. Um, but in like thriller movies, how they have like cutout pictures on the wall or pictures on the wall of people they've been stalking and stuff. He had like a big collage thing on his wall of pictures like that. And I was like, I think somebody needs to investigate all those pictures on his wall because this might not have been the first time. Like, and I don't know, if I had been a detective on the case, I would have wanted to look at the Tinder app and talk to people that he connected with on Tinder before, but I don't know. I'm not a detective and I don't control the taxpayers' money that pays for investigating. So, well, I've been saying that you should start your own YouTube channel for however long I've known you. Because you know more about this true crime stuff than I do. You're always like, have you heard about this case? Have you heard about that case? I do have Discord. Problem is, I have 2 different accounts, and I don't know how to put them together. One of them is Debbie F. Cook, and one of them is Debbie F.C. Oh, that's right. That's right. He said it was self defense because she came at him with broken wine bottles and wine glasses and stuff. Yeah, self defense. I don't know. Let's see, the one on my phone, because I have one on the phone and one on the computer, because I don't know how to consolidate it. Debbie F. Cook. The D, F, and C are capital. Oh, wait. I don't know. Under my picture, it says Debbie F. Cook, and the D, F, and C are capital. But below that, it says Debbie F. C, all lowercase. So I have no idea. I don't know. And when I was trying to join as the gavel drops, I couldn't join because I was trying to join with another account and it wouldn't let me do it. I don't know. I don't know how Discord works, and I've got two accounts and it screws me up. So I don't know. But I have to advertise as the gavel drops because they do notifications for me whenever I go live and whenever I put a video out. And Toxic Orchid will come in and remind me to advertise. So she'll come in and she'll be like, Debbie Face and Cook or Debbie F. Cook, please look at your Discord DMs. And it'll say, here's a link you can post. And I'm like, Toxic, I made you a mod so you can post it. Because I check it on my phone. I can't check DMs from her. I can't check on the computer because that's the account that I couldn't add as the gavel drops to because of my incompetency with Discord. I'm I'm learning, y'all. I'm learning, and I've been doing this for 2 years, over 2 years. I'm your old name. Okay, that must be on the one that's on the computer then. I don't know. Well, I thought I had one on the computer. No, I can't even find that. Oh, jeez. Oh, there it is. Yeah, as long as oh no, it's downloading updates. As long as I'm not playing a video, things seem to work. Probably shouldn't have said that. I probably did jinx to myself. Oh, well, at least least it wasn't hot. I've never had feta cheese. No, not all capitals. It the Debbie F. Cook the D, the F, and the C were capitals. The Debbie F. Okay, well, I guess I can't pull Discord up and StreamYard and YouTube at the same time. I thought it was okay as long as it wasn't video. Dang, I hate. This internet was fine until just recently. I don't know what happened. And okay, well, don't worry about it. I'll get them from somewhere. Oh, or you could email me. What is Judy? What's my email? I have 3 emails. I have 3 emails, and I have my primary email, which is that's got all my junk mail in it, plus like that's the email I give for like official stuff, like the state um for my MMJ license and official type stuff and all my medical stuff. So I'm trying not to use. I need to get rid of all the junk mail, and I'm also trying not to use that for YouTube stuff and this kind of stuff. So I'm using the Google email associated with the channel. Okay. So that's the email that Judy sends me all of my court documents and stuff on. She has her own folder. So I put everything she sends me in that folder, so that's where all my court docs and stuff goes. So I can find it easily. And then I have another one that I don't use. I don't think I use for my other YouTube channel, which I was gonna get rid of because I don't really use it anymore. The only thing with that is if Alita ever decides to start streaming again, I'll lose all my time on her membership. I started over on, well, not like started over, but some of my memberships I do from this account now, because in the creators, I got it, Judy. Judy is on a delay for some reason. We don't know why. We can't figure it out. Um, I forgot what I was saying. Oh, the creators, because I've got premium for this channel now, for this YouTube account. Because I don't know if y'all remember, but when I first started streaming, I had commercials all the time, and I would be like so embarrassed. I was like, "Oh no, I'm sorry about the commercials. I'm sorry about the commercials." So I got premium. I don't have premium on my other YouTube channel, and so I started watching stuff on this, and then I would then go into chat on the wrong account, and then be like, "Oh no, I have to change." And so then I just started watching it with premium and stopped changing, and then just started doing memberships on their account, on that account. And then we were talking about paying, how creators get paid and stuff one day on Recovery Addicts account. He's like, I make more money from the people that have premium. And I was like, oh, I didn't realize that. So I'll start doing it from these accounts, and it's easier on me. So, but I don't know. I probably won't. I don't know. Probably won't delete the other one. I'll probably just leave it because I've been on Alita's. Actually, I don't know if my membership's active on Alita's right now. Because she hasn't had Bike Club in so long, I haven't even checked it. And that's why I started. That's why I started streaming trials, was so all the Bike Club members could come over here, and we could all stay together and still watch trials. And only a few of you followed me, which is kind of disheartening, but that's okay. All the important people are here. So I wish well, we were behind though. I was going to say, I wish I had a timer like Recovery Addict does, so I could time how long the jury's been out. But we would have been behind anyways. You guys are sending me hearts. You're so sweet. Well, y'all. Thank you, Flash. I don't know. What can we watch? While we wait. I really don't think they're going to come back today, though. And they're probably eating lunch right now. Oh, I hope I don't get in trouble for playing this one, but it's so cute. I love this bat. It's very, very short.
This is Alex, and he was rescued last night by Louise. And he's very, very hungry.
Oh.
No obvious injuries. Apart from the fact he's terribly thin. So we're just trying to sort of reconcile why he's so thin. He does have a bit of damage on his thumb, old injuries on his thumb and also on his wing membrane, but certainly nothing that would ground him. Anyway, he'll come. Won't you be, Nate? You're enjoying that banana. Lots of bananas where that one came from. Oh, I'm not going to take it away. Here it is. There you go. Get some juice into him and hopefully he'll be up and hanging in a few days, my darling. I think he'll be. Yeah. I'm going to take you now anyway. There it is. I'll just leave it there for you. Good man.
That was a different one. The other one I saw, that other one, that bat was chowing down on that. I mean, his cheeks were like to here. That's why I thought it was the same one, because of course they all look alike. Yeah, flying dog. I love bats. Of course, I'm going to keep my distance because I don't want to get rabies, but I love bats. I think they're amazing creatures. I just love to watch them. We had one day, Travis was like, come here, look, there was a little bat hanging off the eave of the house. And he was like that big. It was like a baby bat. And I don't know why he was still there. I mean, the sun was out and he's just hanging. I was like, why are you still here? And he was so little, I just wanted to like scoop him down and like, I was like, I know I can't touch him because he's a wild animal, but he's a little baby and he's so cute. Like, because I don't know. I don't know enough about bats to know what to do. And I was like, I'm just going to leave him and hope that he ends up wherever he's supposed to end up. They're not bigger than you, Flash fan. That even fruit bats that are huge are only about, you can't see, that big. Because they have fruit bats at Animal Kingdom. I have never been to Austin, but if I ever go to Austin, I am going to have to do that because that sounds amazing. They had a bat exhibit at the Florida Museum of Natural History years ago, and I missed it. And I was very upset that I missed it because I really wanted to go. That would be really good. Yeah. I live way out in the country. And we have cicadas and grasshoppers that get to be like about that long. And they will just fly right into you. It's like, whoa. And I don't know if it's because of the bugs or if it's because we live way out here in the country. There are spiders everywhere. And I used to be really afraid of spiders. Not like phobic, but afraid. Um, check on court just to make sure. My computer is doing that thing again where it's not paused, but it's still not doing anything. So weird. I hate when it does that. Okay, no sign of anything going on. I still don't think it's going to be anytime soon. But yeah, Lori Vallow's pro se. Yeah, but Peter said she was making good arguments. Even though they weren't going to work, they were still good arguments. So I don't know if the spiders are. We're out in the country, so I don't know if the spiders are because it's country, or if they're here because this is where the bugs are. I don't know. But one time, years and years ago, when we first moved out here. Well, first of all, when we moved out here, I told my dad, I'm like, I don't think I'm gonna live here, Dad. There's too many bugs. But I did, and after we started living here, and he like landscaped the yard and everything, there weren't as many bugs. And one day, I opened the front door, and I was looking back to talk to my dad as I was walking forward, and I turned my head just in time to keep from running into this giant spider web that was from door frame to door frame with a giant banana spider right in the middle. And I screamed and freaked out, and Dad killed it for me. Now, though, when I see the giant banana spider, they are beautiful creatures. And as long as they're not on doorways like that, where you can't go through the door, I leave them alone. And they eat the bugs. And so I'm happy. Stay out of my house and eat the bugs so that they don't fly in the doors when I go in my house, and I just leave them alone. And if they are jumping spiders, I have 2 spider habitats that are ready to go always. And then if I see a jumping spider outside, I scoop him up and I bring him in. I keep worms ready. They're in the fridge. If I forgot what kind of worms they are. But if you put them in the fridge, they go into hibernation. And then I bring them out, and when they warm up, they get all wiggly again, and then I put them in the thing with a jumping spider, and I feed the jumping spider. And then if they seem to do bad, like if they start acting sluggish, or they stop eating, I guess because maybe some of them don't like to be on a all worm diet. I don't know. Then I let them go back outside because I feel like if they're not doing well in captivity, that I should let them, because I've kidnapped them from their home. So, but yeah, I'm not afraid of. I think it was the jumping spider because I used to watch them on YouTube, and I think that was what made me not be afraid of them anymore, because I saw how cute they were. And jumping spiders get to know you, and they like being around you. I'm not so sure about males because I've not really had any luck. The only regal jumping spiders are native to Florida. Pantropicals are native to tropical areas. Yes, I know your dog phobia, Flash. Um, I'm afraid of big dogs if they're like snarling, barking, gonna come after me, big dogs. Um, so male regals, I have not had any luck with. They don't seem to do well in captivity. Um, Female regals, they're very hard to find. I've had 2 of them. They, they, the 2 that I've had, they like to get out and crawl on you, and they'll wave. They'll move their little leg, And now just look up that chin and wave at it. They're so cute. Yeah, I like big dogs, but I prefer smaller dogs. I'm not afraid unless they show aggression to me. I'm not afraid. We used to have pit bulls. We had two pit bulls, and they were the sweetest dogs. I just think I figured out a way I can maybe show you guys those pictures. Maybe. Let me see. Oh, maybe not. Let me see if it, I don't think that's gonna work. Maybe. No, I don't think it's gonna work. I'm terrified. Well, what are you doing, you stupid? No, they did. That is cool. Nope, that didn't work. That's cool. Well, that's good. I don't blame you though. If you don't know the dog, you don't know what they're gonna do. Oh, that one is in California? I remember seeing the the title of that case being Celebrity Hairstylist or something like that. And I was like, Celebrity Hairstylist, where is that? Because they don't stream cases in California. Is it on like a case by case basis or they just allow them to stream cases now? Yeah, I think that's didn't Recovery Addict say he wasn't going to do that because it was the love affair trial? I don't know. I think I heard something like that from Recovery Addict. Ada K is doing it. Ada K is doing this trial and that trial, and she's also still on the Richard Allen thing, the Delphi, because she's like, oh, I missed that trial because I was streaming something else, and I was like, 8K, it wasn't live streamed. So she's like doing all this like research and stuff. She did one stream on Odinism, which I missed. I need to go back and look at that. And then Sunday night she had Bob Mata from the Defense Diaries on, and he talked about, because he was there in the courtroom and he's, I guess, done streams and stuff about it. And he knows his wife. I don't know if he's talked to Richard, but he knows his wife. He's talked to his wife. And so we were asking him questions about the things that happened to him, to Richard Allen, specifically about being held in solitary before he was convicted and all that kind of stuff. Oh, that one? The ASAP Rocky trials in California too? I don't know why I was thinking that was in Atlanta. Yeah, I saw. Why did I see that one? I mean, I didn't see the whole thing. I can't remember whose channel I was watching part of it on. I was watching the video. It might have been on Lawyer You Know's channel. Because no, I didn't know that. Yeah, I really like her daughter. I forgot her daughter's name, but she's so cool. I love her to death. Carmen. I kept wanting to say Candace for some reason. I think it was on Peter's channel. I saw the video of what happened. And it was a close up of their faces, but it wasn't great video. And they had hoodies on, and you know, it was like grainy surveillance video. I mean, I guess if you're there in the courtroom and you can see them close up and you're closer, you know, you can see the video better because you're there. Maybe you can see if it's them or not. But what is ASAP Rocky saying? Isn't he saying like it was a starter pistol or something? It wasn't a real gun? Wait, are starter pistols? Okay, we're going to Google again. No, a starter pistol is not a real gun, but it is classified as an imitation firearm. Starter pistols are blank handguns or electronic devices that are used to start races. Starter pistols are designed to prevent the user from firing a projectile. They are often revolvers that use blank shells or caps. So it's a cap gun? They're also known as blank pistols or blank guns. Is it a blank gun or a cap gun? Those are two different things. Starter pistols are used to start track and field races and sometimes competitive swimming or speed skating races. They are also used for dog training. It is illegal to modify a starter pistol to fire real ammunition in most places. The story is he was at a gas station with some other guys that are all ASAP whatever. And it's a gang. ASAP is gang. But they're saying ASAP is that they were all in the foster system together. So that was like their group. They named themselves ASAP. And I forgot what ASAP stands for. It doesn't stand for the normal ASAP. I can't remember what it stood for. And that some guy was harassing him or something, and that he pulled out the starter pistol to scare him. I don't know. Yeah, it's one of those. That's why I was thinking Atlanta, I guess. It's one, and which is why I don't care to watch it. In fact, I don't even think I watched the whole video because that kind of crime does not. Yeah, and he's Rihanna's baby daddy. That kind of crime doesn't interest me because that's just thugs being thugs. You know what I mean? crimes. I feel so conflicted about liking true crime. Because why do I like learning about other humans being bad to other humans? But thugs just being thugs holds no interest for me whatsoever. I don't want to sit through a trial and listen to a defense attorney defend somebody that this is their way of life. Oh, Ardo, I missed one of your inappropriate comments. What did you say now? Sounds like fun. Yeah. You're always such a joy. I love it when you're in my chat. No, I'm not. Not that I know of. That would be cool though. Unless my husband is and doesn't know it. But I like cases where some stupid idiot has thought they've gotten away with doing something. They thought they were smarter than everybody else. Like Natalie Cochran that did that whole Ponzi scheme thing and thought she was smarter than everybody else. And when her husband started catching on, she ended him. Those are the kind of cases that I like. I mean, even Jason, blah, 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 I can't talk today. Jason Chin, even that case, that was a little below the level of things I like to watch because that one was just like cut and dried, like black and white. That was just the ones where the jury comes back fast. Now, Sarah Boone was like that too, but that had an entertainment value to it, you gotta admit. Likewise with Daryl Brooks. There are some that are open and shut, but there's entertainment value to it. You know, there just is, and you can't deny that. And you just it's like a car wreck. You can't look away. Well, maybe I shouldn't have said car wreck in the case of Brooks, but you know what I mean. Oh, hitman cases are good too. I stayed away from the Adelson cases for the sole reason that I didn't come in at the beginning. Like, I don't even know. Like, were the cases, when I caught wind of it, it was in the middle of Charlie Adelson's trial. Did they even stream, like, his girlfriend's trial? And wasn't there, or did she take a plea or something? Like, I don't know the background of the story. I don't know, like, I didn't know any research. I didn't do any research into it. I didn't know anything about it. All of a sudden, when it was on my radar, it was Wendy was testifying against Charlie. Like, that was the first I heard about it. So I didn't watch it. I didn't get involved in it in any way. I also wasn't streaming trials back then. I was still doing my true crime videos. So I kind of let it alone. And then I didn't start to get interested in it until Donna Adelson got arrested. So I still haven't done like a lot of research or anything into it. But now that Donna Adelson's trial got postponed, I might do her trial, but I still feel like I need to go back and do some research. Because I wasn't gonna, when her trial was set for, when was that? Like September of last year? I wasn't gonna do it because I didn't know enough. But now she has, it's got delayed. She's got new attorneys and all. Doesn't she have new attorneys because they were her son's attorneys and there was some kind of conflict? Which that was idiotic in the first place for her to use her son's attorneys. So I kind of want to do that, but like, and we don't even have time to go back and watch Charlie's trial. I don't think because we've got like a full plate right now because I don't even know. I want to do some more videos, and I don't even know what I'm gonna have time to do videos because the 6th and the 7th is Karen Reed trials or hearings. I'm sorry, hearings. The 6th definitely because they put the 6th and the 7th aside for a Daubert hearing on Green, and I don't know what Bev's decision on that was. We've been up for almost 2 hours. Judy, love, could you do me a favor? Since you're so good at finding documents on Discord for me, can you look and see? Okay, let me write that down. I'm gonna have to write it on a sticky note and put on my whiteboard later because I put my whiteboard here. I thought I was gonna be smart and be like Lita and have a whiteboard so I could just write on my whiteboard every time you guys made a suggestion like she did. But my chair I kept doing this, and my chair would wipe stuff off my whiteboard. So my whiteboard's way up there. And you guys don't want to look at my belly while I'm writing on my whiteboard. So, Jose Baez. Why does that name sound familiar? Microsoft. What did he do? Is this going to be a boring white collar crime, though? Oh, that's why the name sounds familiar. Okay, I detest that woman. Detest her. And there's so much coming up in September. Because there's Stearns, there's somebody else that Judy told me about, whose name I've forgotten. I have it written down somewhere. Judy, did I finish asking you what I wanted? ADHD is on overdrive today, y'all. I am so sorry. Did I ask? Judy, did I finish asking you? I've got my phone in my hand. I could just text you. Gravy Marie. Did I finish asking you what I wanted you to do? Discord documents. Bev's answer about Green testifying. Are they going to have a Daubert hearing tomorrow and the next day for Green, or is it going to be something else? Because she said, let's keep the 6th and 7th open. They also have other motions they need to discuss. So I don't know if it's going to be a Daubert hearing for Green, or if it's going to be other motions, or the motion to dismiss, or what. But she said, let's keep the 6th and 7th open. So I don't know what we're doing, but we're doing motions at least on the 6th. And then I don't know what we're doing on the 18th, but we also have the 18th, March 4th, 5th, and 7th. She set all those dates aside for stuff. And I don't know why. And unfortunately, for that court, I guess it's probably that way for all of Massachusetts, you have to pay for documents. But at the Gavel Drops has them all. I just don't know how to maneuver Discord. So my sweet, wonderful Judy does it for me. And one day I will pay her back somehow. I can't right now. Because I don't have AC and I have to pay $8,000 for that. Thank you, Jesus, that we got all the termites. I think we got all the termites. Because I do not want it. Number one, we don't have the money to pay for treatment. Number two, if they have to tint the house, we have no place to go, and we have 3 animals that we would have to take with us wherever we go, if we find a place to go. So that's not feasible. But Travis put 2 bug bombs in the attic, and he says he doesn't see any wood damage up there. And when he went back up, they were all dead. He didn't see any flying around or anything. So I think we got them all. And the only real bad wood damage was the window frame in the kitchen. I don't remember if I showed y'all. I know I showed you the picture of the bugs because I screamed while I was live streaming. I freaked out. Oh, I can show you the pictures just by holding them up to the camera of the pictures that we took. Although that's not optimal. There is one side of our kitchen window. That was the side that we thought wasn't the bad side. This is the side that we thought was the bad side. It's not as bad. They had fun. They were having a feast. Travis took a screwdriver, he took the back of it and banged. And you could hear the right side, the one that wasn't as bad, it sounded completely hollow. And the left side sounded solid. It sounded good. And there was a crack in the side that sounded hollow, and he just stood there and was just like, looked at me, and I'm like, go ahead, I know you want to. Go ahead and tear it apart. I would rather have no windowsill than bugs. Go ahead and tear it apart. So he stuck the screwdriver in the crack and pried it open, and there were little ones running around in there. So he pried the whole thing off and sprayed the raid and got them. And then he just looked at me. He kept banging. And then I went to the bedroom. I still heard him banging. So I came out. I'm like, go ahead, just tear the whole thing off. Go ahead, just tear the whole thing off. And the other side was worse. She ruled. Oh my God, no way. Shocking. Shock and horror. She hasn't said whether he's qualified as an expert. Shanna Gardner and her new husband, Mauro Fernandez, is accused of hiring a hitman to take out her ex-husband, Microsoft executive Jared Bridgen, whatever. Oh, so it's not, okay, not white collar crime. Man, why do you need to kill your ex? He's an ex. Unless there's kids involved or money involved. Oh yeah, where are the hearings on like Law and Crime or Court TV or something like that where I could stream in? or is it on somebody else's channel? I mean, I'd like to watch them, whether I can stream them or not. I also need to look about Ashley Benfield, even though I know that's probably a no. I've looked her up so many times that all I have to do is click in the name bar and her name comes up. Oh, I don't know. Because before I looked at, because she's got domestic relation cases. That's obviously her and Doug's cases, and felony. But now it says appeals to circuit, and there's a bunch of those. So I don't know which one to look at. Oh, that just looks like a notice of appeal. See, the appeal stuff is different. Yeah, she had a she had a hearing and I streamed it. Oh, yeah. Well, that explains it. That's probably why she did what she did, which is so selfish. I hate it when people use their kids as pawns in a divorce. My ex sister in law did that, and but it also makes me mad when the dad doesn't fight, and my brother did not fight, and it didn't help that his present wife didn't want him to have anything to do with his kids. Why does it just say notice of appeal? And why isn't it one long list? This is so weird. This is totally different than the criminal case record thing. Weird. Well, I don't see Judge White's decision. What the Hitman one that you were just talking about? Or Ashley Benefield? I don't know. I can't find Judge White's decision. Usually, though, judges don't give bond pending appeal, especially in a murder case. Well, I mean, they found manslaughter for her, but okay, y'all, I am perplexed because when I'm streaming a trial and I pause it to talk and I have 6 people here, by the time I'm done talking, I got 3 left. And right now, nothing is happening. All I'm doing is talking and I have 6 people here. Not complaining. Hi, everybody. I don't know what I'm doing wrong, you guys. I don't know. Is it just that people can't find me or don't know what I do here or what? I don't understand. I do understand that when StreamYard crashes all the time, like that would aggravate me. I wouldn't watch a channel where StreamYard constantly crashes. I understand that. If that's the problem, I totally understand. But y'all, I've been on here for 2 years, over 2 years now. I am not telling y'all to get out. No, I'm not. No, I'm glad everybody's sticking around. But I know we don't have anything to do right now. I could find another fun video to watch. That other one, that other bat, he wasn't just licking that banana, he was chowing down on it. I don't know if I can find it or not, though. I thought that one was it. Because, I mean, bats look, those kind of bats look exactly, well, I guess each species of bat, what's the word I want? Oh, are you freaking kidding me? Are you freaking kidding me? They are streaming that dog park murder trial. I didn't think they were going to. Okay. Wow. Okay, you guys, we got something to watch. I had given up on this trial because they weren't doing any of the hearings, and I didn't think it was going to be streamed. And you guys know how excited I was about this trial. Okay, I got a Phil Flash fan in. Okay. These 2 old guys, I forgot what county. I even took down, I had a sticky note that had the guy's name, the case file number, everything. And I took it down and threw it away the other day because I thought we weren't going to get to see this one. Okay, 2 guys. They are older guys. I don't even remember the county. I think it was Hillsborough. It's Florida. They hung out at the dog park every day. And one of these guys, he was gay. And when he came out, he told all his friends at the dog park. And Gerald Radford. He went over to the guy and he's like, "Oh, that's great, man. You shouldn't have to hide who you are. You should be able to live the way you want, love who you want, you know." However, they had some kind of a falling out, I guess. Or maybe they weren't really friends in the first place. I'm not sure. But they didn't get along. And I can't remember the victim's name. His last name was Lay, I think. He has recordings from previous times where they'd gotten into arguments, and Radford had used slurs against him. I think he called him the F word. I'm not sure because I haven't seen those. Because the only pretrial hearing that we saw was the parts of the stand your ground hearing, because he said that it was self-defense. But they're charging him not only with murder but a hate crime, and he said they're charging him with a hate crime, but he said it had nothing to do with him being gay. He just didn't like the guy. That they didn't like each other, and he came at him first and he defended himself. So the reason why I'm interested in this is because, is it a hate crime? Really, is it a hate crime? Did he kill him because he hated him because he was gay? Or did he just hate him? Like, why should he get the aggravated charge of a hate crime if it wasn't actually because he was gay? Maybe he just hated him because he hated him, and it had nothing to do with the fact that he was gay. So, do you know what I mean? Am I making the hate crime distinction clear? You know, is the Uber Eats case? Is that really big guy with all the tattoos on his face? Okay, it looks like this is the morning. We're gonna be playing catch up for a while, and I'm gonna have to figure out. You know, no, I'm not even gonna say anything about that. What in the world? What are you doing? I don't know. Possibly. But sometimes you say something just to hurt somebody. So I want to hear the evidence before I say just because he said it, it meant that he was homophobic. I am not homophobic.
The state's charging document, which I read from yesterday, that's called an information, is not evidence. And it's not to be or your job and my job are very different in this regard and do not overlap. And this is one of our fundamental principles of our system of justice. So let me explain briefly how the trial will be conducted. At the beginning of the trial, the lawyers have an opportunity to make opening statements to you. Now, lawyers are not witnesses, so what they say is not testimony, but opening statements are intended to tell you what they think the case will be during the course of the trial. After opening statements, witnesses will be called, they'll be examined and cross-examined by the lawyers. Evidence will also be admitted during the course of the proceedings. After all evidence has been presented, I will read you the instructions on the law. You also will have your own set of written jury instructions, so it's not a civics test that you have to memorize. You'll have your own set of instructions to use during closing arguments and during your deliberations. The lawyers then have another opportunity to address you in closing arguments, and after that, you'll retire to consider your verdict. You should not form any definite or fixed opinion on the merits of this case until you've heard all of the evidence, the arguments of the lawyers, and the instructions on the law that I give you. Until that time, you must not discuss this case among yourselves. Your verdict must be based solely on the evidence or lack of evidence in the law. You must decide this case without distraction and only on the evidence presented here in the courtroom. You cannot do any investigation of your own. This includes reading newspapers, watching TV, using a computer, cell phone, internet, any electronic device, or any other means at all to get information related to this case or the people and places involved in this case. You cannot visit places mentioned in the trial or use the internet to look at maps or pictures or to see any place discussed during the trial. If you do make these investigations, research, or inquiries of your own, I have no way to make sure the information that you obtain is proper and even accurate. And the parties likewise have no opportunity to evaluate what you're considering. So please do not communicate about this case with anyone, including close family or friends, even your fellow jurors. No communication includes no in-person, telephonic, electronic communication, texting, emailing, posting information on social media or a website or any other forms of communication. During the trial, as I explained yesterday, we will take recesses. You'll be permitted to separate and go about your personal affairs. It's important to remember all of these communication rules apply during all of those recesses. It's important that you keep those juror badges on during the course of your stay here at the courthouse. As you've seen, we share common entrances, lobbies, elevators with witnesses, lawyers, etc. So don't put yourself in the position that you overhear people who might be mentioning things about the trial. Of course, if anyone attempts to have a discussion about the trial in your presence, tell one of our bailiffs immediately. Your cell phones, computers, tablets, ringing, iWatches, all of that type of stuff should be turned off while you're here in the courtroom. Off means really off. It's off, it still annoys the person sitting next to you. And again, the reason for this is that everyone can pay 100% attention without distraction in the jury book. I'll just remind you, in every criminal proceeding, a defendant has the absolute right to remain silent. At no time is it a duty of a defendant to prove his innocence. From the exercise of a defendant's right to remain silent, a jury may never draw any inference of guilt. And the fact that a defendant chose not to testify in his case cannot affect your verdict in any way whatsoever. The attorneys here are trained in the rules of evidence and trial procedure, so it's their duty and really obligation to make legal objections that they believe are proper. How that's going to work: when an objection is made, usually after a question is asked, I'll either sustain the objection, which means the witness will not be allowed to answer the question, or I'll overrule the objection, which means the witness will be allowed to answer the question. If I do not allow the witness to answer, you shouldn't try to speculate on why or what the witness might have said. It's a legal determination that I've made that it's not proper for you to hear. Likewise, don't hold it against the attorneys for making objections. They're both doing what they believe is appropriate in the circumstances. Also, during the trial, it might be necessary to confer with them outside of your presence. You saw a little bit of that yesterday when they come up here, conversations that you don't hear, but we are electronically enhanced. So if you are picking up our conversation, just let one of the bailiffs, will always be a bailiff sitting right there next to you, let them know so that we can adjust our volume here. I did tell you that you are able to take notes if you want to. For your convenience, I think by your chairs, we have some sort of plastic container with a notebook and writing utensil. Do they have? Yes. See them looking around. All right. Good. So a couple of things about note taking. One, you're not required to take notes, so don't feel like you have to if you do not want to. Secondly, please don't become so consumed with taking notes that you forget to listen to the next question and answer that's coming along. Sometimes when we're furiously writing, we kind of tune out to what's happening, so please be on the lookout for that. Additionally, rest assured that they're for your use and your use alone. As you see, we have them labeled with your juror numbers. When you're not using them, the bailiffs keep them locked up. I'm actually required by law to shred them at the conclusion of the trial, so no one reads them. They don't become a part of this court record or anything like this. Additionally, if one of you is a way better note taker than everyone else, that does not mean he or she becomes the official court reporter once you get into the jury room to deliberate. Sometimes people write things down wrong or not accurately. So if your memory differs from the written notes of someone else, I'm going to ask you to rely on your own memory. That's why you've been individually chosen as jurors in the first place. Just another procedural tidbit. If you do happen to miss a question or an answer, or a witness is mumbling or speaking too low and you can't hear something that's said, please feel free to raise your hand or just shout out, please repeat that. Because I've told you that you can't talk to each other about what's happening here in the courtroom. So in ordinary times, we would turn to our friend and say, hey, did she say black or white? And since I've told you you can't do that, it's important that you get it the first time around. So please don't feel inhibited at all. It happens all the time. We'd rather have you interrupt us and make sure that you get the question or the answer the first time around. So please don't feel bad about doing that at all. You're not interrupting or us at all. Additionally, some jurors ask if they can ask questions during the course of a trial. The answer is no. In a criminal case, the state's required to prove this case beyond a reasonable doubt, and having jurors ask is akin to helping them out in that regard. And so it's not really proper for jurors to ask questions during a criminal. We'll have it started.
Fucking faggot.
Whoa.
That's the words of the defendant in this case.
Whoa.
Gerald Radford. You're going to hear that once his relationship, his friendship with the victim in this case, John Walter Lay, deteriorated, every time he saw the victim coming to the dog park they both frequent, that fucking faggot. You will hear Gerald Radford on a recorded phone call talking about a time that he interacted with the victim to his face and said, I told him to his face, there's gay people and there's fags. Gay people live their lives. About the statements that Gerald Radford said. You're going to hear multiple statements that Gerald Radford gave. And you're going to hear things like Gerald Radford would say things like, I want to punch him right in the face, talking about the victim. You'll hear him talk about, he told the victim, I'll break your fucking jaw. You'll hear that the defendant said, I want to fucking kill him. And the day before, 24 hours before John Walter Lay is killed, the defendant is yelling at him, "You're going to die. You're going to die." Those are the words of the defendant. Ladies and gentlemen, you may be asking yourself, how does it ever get to that? And so we'll rewind time a little bit as we talk about what happened in this case and what the evidence will show you, largely from the mouth of the defendant himself, but also from a variety of people who also frequented this dog park, is that there was a group of people. They went to this place called West Dog Park. It's a big dog park. It's a nice place. It's in a community. It's over by Lakeville High School. And they all come in the morning and they hang out and they walk their dogs. And it was like a little group of people that hang out. Daryl Radford, the victim, were two of those people. And for a time, they were friendly. All these people hung out. They had a good time. But you will discover that there became a change in the interaction between the defendant and the victim. You will hear about how they started to have disagreements that were largely centered around matters of politics. It's 2020, it's 2021, it's 2022. We're all living through COVID and mask mandates and vaccines and a whole lot of hot button issues that at the time everybody was real fired up about. And so you will hear that as these two men are having different views on these topics and other topics, you will learn that the defendant becomes the aggressive, hostile one. He's the guy saying fucking faggot. And you will hear from people at the park who will say the victim never got angry, never got hostile, never got aggressive. Eventually, he kind of hit the boiling point and he was like, we can't keep doing this. Like, I can't endure this forever. But Mr. Radford persisted. And you will hear from people who were there, who told Mr. Radford to his face, you can't talk to people like that. It's 2024. You can't run around calling people fucking faggots. And still he persisted. He increased the aggression. He increased the hostility. You will hear how people saw him going up to the victim and blocking his path as if to provoke a fight. And you will hear how Mr. Radford was always very clever to say, but I'm not going to be the guy who starts the fight with the gay guy. So we're going to fast forward eventually to February 2nd, 2024. That's the day that this murder is alleged to have occurred. It's early in the morning. His dog, he goes to the park, he walks around, and as it turns out, that same morning, as so often happens, Mr. Lay shows up with his dog, and he actually has another dog that he's dog sitting, and he comes to the park. Right off the bat, Mr. Radford is going to say, the victim was saying something to me, I don't even know what he said, and I started telling him, why don't you get out of here? I was here first. This is my park. You should go. Nobody likes you. And of course, an argument starts. And that's where the heart of this case is going to come up. Because in this case, the defendant is going to claim self-defense. Gerald Radford shot and killed John Walter Lay. Mr. Lay was not armed with a knife or a baseball bat or a gun or anything remotely resembling a deadly weapon. And he shot him. And you're going to have to decide whether or not he did that legally. And at the end of the trial, the judge will explain to you what the self-defense laws are. And I expect you will hear something like, the defendant must have reasonably believed that he was either going to die or suffer great bodily harm. And there will be pictures, plenty of pictures of the defendant. He'll have a few cuts and scrapes on his face, no broken bones, no shattered teeth, no fractured nose, no broken arms. You'll have to decide whether or not he reasonably believed that he needed to shoot John Walter Lay to prevent death or great bodily harm. But I will submit to you that Mr. Radford's claim of self-defense will fail because it will be clear to you from all of the history, from both the words of the people who shared the dog park, but even from the defendant himself, that the person who was the aggressor, the person who most reasonably would have started the entire fight, was a defendant. And you will hear that if the defendant is the aggressor, if he's the guy committing a crime, then he would have had a duty to retreat. He can't pull a gun. He's got to try and get away. Because you can't start a fight and then be upset that you get your butt kicked in a fight and say, I'm going to shoot somebody. Now, the state of Florida's burden is going to be murder in the second degree. And there are a few elements. There are the things that sort of make up the concept of murder in the second degree. The first one is the victim must be dead. That's an easy one. I'm going to show you autopsy photos of John Walter Lay. I'm going to show you the spot in his chest where he has the gunshot wound that killed him. And I'm going to show you an array of injuries that he suffered to his head and body in the course of the fight. We'll have a doctor come tell you about the autopsy. He's dead. It's even so much an easy thing to do. The defense has actually stipulated, you will see the stipulation that John Walter Lay is dead. That one's easy. The defendant caused the death. That's the second element. Well, the defendant is telling you that he caused the death. That's what self-defense is. I did it, but ... I was allowed to.
Like that.
And so I submit to you that when you decide the defendant did not act in self-defense, you will ultimately conclude that the defendant caused the death because that's the only obvious answer. And so what will be left is what is in the heart and the mind of Gerald Radford at the time of the killing. You will hear this phrase about an act imminently dangerous, evidencing a depraved mind. That's a long sentence of words that you'll get. And there will be a definition. And what you will hear are the words ill will, hatred, spite, or an evil intent. And I submit to you now, and I will argue to you at the end of this trial, that the person with hate in their heart is that man, Gerald Radford. He's the aggressor. He's the hostile one. He's the disrespectful one. He's the words of hate. Now, I told you you're going to hear a lot of interviews in this case, and I want to explain to you how the case is going to unfold so you understand what's coming. The case basically starts with a 911 call. You will eventually get a 911 call, and that triggers the response of members of the Hillsborough County Sheriff's Office. The first witness you're going to hear very shortly.
Okay, Flash, my sweetie, I know you still support me. I was just teasing you yesterday, but I'm glad you showed up. Okay, have a safe trip. Have fun. I'll see you when you get back.
Is Deputy Craig Hoffman. He's one of the first responding deputies to the scene. He arrives at the dog park. He's one of the first people to have any interaction with the defendant. You'll be able to see the defendant as he's originally found. And then pretty quickly, you will see Deputy Hoffman attempt to go render aid to Mr. Lay, who's laying on the ground dying. Mr. Lay's dog, confused in the moment, is barking at the deputy, trying to defend his owner, not understanding what's happening. You'll watch that interaction. And then eventually you will watch two deputies try and provide life-saving efforts to Mr. Lay before they just say he's not breathing. We're not going to make you watch the entirety of it, but you will watch those moments where deputies try to save Mr. Lay's life. And as you do, I want you to pay careful attention to where Mr. Lay is laying on the ground, because you're going to discover that there's actually a spot where Mr. Lay is laying, and then there's another spot where there's some items, some mugs and sunglasses and things. And that's going to become important, the distinction of those two locations, the distance between them. So you're going to hear about that. Once the scene is initially some sort of stability is established, detectives are called in. You're going to hear from Detective Kelsey Nix. Detective Nix is what's called the scene detective. She's going to come and talk with you about all the things that are discovered at the scene. You're going to see the cell phone that Gerald Radford had in his hand. You're going to see a speaker that he was wearing on his belt. And I want you to listen carefully to the 911 call and see if you hear music on the 911 call. And I also want you to listen carefully to the video from Deputy Hoffman when he first responds and see if music is playing. Because what I think you're going to see is you're going to see that Mr. Radford was not concussed. He was not frantic. He was not panicked. He was not responding to some emotional trauma. He actually had bothered to turn music back on while he was waiting for the police to show up. But it wasn't on while the 911 call was going. So she'll talk to you about those things. You'll see the gun. Mr. Radford did call 911. That's the 911 call you're going to hear. He had taken his gun, he had put it on the table, he had unloaded it, he had waited for the police. And so you'll see those items and talk about that. Then we'll talk about that other area that I talked about. You're gonna see in the dog park, there's like a water trough area for like dogs to drink water when they're at the park. And right near there, there's a series of items. You're gonna discover there's a bright blue, like mug, like one of those things you screw the top on to keep your coffee warm, like a thermos sort of thing. That's the victim's mug. You're gonna see a darker blue thermos mug. That's the defendant's mug. You're gonna see that the handle is broken off of the defendant's mug. And you're also gonna see a pair of sunglasses, which the defendant ultimately identifies as his, laying on the ground. And as you watch the video and you look at the pictures, I really want you to pay attention to the ground. And I want you to ask yourself what you can see in those pictures and what you know of just what the sand and dirt is like anywhere in the state of Florida, but especially in Hillsborough County. Because what you're going to see is on the sunglasses, they have dirt all over them. But the mug doesn't. The gun doesn't. The cell phone, the speakers don't. You're going to see pictures of Mr. Radford. You'll see the injuries. I'm not going to suggest he didn't suffer any injuries. He's got some little cuts and scrapes to his bridge of his nose and above his eye and under his cheek and a little thing over here near his collarbone. You're going to see those things, but you're going to see that Gerald Radford doesn't have a speck of dirt anywhere on him. You will hear Gerald Radford, when he's interviewed by law enforcement, tell the police, tell the sheriff's office, I got a mouthful of dirt while we were rolling around on the ground fighting. He doesn't have a speck of dirt on his face anywhere. You'll see his jeans. There's no dirt there. Not from rolling on the ground, struggling. Because what Gerald Radford is going to say is he's going to say that basically Mr. Lay, the guy who had never been the aggressor, who had never been hostile, today was the day that he decided to attack Mr. Radford, to ambush him, to hit him in the face with his mug, knock him to the ground, and that two grown men rolled around on the ground. And while Mr. Radford was pinned on the ground, he was able to draw the concealed firearm he was carrying on his right hip with his right hand. And what he will tell police is that when he initially draws that gun, he does the most instinctual thing. He immediately points it at the victim and he shoots him. And since he's right-handed, shooting at somebody who's facing him, he would shoot him on the left side. You will watch Gerald Radford literally demonstrate to the police, I shot him over here. Problem for Gerald Radford is the gunshot's over here. It's not in a position that makes any sense. And I will go to great lengths when the medical examiner is on to explain to you how medical examiners can literally open a human body and follow the path of a bullet through a body. So the medical examiner can tell you not only that the bullet goes here and comes to rest down here, but that angle is downward, meaning that gun is up here, pointing downward. It's not here, pointing at the left side of the victim, as Mr. Radford initially tells the police. And that's what you're going to discover. What you're going to discover is that Gerald Radford gives multiple statements. He makes a 911 call. He gives an initial hour-long interview with police. He goes back to the scene with them. He does a walkthrough. It's on video. You'll get to watch it. A week later, they interview him again. A month later, they interview him again. And in every instance, there starts being new facts and changes to the facts that he's told. Gerald Radford will tell you that he was concussed and was so out of it that in the moment, he didn't remember all the facts. But as time went by, more facts came along. But listen to the facts that come along as the interviews and the moments progress. Because what you'll discover is that we'll get multiple interviews into this before Gerald Radford ever says anything like, oh, the victim had his finger on the trigger. The victim was trying to pull the trigger to shoot me. You won't hear that in the first initial interviews. Mr. Radford will very clearly demonstrate, I drew the gun with my right hand, I immediately pointed it up, and I fired. And somehow later, that will transform into the victim got his hands on the gun, both hands on the gun, and we were fighting over the gun, and now he's got his finger on the trigger, and he's trying to turn the gun towards me, and I somehow magically can disengage the safety and shoot him before he can do anything. So you will have to pay careful attention to what is said and when it is said and how the details change as the case progresses. But there are also going to be some things that are just glaringly obvious to you. In the first interview with Mr. Radford, sitting down with detectives, the longest interview he gives, he says the following: I never did anything to him. I never insulted him. I talked to him and treated him with respect, just like everybody else. That's the same Gerald Radford who will admit he called the victim a fucking faggot to his face. I swear to God, I never did a damn thing to that guy, and I don't know why he started on me. Well, you will discover that not so long ago, in a separate proceeding, Mr. Radford gave some testimony. And finally, about 2 months ago, Gerald Radford told us what this fight was really all about. You see, Gerald Radford and John Walter Lay were friends. Mr. Lay is a gay man. One day, Mr. Lay made the mistake of asking the defendant out for a beer on a date.
Oh.
And you will hear Mr. Radford say that. In fact, when we read the transcript, you will hear Mr. Radford first say, well, I was told I wasn't supposed to volunteer information. And I say, no, please, tell us whatever. And he admits that that's what the real dispute was. It wasn't about politics. It wasn't about COVID, mask mandates, vaccines. I'm sure those things happen too. But you will hear Joe Radford tell you that what really dissolved their friendship, what really set us down the path of fucking faggot, I'll break your jaw, I want to kill him, you're going to die?
Oh, gee.
Is that a gay man asked him out?
You say no, thank you. I'm not interested.
Gerald Radford also said, no, I don't think I ever threatened him. And at the back end of this trial, I will bring up a half dozen people who were all at that park, and they will tell you that in the days and the weeks leading up to this shooting, Gerald Radford was getting out of control. They will tell you that they were trying to intervene. They will tell you that they saw him aggressively approaching the victim, and they were worried that something was going to happen, and they were trying to talk reason to him, and it just wasn't having it. Ultimately, as I said, you will have to make a decision about whether or not the defendant acted in self-defense. And I submit to you that, ladies and gentlemen, self-defense is rooted in fear. You must be afraid you are going to die. You must be afraid someone is going to cause great bodily harm to you, not cuts and scratches on your face. And so you will literally hear it from the horse's mouth. When Gerald Radford is asked, during this incident, were you in fear? His response is, what's fear? I didn't want to get my ass kicked. Yeah, I thought he was going to kick my ass. And still, the detectives take a second try at asking him, during this altercation, at any point were you in fear for your life? Well, after I got blood on my face, I was kind of scared. Yeah. You're going to hear Gerald Radford unprompted basically say the following: I should have just let him kick my ass and be done with it.
You think?
I just needed him to stop beating me up. That's what I needed. When asked, Gerald Radford is not going to be on video saying, I thought I was going to die. Oh, he'll get to that later. He'll keep changing the facts. But in the first initial statements, he won't say, I thought I was going to die. He won't say, I thought he was going to kill me. He won't even say, I thought he was going to break my nose or pound my face in or, whatever. And so when this trial proceeds, I ask that you start and always think about what is the ultimate question that I submit to you will be at the end of this case. What was in the mind of Gerald Radford when he pulled the trigger and shot John Walter Lay? Was it fear? Was it the fear of death or great bodily harm? Or was it hate? And I submit to you at the end of this trial, you will find the defendant guilty as charged because you will decide everything tells you he had hate in his heart. Thank you.
Thank you. Would the defense like to make an opening statement at this time?
Yes,
All right.
May it please the court, morning court staff, counsel. Good morning, ladies and gentlemen. There are two sides to every story. And I know that that sounds cliche, but it's true. And what the state just told you is a story. It's their theory of what happened. And so now, using that same evidence, I'm going to tell you the story. And I'm going to tell you Mr. Radford's story. Because in this story, there are two men and two sides. Everyone, this is Gerald Declan Radford. He is the man that sits before you, presumed innocent. He goes by Deck. People call him Deck. That's his nickname. And Deck, he was born in Ireland and spent most of his life being raised in New Jersey before settling down here in Florida with his wife. And he's been down here now for about 13 years. He has 3 sons, and of course he has his 4-legged babies. Mr. Radford is a veteran. He's an ex-Marine. And like many ex-military, he carries a firearm for protection. This is Florida. This is not unusual. So as you see, he's just a common man doing common things, going to the dog park every day, living a very common, quiet life. And that all came crashing down on February 2nd, 2024. It is a tragic day that has impacted the lives of 2 men forever. And the 2 men involved, Mr. Diaz is right, they were friendly, they were cordial, most importantly, they were peaceful. But unfortunately, as we stand here today, Mr. Lay, the other man in the story, he's no longer with us. But as you know, this story starts way before February 2nd, 2024. Both Deck, as he goes by, and Walt, Mr. Lade goes by Walt, were longtime regulars at this West Tampa dog park, nearly daily, same time in the morning. And there was a group of people there that were all friendly and got along and talked. And they became known as the morning crew. But you'll hear that around the time when COVID was becoming our life, that a rift began between Deck and Walt. And I'm sure you can remember in your memories very keenly what life became like during COVID and how polarizing it became. COVID was politicized. And many people, maybe even your loved ones and friends, you didn't see eye to eye on. And that's where this started. Okay, it's not about a date. It's about varying a misalignment of ideology. And unfortunately, the people at the dog park, the morning crew, they, just like the rest of society, kind of fell victim to this cleavage of ideology, and they began to splinter. And as they did so, the group kind of split down ideological lines, quote unquote, liberals and conservatives, right? And they would no longer sit together, stand together and talk, commingle. That had kind of ended. Now, my client, Deck, not shy about his views. Not going to pretend that he is. And some people may call these views harsh or extreme. Maybe you don't share them, maybe I don't share them, but they're not uncommon views. And when he expresses these views, yeah, he uses horrible language, horrible, vulgar language, language that you and I probably today would not use. But Deck, he's from another time. Jersey, he's a Yankee. He's from a different place. Okay, he grew up in the 60s and 70s. And that's a time when using a word like faggot was commonplace. It was like calling somebody ugly. It was just an insult. When I was a kid, and I'm dating myself now, but we tossed around the word gay a lot. And that had no implication of homosexuality. It was just a word. These are words, just insults. It is not, I implore you, indicative of a person who hates an entire subsection of our culture, let alone drive you to murder. And we concede that the state's going to parade many people before you. And it's going to be ad nauseum. You're going to hear the same thing over and over again. He uses this language. We know that. His views are harsh. We know that. He's aggressive. He's in your face. We know that. Well, Depp himself will tell you, I'm an asshole. I can be an asshole. So from the time of COVID on, this animosity begins to grow because Walt and Deck definitely do not see eye to eye. And Walt does not like the use of the slurs. But what you won't hear is at any point it becoming physical. Over those years, despite what was said, the horrible things that might have been said, it was never physical. So despite the bickering, and you can't tell me there wasn't bickering back and forth, despite that, Walt and Depp never got physical. Well, obviously that changed. That changed on February 2nd. And what started as a normal morning for these two men, taking their dogs to the dog park like they do every day for years, will turn deadly. And that morning, at that time, there was only two people in that park, Deck and Walt. So there are no eyewitnesses. And there's no surveillance, and that's large in part due to a failure in the police investigation. So there's nobody that can tell us what happened that day except for Mr. Radford. So you are going to be forced to either rely on the state's version of events or the events as they occurred by somebody who was actually there. And we believe that the evidence you're going to see supports the fact that an altercation was started by Walter and Declan was forced to defend himself. According to Deck, he was the first one at the park. And Deck, at this time, had sadly just lost one of his dogs. And these dogs are like children to Deck, okay? And he was really struggling. And he was especially melancholy. And he was even more alienated from this group of mourning folks that got together because of the tragedy of losing his dog. He wasn't interacting with anybody. He was keeping to himself. And obviously, at some point there soon after, Walt arrived at the park with his two dogs. And now, it's going to be important to look at when you see the evidence and you see the pictures of the dog park, that when you pull up to the dog park in your car, not only can you see the parking lot and who's there and see whose car is there, but you can see the whole park. And so it would have been plainly obvious to Walt that not only was Declan in the park, but it was just going to be the two of them. Now, unfortunately, Walt's not here to tell us what caused the next decisions that he made or what he was doing. But we believe that he was fed up with the bullcrap at the dog park. He was fed up with it. Tired of the arguing. Tired of it. And when he sees Deck there, he makes a beeline for him. And Deck is over by those washing tubs that Mr. Diaz talked about. And coming at him, Walt could have made the decision to walk around this platform and go to the other side. But instead, he walks around to the same side that Declan's on. And as he does this, he says to him, "Why do you come here? We fucking hate you here." Deck says some time passes, and before he knows it, whack, he's hit in the face with some object. And Deck was knocked to the ground, and the next thing you know, Walter is over the top of him. And he is using part of his body to pin down Declan's left leg. Well, we surmise that it was in that fall, in that initial scuffle, that Declan, when falling to the ground, dropped and broke his mug. So once they're down on the ground, Walt began to what Dex referred to as hammer fist him. So hit it, striking him like this. Now remember, he's over the top of him. He's not punching him directly. He's beating down on him like this, over and over and over again. And this is consistent, by the way, with the evidence you're going to see, including bruising to the outer part of Walt's hands and lots of it, covering what you wind up seeing are pretty deep abrasions on the knees of Walt, which tells us he was on his knees over Declan. So now you have this larger man, taller man, 13 years his junior, over the top of him, beating him, raining down these fists. And he does sustain multiple injuries to his face. And the face is covered in blood. At this time, he is completely helpless. He is overpowered, and he is being hit over and over. And you'll see the pictures of his injury, and you'll see the blood, and you'll see it's nothing short of a vicious attack. And this goes on for, Dex seems to think, and sometimes it's hard to gauge time when things like this are happening, but he believes about 15 to 20 more seconds of this, and there's no sign of it stopping. And of course he feared for his life in that moment. He is completely powerless against this man. And that left him with no choice but to try to retrieve his firearm that he carried for personal. And Deck is able to manipulate and move over and get that firearm. And he brings that firearm and gets that 9mm up to the side of about the mid-torso of Walt. And that's when they begin to struggle over this gun. They both have their hands on the gun. And it's twisting. And it's moving. And it's up. And it's down. And then there's a loud bang, a bright light, and Declan has shot Walt. Now, there's a few things I want to point out about the struggle that took place, the evidence I want you to pay attention to. One, you're going to see that there's mixed DNA on the gun. 2 people touched that gun. There is DNA from 2 people on that gun, telling you 2 people had to have touched it. Walter's injuries are consistent. The bruising in the knees of him being over top of Walter. And you will see pictures of Deck afterwards. And you will, if you look close enough, I did, that's my job, you will see debris at the bottom of his pants. But also what they failed to tell you is they took those pictures after he changed his clothes. He was wearing something completely different when law enforcement showed up. And the sweatshirt that he was in was taken not for evidence, not to be preserved. It was tossed in the back of a police cruiser. Declan doesn't have any injuries to his hands. They're clean. And as far as the trajectory of this bullet, we believe it is consistent with being shot from being over the top of somebody. Now, I predict that Mr. Diaz is going to get up with the medical examiner and they're going to grab a skeleton and they're going to move the gun all around and they're going to try, well, it could have come from this way, it could have come from that way. And, you know, it's pointed down, which doesn't make a lot of sense because Declan is shorter than Walter Clay. And he's a former Marine. Why would he shoot from up above and down? We posit that in the course of this struggle, when that gun comes up to the pectoral muscle of Walter, his back is at this angle. And so if I'm shot and the bullet goes through, it's going to go through this way, not this way. That's consistent with being over the top of somebody. And it was a chaotic scene. There's phones everywhere, there's coffee mugs, there's a speaker, and the dogs are going nuts. So there's evidence that something violent took place. And Declan, he staunchly maintains this version of events. He was overpowered. He was helpless. He's 66 now, but 65 at the time. He is riddled with arthritis. He has bursitis. He has 2 knee replacements. He was no match for the younger, bigger, stronger Walter. And he did fear for his life in that moment. A reasonable person would fear for their life in that moment. And unfortunately, a decision was made that nobody should have to make. And realizing that Walt had been shot, what does Deck do? He doesn't run, he doesn't leave the park. Remember, there's nobody else around. He calls 911 immediately. And when you listen to the call, listen to the raw emotion, listen to the anguish, listen to the torture in his voice. The torture that is consistent with someone who was forced to take a life to protect their own. Not a hate-filled killer, not somebody who just walked in to the park and picked a fight and shot somebody. You wouldn't have that much of a visceral reaction to it. And when law enforcement arrives, they find Deck peaceful, hands up. He had made sure the gun was secure, set it far away, and just stood and waited for police. And at this time, this poor man is in complete and utter shock. He couldn't even remember his name when asked by police. He stumbled over it. They had to take his license out of his wallet. He is breaking out in these spontaneous bursts of, he's sobbing, he's hyperventilating. Everything about Declan's behavior is consistent with someone who was just traumatized by taking a life to protect his own. And if that behavior was not consistent, give that man an Oscar, because that was an Oscar-worthy performance. Now, by this time, an investigation has commenced, and I use the term investigation loosely. Deck, he is taken by detectives down to the station to do an interview. And Deck gives several interviews with the police. He is always cooperative. He is always remorseful. And he is always forthcoming. Are there variances in his accounts? Yes, there are. But as you can imagine, as anybody can understand, that as that shock of the day's events, especially immediately preceding, and that adrenaline leaves your body and your mind can visualize and time passes, of course you're going to start remembering what happened once that shock is worn off. Additionally, Mr. Radford began therapy that helped him to process the things that had happened. And really, the story changes per se. He just provides law enforcement with additional information. He's not walking anything back. He's adding to it. And those are two very, very different things. Now, after his second interview with law enforcement, Mr. Radford, Declan, is provided the contact information for a victim's advocate. Now ask yourself, how many suspects are provided with a victim advocate? Why would law enforcement down the road give victim advocate information if the preceding investigation did not lead them to believe that he was a victim and that this case was self-defense? After this second interview, which was days after the incident, they didn't arrest Declan. In fact, on February 12th, law enforcement met with members of the state attorney's office. They didn't arrest Declan after that. Additionally, on February 14th, law enforcement says in their report they met with the FBI. Didn't arrest Declan after meeting with the FBI. And that is where this investigation should have stopped. Law enforcement knew this was self-defense. But law enforcement, they're spurred on, compelled by a barrage of angry emails from the witnesses that the state is going to put up there, and by political motivations, not new evidence. The evidence in the story remained the same. The only thing that changed from the beginning of February to March 8th, 40 days later, when they arrested Declan, was the public interest in this case, not evidence. Insofar as the video that the state is so heavily going to rely on, law enforcement had that video in the very beginning of the investigation, I would say within the first week. This video that allegedly Walt's life, he had said Deck had threatened his life. Law enforcement had that video. And even that video was not significant enough to change their minds and make them arrest Declan. And I want to talk about this video because the state's going to rely on it so much. If Walt's life had been threatened, would he have gone back to the dog park at the same time as Declan, and he knows Declan will be there, and furthermore go in knowing you're alone in there with him? Wouldn't he call law enforcement? He doesn't. In fact, 2 years leading up to this incident, Walt never contacts law enforcement about anything that happened at the dog park. But instead, Walt decides the very next day he's going to go back to the dog park at the same time that Declan has been going to that park much longer than him, almost 10 years. So you can't tell me that there was an antagonism going back and forth. And I don't truly believe that the threat was real. And I certainly don't believe that Walt felt truly threatened. In fact, we know that Walt wasn't threatened by Deck because he says in his own words, in text messages, I'm going to quote Walter, he, meaning Declan, doesn't really intimidate me. Quote, he, meaning Declan, is weak and feeble. Quote, if he, meaning Declan, blocks my path again, I'm going to try and tackle him. Isn't it interesting that that is exactly what happened? But regardless of why Walt decided to go to the park that day, despite his life being threatened and him being in such odds and fear of Declan, he goes back. We may never know the reasons. But what we need to focus on is the tragic loss of life. That's what we're here to talk about. And I want you to ask yourself, if an innocent man who was forced to defend himself is being railroaded by the state attorney's office and by law enforcement who folded to public pressure to charge Declan and make this a hate crime. And whew, tell you, that is some leap that the state is asking you to make. To believe that just because somebody uses homophobic slurs, that they have hatred in their heart so much that they're going to go out and kill somebody, going to go out and target that person. Well, if everybody who had disdain and used foul language, if logic follows, were murderers, we'd have a lot of murderers out there. Everybody's got a weird uncle they invite to Thanksgiving, and you never know what's going to fall out of their mouth. This is almost ludicrous, but it's the story. That's the story that the state wants you to believe. That despite there never being any violence between them, that Declan killed Walter that day purely because he was gay. And remember, what we say.
What was that? Was that an objection? Or was that a time limit thing? Because somebody said something and she turned her head and I didn't hear what was said. And I agree with you just because, but you also can't know what somebody has in their head.
What the lawyers say, it's not evidence. This is not murder because Mr. Diaz just got up and told you it. This is not a hate crime because the state says it is. Make the state work for it.
Oh my God.
Their burden is so incredibly high, so difficult to overcome. And as Declan sits before you, he is presumed an innocent man. Do not forget that. They have to prove their story, their version of events, beyond and to the exclusion of all reasonable doubt. Evidence just doesn't support it. The evidence does not lead you safely to guilty. It just doesn't. And when you deliberate, you're going to get a lot of instructions. And one of those instructions says, that if your opinion vacillates, if you waver, that, members of the jury, is reasonable doubt. Ladies and gentlemen, there are two sides to every story. And if at the end of this trial and at the end of this evidence, you do not know the truth about what happened that dreadful morning at the West Tampa Dog Park, if you do not know the truth, you must find Mr. Radford not guilty. Thank you.
All right.
Judy says there's movement in the courtroom. So let me find. Where did it go? Yeah, now I can't find it. Yay.
I don't think we provide transcripts because it's required to be done in open court. All I can
All right, StreamYard. I think this is just a question because I heard him say something about transcripts.
do is permit a readback or a playback, but I don't think there's a recording. So is that correct, Madam Court Reporter? No playback? All right. So the bar has recommended certain instructions in this instance. First, the standard instruction directs or suggests they be told that transcripts are not available, but that they may have testimony read back to them. And then I can combine that with the instruction that talks about how long it's going to take the court reporter to prepare it for readback, and then tell them to discuss their request further. And if they're not able to resolve their question about the requested testimony by relying on their collective memory, they should write down as specific as a description as possible of the part of the witness's testimony they want to hear. So I can do that, or I can say no, just flat out no. So Mr. Levine.
Was it?
I'm fine with either one, Your Honor.
Judge, if I could have a moment.
All right. Hate to say no because there's obviously something they cannot collectively remember, but
Judge,
you have the look of you want me to say no on your face.
I do. I should not play poker with you.
Not very good at it.
If I
Dang it.
hear that because I was in that. At any rate, a read back done, and if they can narrow down their request further, that would be helpful. So basically, baby steps. Start with no transcripts are available. Please rely on your collective memory.
Mr. Levine?
Could you please read their question one more time?
We are requesting, I think that says court. We are requesting court transcript from Susan Detman's neighbors, Sally Bell and Nancy Jones.
Kidnapping. They're hung up on kidnapping.
I'm fine with the court doing whatever he feels appropriate under the circumstances.
Is there some prejudice to taking 2 baby steps first and saying transcripts are not available? A read back may be possible, but we will need you to be more specific regarding your request or the portions.
How about 2.5 baby steps then? If you're not willing to tell them just no transcripts are available, please rely on your collective memories. Then add the step of a read back may be possible if you can narrow your request further, so that they don't come back and say we want all testimony of both witnesses read, because that I think is a problem, because then we could get into having a read back.
All right, so let me call together these instructions. How long? Well,
30 minutes.
okay. Whether they, no matter what they want.
They were short, right?
Yes, they were
They
fairly
weren't
short.
the longest witnesses in the world, but they also weren't the shortest. Out loud, and as I'm writing it down, I'm thinking though, if we ask them to narrow their request, then that might risk the possibility of highlighting a certain piece of testimony over any other piece of testimony. So I go back to my original request of just saying that no transcripts are available.
Mr. Levine?
If we're going to say there are transcripts available, I think it should be included a read back may be possible.
I'm thinking, it's like I said, it obviously would be helpful to know if there's a particular area that they are asking for
The instruction suggests that I can be somewhat generous in my response, but ask them to be specific as they can. So I intend to advise them transcripts are not available, to discuss their request. If they can't resolve it with their collective memory, then they may request to have testimony read back to them, and that if they decide such a request, it should be as specific as possible.
That's acceptable to the state.
And how will be instructed. So let me just here.
Yeah, I think they're stuck on the kidnapping too.
All right. So my intention is to advise the members of the jury you have asked that transcripts of testimony be provided for you.
I don't know how I do it. But I get my windows separated. Grab the crazy and I can't find it.
Members of the jury, you have asked that transcripts of certain testimony be provided for you. Transcripts are not available. However, a readback of testimony may be granted in the court's discretion. I'm going to instruct you to return to the jury room and discuss your request further. If you are not able to resolve your question about the requested testimony by relying on your collective memory, then you may request to have testimony read back to you. Again, that would be granted in my discretion, if at all. Now, if you decide to make such a request, it should be as specific as possible. You may now continue with your deliberations.
All rise, please.
Okay. So now we're gonna, well, I thought we were gonna jump back to our other trial, but I've lost that one now. Dang it.
I will also tell you, I don't know who told Mr. Hertel, but the jury verbally told him they want to end at 4:30 today. I did not ask him to have them put that in writing because they might change their mind. They know to tell him they want to go home for the evening. So I just left it at that. Any objection to that, Mr. Levine?
No, here.
Yes.
Don't go far.
All right.
Raise your right hand, please. Do you solemnly swear or affirm that testimony that you're about to give in this cause will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you, sir. Step this way.
Good morning. If you would please introduce yourself and spell your name for us.
Deputy Craig Hoffman. Last name is Hoffman.
Thank you, Your Honor. Good morning, Deputy Hoffman. Where are you employed?
Hillsborough County Sheriff's Office.
Now, how long have you been employed with Hillsborough County Sheriff's Office?
16 years.
Okay. And what is your current position at Hillsborough County Sheriff's
I'm on
Office?
a behavioral health squad. I deal with homeless issues.
Now, was that the same position you had on February 2nd, 2024?
Yes.
Okay. Now, were you called to a scene on February 2nd, 2024?
I wasn't called, but I self-dispatched myself, talking on the radio.
Okay.
So I went through, I wasn't too far.
Where were you called to?
Occident Road, the dog park.
Is that in Hillsborough County?
It is.
Okay. So what did you do when you arrived on scene?
I saw the defendant with his hands up. Me and Deputy Lowe went and secured him, put him in handcuffs.
Now, this defendant, did you find out who this man was? Were you able to identify him?
Yes.
And what was his name?
Gerald Radford.
Is this man in the room with us today?
Yes, sir.
Can you point to him and identify an article of clothing?
The gentleman in the blue jacket.
Your Honor, may the record reflect that the witnesses identified the defendant?
Yes.
So why'd you place Mr. Radford in handcuffs?
Well, it was a shooting call. It was him and the decedent in the park. He had his hands up. So, and I believe there's some description on the radio, not 100% on that, but I was under the belief that he needed to be secured because a shooting just occurred. So we put him in handcuffs.
So after you secured him, what did you do?
I then I left him with Deputy Lowe, and I went to do CPR on the decedent.
Now, when you attempted to render aid, what happened?
There's dogs in the park, and I believe it was the decedent's dogs. He was barking at me, kind of aggressive, and I finally got over, and I started packing the wound.
Now, were you wearing body-worn camera footage like that?
I was.
Your Honor, state request to publish State Exhibit 1.
All right.
Judge, I apologize. I think it's the time for the redaction instruction.
All right, members of the jury, you're about to view this video recording, and I'll instruct you now that the recording has been edited to eliminate irrelevant portions that would not add to your understanding of the case. And the fact that it has been edited to take out long periods where nothing is shown, for example, or something like that, shouldn't affect your viewing of the evidence.
Now, did you hear music in the background when you were placing him in cuffs?
I don't recall that.
What you got on the table? Okay.
It's okay. It's okay, buddy. Come on, our daddy's going. Okay. Oh my God. Oh my God. Oh my God.
I don't know. I'm just trying to get him. I just want that dog there. Go, great relative. It's okay, buddy. It's okay, pal. Baby, Cody.
Yeah.
Wait, more breathing.
Lady, where did you learn to do CPR? You are not pushing hard enough.
Now, I believe you stated this, but when you were attempting to render aid, what did you notice about the victim?
Color of the skin, his chest wasn't moving, and he didn't have a pulse.
Now, what did you do after you were attempting to render aid to the victim?
After I rendered aid, then I just sat with Deputy Lowe as well. Mr. Red, who was detained.
A moment to confer, Your Honor.
Those poor dogs.
State passes the witness, Your Honor.
Right. Russ.
Morning, Deputy Hoffman, correct?
Yes, ma'am.
Fair to say you were probably the first person to encounter Mr. Radford?
That's the second person.
Okay.
Deputy Lowe was ahead of me.
Okay, but you all kind of arrived at the same time.
Pretty much.
And isn't it true that at some point during your interaction with my client, he told you, hey, there's a sign, I think there might be security video?
Objection here, Your Honor.
I don't.
Overruled.
I don't recall.
Isn't it true, Deputy Hoffman, that when you first encountered my client, he was in shock
Yes.
and he seemed confused?
Yes.
And he was exhibiting real emotions. You saw him crying
Yes.
and hyperventilating.
Yes.
He remained cooperative, didn't he?
Yes.
And he stayed in the park after this happened, correct?
He did.
And he called 911.
To my knowledge, he did.
And you saw noticeable injuries to his face.
Yes.
And was there a lot of blood?
I don't recall. I think there was a little bit of blood on his face. Not exactly. I forget how much blood it was.
At this time, defense would like to introduce and publish what's already been stipulated to as defenses 1.
All right.
Okay.
Do you recognize this, Deputy?
I do.
And is that the face of my client as you met him in the park that morning?
Yes.
And are these the clothes that he was wearing?
I believe so.
And is that blood down the front of his shirt?
I see it on the, yeah, some blood on the lettering there.
And you attended to Mr. Lay, correct?
Yeah, I called EMS.
Okay. And at that time that Mr. Lay was still on the ground, were you able to notice anything about his condition?
Say it one more time, please.
Were you able to notice anything about the condition of his body? Did you notice the dirt that was on his legs?
I know it was dirty. I don't remember where the dirt was.
At this time, we would like to introduce and publish what's been stipulated as defenses number 2.
All right.
Deputy Hoffman, is that what his legs looked like after?
I believe so.
And you mentioned that you had to put handcuffs on Mr. Radford.
Right.
Sir, did you do that because you were scared?
I had some fear. Shooting just occurred, so.
But you weren't afraid in that moment of Mr. Radford. It's protocol, right?
I wasn't, but yeah, a shooting just occurred, so I don't know what his mindset is.
So would you say that agree that it's a matter of protocol, and it wasn't because in that moment he was acting violent?
No, he was not. It's protocol.
And he was definitely not being arrested and taken into custody.
He's being detained as far as I understood at that time.
A moment to confirm, please, Your Honor.
Yes, ma'am.
Hoffman, I have no further questions for you. Thank you, sir.
Anything else from the state?
Now I'm gonna redirect you to what has been marked as Defense Exhibit 1. Now, let's see. Now the blood that is on his shirt, does that correlate with what the blood has been dripping off his nose when you observed him on scene?
I would assume so.
A moment to confer, Your Honor. No further questions from the state, Your Honor.
All right. You can step down, sir. Thank you. Is he released from his subpoena?
Yes, sir. Yes, sir.
All right. Call your next witness.
State will call the second witness, Your Honor. Yes, Kelsey Davis, who's now Kelsey Nix.
Raise your right hand, please. Do you solemnly swear or affirm that the testimony that you're about to give in this cause will be the truth, the whole truth, and nothing but the truth? I do. Thank you, ma'am.
Oh my God, he does. Does look like Rick.
Good morning.
Good morning, Your Honor.
If you would please introduce yourself and spell your name for us.
My name is Detective Kelsey Nix, N-I-C-K-S. At the time of the investigation, it was Davis.
Thank you.
Detective Nix, you answered my first question right off the bat, so I do appreciate that. Good morning. Where are you employed, Detective Nix?
I'm employed with the Hillsborough County Sheriff's Office,
Okay, how long have you been employed there?
approximately 9 years now.
Okay, and where are you currently assigned?
I'm assigned to the homicide section.
Now, was that the same position you had on February 2nd, 2024?
Yes, it was.
Okay. Now, were you called to a scene that day?
I was.
Okay. What were you called to?
I was contacted by my supervisor at the time, Sergeant Florio, and he advised that I was to respond to the shooting investigation.
Where was the shooting investigation?
West Park.
Okay. Is that in Hillsborough County?
It is.
Okay. So when you arrived on scene, what were you asked to do? What were your duties?
Upon arrival, I was tasked with overseeing the scene investigation.
Okay. Now, tasked with overseeing the scene investigation, what do you do in that task?
Typically, it's to document any evidence that may or may not be present at scene, and to kind of oversee photographs that are taken, look for any evidence that may or may not contribute to the investigation.
Okay, so what'd you start with first?
So typically, I arrive on scene, and first thing that I usually do is attend a briefing with other members of the homicide section.
Okay, and what'd you do from there?
From there, I spoke with Sergeant Florio as well as Deputy Barrios, who briefed me regarding the incident.
Okay, and then after that, what happened?
After that, a scene walkthrough was eventually conducted, and then I, along with CSI Mullaney, conducted the photographs of the incident scene and began to examine items of evidence.
Now, when you say that you observed the scene with crime scene investigator Winnie, so that means you took photos, looked at evidence that you observed on scene, and processed the scene with crime scene investigator Winnie. Is that correct?
I did not take any photographs, but yes.
You were with crime scene investigator Winnie who took the photos.
Correct.
Okay, so you observed all these photos taken.
Correct.
Okay. Now, after that, did you do anything else when you're on scene?
Prior to doing 911 phone call.
Okay. Go through the scene to look for anything in particular.
We were conducting general observations at first, and we eventually progressed to a narrower scope of items that we were looking for.
Now, were you trying to observe anything else, like shell cases or anything else when you are on scene?
Yes.
Okay, so what did you do to try to find those shell casings?
Initially, we began, prior to photographs being taken, we try not to disturb items as they are. We try to keep the crime scene as is until photographs are taken. Eventually, we do conduct a thorough line search of the area in an attempt to locate that casing.
Now, what is a line search?
It's typically various members of law enforcement, crime scene, deputies, detectives. We pace ourselves out at various increments, covering a designated area, and then we will begin to search in a linear pattern on either side, progressing through the designated area to be searched.
Now, besides the stuff you already observed and took in the photos that were already taken, did you find anything during that line search?
Yes.
What did you find?
I believe 45 caliber casings.
Now, but were those shell casings in any relation to the firearm that was found by the defendant? That was the defendant's firearm.
No, at the time we located those casings, the firearm we had already located that had been designated in this investigation was a 9mm.
Now, was a diagram created of the scene?
Yes, it was.
Okay. State would ask to publish State Exhibit 3, Your Honor. Okay, I'm gonna try to zoom this out to the best of my ability. Okay. Now, can you tell me what this right here at the top is? What am I looking at here?
Within West Dog Park, there
Yeah.
was a covered picnic table. It was like an open pavilion.
And now these yellow markers all over the diagram, are these the evidence markers that you've tagged on the scene with your crime scene investigator?
Yes, that's correct.
Okay. Now, what is these green shrubbery things that I'm seeing on the diagram?
Throughout the dog park, there were several large trees that provided quite a bit of shade throughout the park.
Okay. And what is this circle within a circle in a square that I'm looking at on the diagram?
Under one of the trees was an area kind of designated as a watering station for dogs. There were various large troughs that could be filled with water.
Okay. And is this the path of travel to come in or out near the pavilion?
Yes, those are they're a set of sidewalks that led into the park through a series of chain link gates and into the fenced enclosure.
Okay. And then up at the top left corner is these are the markers of the items that you discovered on scene.
That's correct.
Now, as we discussed, you said that multiple photos were taken of the scene. Is that correct?
Correct.
State would ask to publish State Exhibit 2, Your Honor?
Yes.
Thank you, Your Honor. I'm looking at State Exhibit 2A. Can you please tell me what that is?
That is the entrance to the dog park. We're going to delve into the larger dog park area. Is going to be on the right side gate, right, the one that's covered in crime scene tape.
Okay. Now, and then I'm showing you what has been marked as State Exhibit 2B. Can you please tell me what that is?
That is through the initial gate into a holding area. That is the second gate that leads into the large dog area of West Dog Park.
And then 2C, is this another entrance photo of the dog park?
Yes, it is.
And then 2D, is this another photo basically showing an expanded view of the dog park in question?
Yes.
Okay. Now, in 2E, is this the watering hole? I'm going to describe it as a watering hole or watering area for the animals that we just discussed in the diagram.
Yes, it is.
Okay. Now what's been marked as 2F. Is this the pavilion that we discussed that you said was on the diagram?
Yes.
Okay. So this is one of the walkways to enter to go to that pavilion.
Correct.
In 2G, is this just another photo regarding that pavilion that we discussed?
Yes, it is.
Now, in 2I, were there items, some of these items that you discovered on scene in this photo?
Yes.
What were some of those items that you discovered?
That orange item, kind of in the lower center portion of the photograph, was an orange Bose speaker, and that cell phone more to the right in the center of the photograph on the sidewalk was a cell phone.
Did you discover whose items those were?
I did not.
Okay, but they were, you later on, law enforcement discovered whose items those were.
Yes.
And whose items were they?
The defendants.
Is that
And
light
now
even on?
2I, is this the inside of the pavilion?
Yes, it is.
Now, what is inside the pavilion? A pavilion that's been marked off in this photo.
On the picnic table, on the lower right side of the photograph, we located what appeared to be a multicolored beanie hat, as well as a firearm and a casing, or sorry, a magazine for that firearm.
Now in 2L, is this with the crime scene ticket? Is this where you discovered where the shooting occurred?
From what was indicated, yes.
In 2K, there is a lot of remnants of what it seems. What are these remnants here that I'm pointing at next to the fire hydrant?
So those various kind of hoopers and wrappings were left over from medical attention that was provided to the decedent in this case. His kind of fire rescue had left those supplies there prior to law enforcement arrival.
Now, does that occur occasionally when fire rescue is attempting to render aid to a victim, that sometimes supplies are left when rendering aid?
Yes, it does.
Oh, yeah. They do not clean up after themselves.
2L, is this, now are these items over here that you soon discover other items of evidence that you found?
Yes, they are.
What items were those?
I believe that they were two thermos style cups.
In 2M, were these the thermos style cups that you just discussed?
Yes.
Now, was there another pair of sunglasses you also found on scene?
Yes.
And were those pair of sunglasses the defendants?
Yeah, identified episodes, yes.
State would ask to publish State Exhibits 4A through I, Your Honor.
All right.
Thank you, Your Honor. And I know we discussed this, but we're going to go into more detail. These photos regarding 4A, as we discussed before, these are with markers now. Are these the markers you left for the items you discussed previously?
Yes, those are the markers. Yes, I know in place.
Okay. And the markers that are placed, are these next to the phone and the speaker that you discovered?
Yes, that's correct.
Now, for B, is this a close-up of that speaker and phone?
Yes, it is.
Okay. And for C, is that the speaker again?
Yes, it is.
Did you notice anything out of the ordinary? Did you notice any sand or debris on that speaker when you found it?
Nothing that would appear out of the ordinary for it being on the ground.
And 4D, is that same speaker?
Yes, it is.
Now in 4E, as you discussed briefly, again, what is this?
That was the multicolored kind of beanie style hat that we located, as well as the firearm and the magazine.
And at this point, those had been marked as evidence, right?
Correct.
And 4F, is this just a close-up of the firearm and ammo that you discovered on scene with Mawini?
Yes, that's correct.
And 4G, is that the defendant's firearm that you discovered on scene with Mawini?
Yes.
And 4H, is it that same firearm just flipped over?
Yes.
And 4I, what am I looking at here?
That was the magazine that was located next to the firearm, as well as the rounds of ammunition that were previously loaded into that magazine.
And you didn't find any additional ammo on scene, is that right?
Correct.
State would ask to publish 7A through M, Your Honor. Thank you, Your Honor. Now, in State Exhibit 7A, now you started to mark this scene as we discussed before, and some of the items you began to mark were these, the thermoses and sunglasses that you discovered on scene with Mawini?
Yes.
Okay. Now, was this just a close-up photo in 7B of those thermoses and sunglasses that you observed near the watering hole?
Yes.
Now, in 7C, you observe these, you've marked the two thermoses. Now, what was marked in marked in evidence tag 6 here?
That appeared to be a piece of plastic that resembled, at the time, what could possibly have been a handle to one of the thermoses.
Was that potentially to the mug on number 5?
Correct.
Did you discover whose mug was whose?
Yes.
Was the defendant's mug number 5?
Correct.
And 7D, is that just another close-up with the handle and the mug of the defendant's mug?
Yes.
And 7E, is that another close-up with an evidence tag next to that mug?
Yes.
And 7F, what am I observing here?
That was the area of the mug that appeared to have something broken off of it, which drew our attention to that handle.
And 7G, is that the handle you're referring to?
Yes.
And 7H, is this just another photo of that handle from the defendant's mug?
Correct.
Now in 7I, what do you know, whose mug was this? Or did you discover whose mug was this?
I did not.
Okay. Did law enforcement discover whose mug this was?
I believe so.
And whose mug was this?
The victim.
And 7L, is that just another close-up of the victim's mug?
Yes.
Now 7K, what am I looking at here?
Those were a pair of sunglasses located at the incident scene.
And you stated those were the defendant's sunglasses?
Correct.
Okay. And 7 sunglasses?
Yes.
Now, when you had an opportunity to look at these sunglasses with Melanie, did you notice anything out of the ordinary regarding these sunglasses? And I mean out of the ordinary, do you see anything broken, fractured, cracked regarding these sunglasses?
No, the sunglasses appear to be pretty intact when we located them.
Just a little dirt on them.
Correct.
And I'm showing you 7M. Is this just another close-up of those sunglasses?
Yes.
Okay. Now, after you and Moeni processed the scene and processed for shell casings, anything else you did on the scene that day?
Not after the line search.
Okay. Mug to confer, Your Honor?
Yes.
Thank you, Your Honor. State will pass the witness, Your Honor.
Cross.
Good morning, Detective. How are you today?
Well, Counselor, good morning.
How long have you been a detective?
Just about 3.5 years now.
And how long has that been in total or in part in major crimes?
3.5 years.
So, and you're still in major crimes.
Correct.
And as a major crime detective, am I accurate in my understanding that you are tasked with investigating shootings, violent crimes, more serious offenses?
That's fair to say.
Homicides?
Correct.
Do you do sex crimes at all or no?
I previously worked in the special victims section. Yes.
Would it be fair of me to say that throughout your 3.5 years, you've probably interacted with members of the community, either suspects or alleged victims that have experienced some sort of trauma?
Yes.
Would it also be fair of me to say that in those interactions, there's no consistent way that anybody responds to trauma?
That's true.
Everybody reacts differently.
Yes.
Some people can remain stoic, right?
Yes.
Others can be, emotional wrecks, right?
At times, yes.
And everything in between.
Yes.
As part of being tasked by, I believe it was Sergeant Florio, to assist in this investigation, kind of in the hierarchy of lead detective, assistant, where did you fall?
I was assigned as the crime scene detective.
Okay, so you were just the crime scene detective, but as I understand it, subsequent to your investigation at the crime scene, you may have been tasked with a few things here and there as follow-up investigation.
As it pertains to the scene, yes.
So as the crime scene detective, you worked hand in hand with the crime scene investigator or crime scene tech to document the scene, as we just saw the state demonstrate with a variety of photographs.
Yes.
Now, is there any way for you to tell the jury how all of the items that you just went through with Mr. Chambers ended up in their final resting places?
What do you mean, Counselor?
Well, do you know how those items ended up where they did?
Since since I arrived after most of the incident had already taken place and any fire rescue had already left and first responding deputies had already left, I can't attest to what was and was not removed during the actual incident.
The truth is, you wouldn't be able to tell the jury how many people walked through and disturbed that crime scene prior to your arrival, right?
No, I don't know.
But we both could agree that prior to your arrival, Deputy Hoffman and Lowe both arrived on scene, right?
Correct.
That deputies attempted to render life-saving aid to Mr. Lay, right?
Yes.
That EMS arrived on scene to render life-saving efforts, correct?
Yes.
Do you know how many?
That I don't know.
Do you know if they had, inartfully, one of the, like a gurney with them?
Typically, yes, in this particular instance.
At this point, there's no crime scene log, right? There's no log keeping track of who's coming in and out.
During first initial response, I don't believe so.
Is there any way for you to tell the jury how many deputies, EMS, fire rescue people walked through that scene prior to these tags and these photographs being taken?
I don't know.
Could be dozens.
That I don't know.
The dogs were, prior to your arrival, or if you know, were running around the crime scene panicking, right?
There were 3 dogs still in the park when I arrived. Yes.
And the point I'm trying to make for the jury, and I think we're there, is that there is no way for us, as you and I sit here, to know how these items, or if these items were actually where they're tagged when this event took place, right?
Yes.
In the interactions you had with Mr. Radford, he was cooperative?
I didn't have much interaction with Mr. Radford. Detective Herrick would have more to speak on with that.
Were you present for his interview at the station?
I was not.
Did anyone make you aware that Mr. Radford couldn't even remember his name when asked by Deputy Lowe?
No, I was not.
Are you aware, or were you made aware by either Detective Harrop or any of the deputies on scene that Mr. Radford had pointed out at the initial interaction with law enforcement a sign on the fencing that indicated the park was under video surveillance?
Objection. Calls for your second.
Overruled.
I observed the sign, yes.
So you did see that sign?
Yes.
3.5 years major crime detective, right?
Yes.
Would it make sense to you if somebody had just committed a murder? It was one of the first things to tell detectives or law enforcement, of course, after calling 911 and staying like all civilians and citizens of this country would expect somebody to do if they had to take somebody's life in self-defense. But would it make sense to you that one of the first things they say, if they had in cold blood killed somebody, oh, by the way, there's a sign, this is all recorded? Would that make sense to you as a major crimes detective?
Sustained.
The shell casings you indicated that were found, I think you said 45. If I told you that reports indicate they were 40 Smith & Wesson rounds, would that make sense?
It would.
And there's no indication that, or at least I believe I'm accurate in saying this, law enforcement deduced or assumed that those were from some other event, right?
At the time, I don't believe we could definitively say that. There was nothing at the time that indicated to us that they were directly involved in the current investigation.
Knowing what we know now, we know that Mr. Radford was armed with a 9mm, right?
Yes.
And it goes without saying, but I'm going to say it. Those rounds wouldn't even fit into Mr. Radford's firearm.
I would say so, yes.
similar questions, or in a similar vein to the questions I asked about how the items got where they got, and that nobody really knows because of the disturbance on the scene. The mugs that the state published photographs of, we also don't know how they ended up where they were, right?
Sorry, my red light, I can't say.
And what I'm getting at here is you documented them with crime scene where you found them.
That's accurate to say.
Do you recall if the handle to the mug that law enforcement ultimately determined belonged to Mr. Radford was glued on or screwed in?
That I'm not sure.
Is that something you all looked into?
That I'm not sure.
The clothes that were recovered in this case, did you have anything to do with that? Let me rephrase. The clothes that belonged to Mr. Radford.
I was present for the collection of, I believe, one article of clothing.
Which one was that?
The clothing that was recovered from, I believe, Deputy Lowe's vehicle.
Are you aware that Deputy Lowe removed that jacket or hoodie and just tossed it in the back of his vehicle?
That you'd have to ask Deputy Lowe.
When you received it, was it in an evidence bag?
I believe it had already been collected by CSI Mooney.
Now, as I understand, on March I believe it was 6th, you were tasked by Detective Harrop to go perform some type of laser measurement of a house nearby relative to the crime scene, right?
No.
You were not.
No.
Do you know who that was?
I do not.
Are you gonna ask another question? Are you thinking what's happening here? Did the hamster stop running on its wheel in your brain or what?
Did you have any involvement in, or were you ever tasked by Detective Harrop as part of your involvement in this case in seeking, obtaining, searching for surveillance footage in the homes nearby on West Jean or West Hannah near the dog park?
By means of a neighborhood survey or something similar to that, Counselor?
In any capacity?
My only involvement was the execution of the search warrant on nearby residents that may have had video cameras that I can't recall.
Is in March?
Yes.
Okay. Now, this crime happened before, correct?
Correct.
You've been a major crimes detective for 3.5 years, right?
Correct.
Safe to say, and I think you'd agree with me as we have this conversation with in front of the jury, that if video surveillance of a self-defense situation or an alleged homicide exists, that would be one of the top priorities for you as a major crime detective to obtain, correct?
Correct.
And as a 3.5 year, I would call you a veteran major crimes detective, that you're going to place a high priority on it, not or describe for the jury why at times surveillance footage is tough.
On some cases, some cameras can overwrite data, but not all. And sometimes that data can be erased due to memory capacity. I'm not certified in any kind of digital evidence capacity.
And nor am I. However, I think from your experience, you've gleaned that whether it's a 7-Eleven or a home surveillance system, the amount of time that evidence exists can be fleeting due to the storage capacity of the device. Correct?
Sometimes.
Now, knowing that, you would place a high priority on obtaining that evidence as soon as possible, right?
In most cases.
So if you were the lead right across the street, pointing at the very location that this incident may have taken place, would you have waited till February 12th to follow up to see if you could obtain that footage?
Overruled.
It would depend on circumstances surrounding the investigation. I can't say without knowing all the details surrounding each case, Counselor.
Would you have waited until March to try to obtain a search warrant to obtain that video surveillance footage? Now, when I say March, we're talking a month after this incident took place.
That would depend on when and how I became aware of that.
For argument's sake, let's say that you, as the lead detective, were aware on day one that a camera across the street from the West Dog Park had potential surveillance footage. Would you have waited until March to try to obtain a search warrant to get it?
I would have probably attempted to try earlier. Again, I'm not the detective that attempted to get that video surveillance, Counselor.
And I understand the difficult spot I'm putting you in because you weren't the lead detective in this case. But the truth of the matter is, you would have done something day 1, day 2, or even day 3. Not 10 days later, not 2 weeks later, not a month later, right? That's the truth.
Again, it depends, Counselor.
And I can understand the difficulty that question poses for you. And I think that the nature of your response has answered my question, so I appreciate that.
May I have a moment to confer, Your Honor?
nature of your responses has answered my question. I like the way you put that.
Judge, I'll send it to the witness.
All right.
So they didn't. I'm having such a hard time hearing her. So they didn't get surveillance, or they
No.
waited.
Going off defense's hypotheticals here. Detective Nix, can you just, as a law enforcement officer, just walk into someone's house?
No, I did not.
Now, what do you need to walk into someone's house?
Typically, not in all cases, but in most, that is consent to be there, especially when a crime is occurring or has occurring, exigent circumstances for search warrant.
So you need consent or a search warrant,
Correct.
or as you said, exigent circumstances, right? Okay. So let's say someone who owns a house says they don't want you in that house. It's kind of a problem, right?
Correct.
So you need a search warrant, correct?
In most instances.
Most instances. Moment to confer, Your Honor. No further questions.
All right. You can step down. Thank you.
Thank you, Your Honor.
She released from her subpoena?
Yes, Judge.
All right. Thank you. Need a break? All right. We'll take a quick recess. All rise.
I wish they would talk in the microphone or turn it on or whatever is causing the audio issues. It was
All right.
good.
We'll be in about a 10-minute recess.
Just for my own planning, we'll pick up somewhere around 11:20, 11:25. I can tell you that pretty early in Detective Harris.
Raise your right hand, please.
Yes,
Do
ma'am.
you solemnly swear or affirm that testimony that you're about to give in this cause will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you, sir.
Thank you, ma'am.
Step this way.
Yes, ma'am. Good morning. Yes, ma'am. Good morning.
That part I got.
If you would please introduce yourself and spell your name for us.
Yes, ma'am. My name is Robert Harrop,
Yeah.
Robert, Harrop as in Papa. Yes, ma'am.
Detective, well, Mr. Harrop, are you a detective with the Hillsborough County Sheriff's Office?
Yes, sir. I'm a detective.
And what is your current assignment with the Hillsborough County Sheriff's Office?
I'm currently assigned to the Special Investigations Division on the Internet Predator Unit.
And so that is a different assignment than you would have had February of last year, 2024.
That is correct, sir.
What were you assigned to February 2024?
I was assigned to the,
Now you're dealing with people who are doing like child porn kind of stuff on the computer, but before you were doing homicides.
that is correct.
And how long have you been doing homicides as of February of 2024? How long have you been?
Well, I was on the actual homicide section at that point for a bit under a year. Prior to that, I worked death investigations in the Special Investigations Division involving narcotics-related homicides as they relate to.
And that's what you've been doing in the recent history. How long have you been with HCS? So in total.
I started with the Sheriff's Office September 12th of 2010, so a little over 14 years.
Were you called to the scene of West Dog Park on Occident Street on the date of February 2nd, 2024?
Yes, sir. Yes, sir.
Explain to the jury, how does a detective get called to a scene? How does all that work? What comes in the immediate moments thereafter?
So typically a call goes out section. It is a homicide. The supervisors are commonly made aware of the incident by somebody on patrol or, another supervisor. The supervisors then will task the detectives on the squad with where to go. In this case, it was 6402 North Occident, which is West Dog Park, And then commonly the supervisors will additionally provide a set of tasks or give you, an assignment as it relates to the actual investigation itself. So pretty much always comes from the supervisor.
And what kind of assignments get handed out by the supervisor?
Supervisor will commonly assign like a lead detective, somebody to assist them, a crime scene detective. There's an array of different assignments, but there's multiple for every homicide.
And so a scene detective, what is their responsibility?
Their responsibility is to focus primarily on the crime scene itself, to document the facts.
What just happened? That's on their end. No, that's on their end. That's not on my end.
To a suspect or things like that?
No, usually it's pretty singular focused. Sometimes we have more than one crime scene. There might be two assigned, to go to different places, but it's pretty singular focused on the actual crime scene itself and the evidence.
And who was the crime scene detective in this particular case where Gerald Radford is the accused?
Detective Kelsey Davis.
She's now Kelsey Nix?
I believe so. I believe so.
Right,
I believe
okay.
so.
What assignment were you given then?
I was assigned the lead detective role.
And what does a lead detective do compared to like a scene detective?
Most commonly, we're tasked with doing interviews of involved parties, and then, in essence, filtering the information and mainly focusing on the actual interviews themselves is the primary.
So you talk about there's a lead detective, there's a scene detective, and then there's other detectives that might get assigned other tasks. There's other tasks that might get assigned, like looking for other potential witnesses, like going into the neighborhood and see if anybody by chance heard anything.
Certainly, yeah. So oftentimes on homicides, that's also a task of patrol deputies. But if we are in a neighborhood or something like that, those tasks could include a detective being specifically assigned to what we call a neighborhood survey, with go to nearby homes and things to try to talk to people, see if they can develop witnesses. And that can be a primary focus, or there might be multiple tasks that detective is given, but that could be one of the tasks.
We live in a modern age, digital age, is another task that might get assigned to going and looking for surveillance camera, video footage, things like that.
Correct.
And so when the scene, when the investigation initially starts, you got one detective at the scene, you got a lead detective out talking to people, and you got other detectives maybe doing whatever else might be needed.
That is correct.
And that's the standard sort of operating procedure in any homicide investigation.
That's correct.
So in this case, did you end up responding to the scene at West Dog Park to just initially go there and see what you could determine from the evidence itself that was like visible?
So yes, sir. I did respond there. The call initially came out at 7:55 a.m. My supervisor was made aware of it, Sergeant Florio. He advised me of the incident at around 8:50 a.m. And then I departed our office and arrived at the park at, I believe, 9:31 a.m. And that was my initial response was the West Dog Park.
All right. So I want to clarify, make sure they heard that. What time do we believe the incident occurred? What are we using as a point of reference?
So the call itself was memorialized as approximately 07:55, so 7:55 a.m.
And when you say the call, do you mean a 911 call?
Correct. So that's the call I look at that's imported into the computer system. It was imported at 7:55 a.m.
All right. And just while we're talking about the 911 call, I'm going to go ahead and play what has been admitted as State's Exhibit number 15. The disc is over there, but I have it here.
February 2024, 07:55 and 07 seconds.
911, do you need police, fire, or medical? Hello, 911. Okay, hang on. Hello? Hello, 911. Do you need police, fire, or medical? Yeah, please. I just have to shoot somebody at West Dog Park. Can you repeat that, sir? West Dog Park. I was just attacked, and I have to defend myself. I had to shoot somebody. Sir, what is the address that you were at? It's Octagon Road, West Shaw Park.
Detective, I played the first 53 seconds or so. Just want to ask, this 911 call we're listening to, this is the 911 call you heard, right?
That is correct, sir.
There's not been any sort of audio enhancement or change or anything?
No, sir.
The reason why I ask is I don't hear any music playing.
But neither do I, sir.
And do you have a weapon on you, sir? I do have a weapon, and I'm unloading it, and it's on the table. I think you might be dead. And about how long does this occur? Minutes. I called as soon as I could dial the number. On the table, so are you in a house? No, I'm at a dog park. And who did you shoot? This guy is constant. Do you have to know his name and what's going on? Yeah, I've been having trouble with this guy for months and months and months. I'll explain to you please from the get-go. Oh my God. And you are still outside that dog park? What are you wearing so that you can see him? I'm sitting at the table in a camouflage jacket and jeans. Oh my God. Jacket and jeans? Yeah. And where's the victim? Where is that guy? He's just lying in the park. You said he's in the park? Where in the park? He's just lying in the park, man. Oh, God. What is your name, sir? Gerald. G-E-R-A-L-D. And
Detective, I think I hear the voice saying Gerald, G-E-R-A-L-D. Is that the spelling of the defendant's name as you know it?
Yes, sir.
You didn't spell it incorrectly, did it?
No, sir.
Was there a pause between where they ask, what's your name, sir? And he says immediately, Gerald? Is there some pause that we edited out?
No, sir.
The person you shot, what is he wearing? Shorts and a jacket. What color shorts, sir? Gray, brownish gray. Oh, man. You got anything? And last I recall, you said you were by the table. Are you still at that table, sir? Yeah, I'm right here. And is the weapon still on that table? Yes, it is. And you said you unloaded the weapon? Yeah. Oh, and it's that table you're sitting at, correct? Yes. And how many times did you shoot him, sir? One. And where was he shot at? I don't know.
Detective, we just heard Mr. Radford say, I don't know, and ask where he shot Mr. Lay. Do you, later on in the investigation, get to interview Mr. Radford back at like the HDSO district station?
Yes, sir. I interviewed him at our District 3 office.
And how much time, this is 7:55, they're approaching, somewhere right before 8 o'clock. What time do you think you interview Mr. Radford when you're back at the station?
Maybe around 10:30. I'm not sure the exact time.
So 2.5 hours later.
Yes, sir.
By the time we get to 2.5 hours later, we haven't gotten there yet, but in the interview, Mr. Radford, is he able to give you very specific details about where he shot Mr. Lay?
Yes, sir.
He grabbed hold of me and I'm about to be on the ground. I was scuffling around in the ground. And I managed to grab him, hit me in the face with his fucking cuffs.
I know that's how you stop my. Man.
Hi, sir, and I just want to confirm, you're still at that table, correct? I'm in the area of the table, the gun's on the table underneath my hat. And when you say you're in the area of the table, where exactly are you? Just like, you walk in the gate and it's a table. You walk in the gate of the dog park, there's a table just to the right, under a gazebo. I'm under the gazebo.
Detective, you've been to this dog park. In terms of the description of you go through the gate, you walk through the gate, I'm at the gazebo, all those. That's a correct recitation of what the scene is like, right?
That is correct. When you walk through the pedestrian gate, there's a sidewalk that leads to a covered like picnic style table under a gazebo.
We haven't heard it, but I want to make sure. Is there some part of the video, the audio that's edited out where Mr. Radford is slurring his words, responding incoherently, just babbling about something, making any sort of indication, doesn't know where he is, what he's doing, what the scene looks like? Any of that?
No, sir.
He sounds
He's about 25 yards away.
not incoherent though.
You said he's about 25 yards away from you? Yeah. I had to shoot him with laughing. He attacked me. I had to shoot him. Hello there, sir. Yeah. I'm gonna go ahead and get you over to the fire rescue. Please do not hang up. I won't. I'm sorry.
Hillsborough County Fire Rescue, what is the address of the emergency?
It's at Oxford Road, West Village, West Park, Dog Park. I see a police car coming now.
Okay, is this, somebody was shot?
Yeah.
Okay. Are you the victim or are you with the patient?
No, I'm the do it.
I'm sorry, I couldn't understand what you said.
I'm the guy who has to do it.
Oh, okay. So you're calling 911 for the person that was shot?
Yes.
Okay. Yeah. You see the police officer? Can you flag them down? Okay, I'll let you go talk to them.
Thank you.
You're welcome. Bye-bye.
Detective, towards the back end of the call there, we heard Mr. Radford saying things like, I had to shoot him. He attacked me. He attacked me. I had to shoot it. I'm the guy who had to do it. There's some missing part of the call when you heard it that's not here now, where he said, I thought I was going to die. I thought he was going to kill me. I thought he was going to pound my face in. I thought he was going to make me a cripple for the rest of my life. Anything like that?
No, sir, that was not stated.
All right, so now you arrive at the park. You know that this is already a self-defense claim, correct?
Yes, sir.
Now, I want to talk with you because I'm sure the jury doesn't have any understanding of how this normally works. When a homicide occurs, you get called out to the scene, right?
Yes, sir, that's correct.
Do members of my office, the state attorney's office, particularly homicide prosecutors, get called to the scene?
Yes, sir.
And I wasn't the original prosecutor on this, correct?
That is correct, sir.
But when an investigation of a homicide occurs, there are things for which you sometimes need a lawyer, like you want to get a search warrant approved or you want a subpoena issued, correct? That is correct, sir. And we assist you in that.
Yes, sir, you do.
But there is also an agreement between the sheriff's office and the state attorney's office that arrests are not made without the state attorney's office signing off on it, correct?
That is correct, sir.
So it's not like you can just decide to make an arrest on your own if you really wanted to.
Not regarding an investigation like this, sir.
Well, I mean, I guess you could, but then your boss and my boss would probably have a conversation with each other.
Yes, sir.
Okay. And so when it's a self-defense case, is there also another step where sometimes HCSO homicide detectives like yourself have to come to my office and actually make a presentation to what's called the homicide committee?
That is correct, sir.
So that's a whole nother step,
Yes, sir.
again, to decide whether or not an arrest is going to occur.
That is correct, sir.
Would it be fair to say that some of the prosecutors in the room can make you want to have to jump through all the hoops before a decision is made?
Absolutely, sir.
So you arrive at the scene and you know that you're already working on a self-defense claim. I just want to ask you about this picture, which is State's Exhibit 2E. Let me click over that, sorry. Here in 2E, we can see this area in the dead center of the picture, just to the right of the tree. There's kind of this brightly colored bucket, it looks like, on the ground. What is this area?
It's like a dog watering type area. I think there's like some concrete there, a couple of like Rubbermaid or like plastic bins that contain water.
Okay, and so even here in this early picture, you can just make out to the right of this sort of T-shaped wooden structure, there's something blue here on the ground. Do you know what that is?
Like a travel style mug.
Some kind of mug or something.
That is correct, sir.
Okay, and so, you know, angles in pictures can be a little confusing or a little deceptive sometimes, but this doesn't appear to be right next to this fire hydrant, for example.
It is not, sir.
Now, as part of the investigation, you know that other deputies would have responded first, like initial responding deputies, and that many of those deputies wear what are commonly known as body-worn cameras.
Yes, sir.
I'm going to show you State's Exhibit number 1. I'm going to jump ahead here a little bit. Oh, it's not on the screen, sorry. There we go. Is that the defendant wearing the camouflage jacket?
Yes, sir, it is.
I can hear singing. Someone is singing, "I'll send an SOS to the world." I'm a little bit of a fan of classic rock. I think that's the Police, "Message in a Bottle."
I'm not super familiar with
Yes,
that song,
it is.
but there's definitely a song in the background.
I mean, you don't expect that HCSO deputies are walking around with portable speakers on them playing music when they're conducting an investigation, do you?
No, sir.
What's going on the table?
I'm just going to back up a second there because we got a semi-decent view of it. The defendant is wearing blue jeans, right?
That is correct, sir.
And we can see he's wearing a camouflage jacket. Did you ultimately discover the defendant had on sort of layers that day because it's February and it's cold?
Yes, sir.
Did he have on like a camouflage jacket over like a black hoodie, over like a green sweater, and then sort of like one of those blue sort of shirts that's like to wick moisture off of you?
That is correct.
So he's wearing multiple layers, but he appears his outer layer is jeans on the bottom half of his body, correct?
That is correct, sir.
So I'm going to jump ahead here.
That's how you
The
get
deputy
from Florida.
approaches the dogs. All right, here at 59 seconds, I can see this bright yellow bucket and this sort of T-shaped structure. Is that the same water area we saw before?
Correct, sir.
And then we can see the body and the dog in the distance here to the right and the fire hydrant, correct?
That is correct.
Okay, it's okay. I know. It's okay, buddy. It's okay.
Detective, I'm going to point here with the mouse. There appears to be an object right here-ish to the right of the T-shaped wood structure, and another one here-ish to the right of that, between a little closer to the body of the victim, but right at the edge of where you can see the gray dirt. When you were at the scene, did you see items on the ground there?
Yes, sir, I did.
Did you see the blue travel mug?
Yes, sir, I did.
Did you also see a darker blue thermos mug with a broken handle?
Yes, sir.
This would be the first responding deputies, right?
Yes, sir, that's correct.
Based on the video, it doesn't look like any other deputies have walked through the scene. First emergency rescue, like the EMS guys haven't gotten there yet. Gurneys haven't been wheeled through. Nobody's appeared to have walked through there from law enforcement or EMS to have disturbed the scene, does it?
No, sir. They were the first to arrive.
Here I'm at 127. That object appears to be blue, the one that I pointed out earlier, correct?
Correct, sir.
And now at 132, does that look like the blue travel mug and the blue thermos mug as you found them at the scene later on when Mr. Radford does what's called a walkthrough and actually says, that's my mug and that's the victim's mug?
Yes, sir.
All right, so you now arrived at the scene. You become aware of the fact that there is a person being detained, and that is Mr. Radford, correct?
That's correct, sir.
And when you met Mr. Radford, had he already removed some layers of clothing?
Yes, sir, he had.
What layers had he already moved at that point?
I believe at that point, the camouflage jacket that was in the video was removed. I believe there was also underneath that a black hooded like sweatshirt with some white on it that had been removed. And I believe when I arrived, he was wearing a kind of olive drab green in color like sweater, basically.
Right, and so here is Defense Exhibit 1. Let me put that up there on the screen for you. Is this what you understand Mr. Radford originally would have looked like? Camouflage jacket, black hooded sweatshirt, and then some of your green sweat blue.
Yes, sir. Prior to my arrival, yes, sir.
All right, and here on the front of the hoodie, does this appear to be of note to you? What does this look like to you?
Suspected blood.
But also in this picture, Mr. Radford appears to have blood dripping down his nose, correct?
That is correct, sir.
So detective, you are not the scene detective, but still you are aware of a few things that are recovered at the scene, correct?
That is correct, sir.
One of which is a firearm.
Yes, sir, that is correct.
Specifically the firearm that is admitted here as, I believe it states Exhibit 5. Can I get the thing? Yeah, I'm just gonna get the tag off so people can see it. That's a little better. All right, detective, is this a firearm?
Yes, sir.
Specifically, is this what's called a semi-automatic firearm?
That is correct, sir.
People may have watched cowboy movies and seen the old style cowboy movies with like the cylinder in the middle that spins and all of that. That's not a semi-automatic, that's like a revolver.
Correct, sir.
How does a semi-automatic work? You carry one, something similar to this for work, right?
Yes, sir.
There's this other object over here. What is this?
Magazine, which holds the ammunition.
All right, so if you wanted to load this gun, assuming you had bullets, what would be the process one goes through?
You would load the magazine initially with your bullets, and then towards the bottom of that grip is where that inserts, the mag insert. After it was loaded with the bullets, you would put the magazine actually into the gun and secure it. And then in order to chamber around, in essence, or make it to where it was ready to shoot, the slide, which is the upper portion, which contains both the rear and front sight, you would pull that back and let it move forward to basically put the round inside the gun itself.
Okay, and so the gun would, for example, this will be easier with a picture. You pull this part up here, is this the slide?
Yes, sir.
You pull that back, it releases whatever mechanism or whatever, and then slides forward so that the bullet is chambered and the gun is ready to be fired.
That is correct, sir.
And so, oh, I'm sorry, for the record, I am showing State's Exhibit 4H. That's the picture I was showing. When a person has a gun, people talk about guns jamming. Is that what's also commonly called a stovepipe? Is that a type of jam?
Yeah, that could be a malfunction that semi-automatics have.
Tell the jury what a stovepipe is for anybody who doesn't know.
So I'm no gun expert, but in essence,
Are you trained to clear a gun jam like a stovepipe?
For sure, yeah. So
Okay.
I just don't know how eloquently I can explain this, but in essence, whenever you fire the round, the slide kicks back and ejects the spent casing, which the bullet was, originally in.
So I'm not moving like John shooting a gun. I see bullets flying out the side.
Correct. For a semi-automatic firearm. So if the slide or, if it doesn't come back completely, when the bullet goes to eject, it goes forward prior to the bullet fully ejecting, it'll get caught inside of the port that it's supposed to eject from. And in essence, whenever the malfunction occurs, it doesn't allow another round to go in. It blocks the slide from moving all the way forward, and it looks like a stovepipe, if you will, because the round is sticking up, kind of facing, upward.
So looking at States 4H again, this sort of indentation here in the slide, this is where a bullet or a spent casing would normally eject from the gun.
That is correct, sir.
The actual bullet goes out the front of the gun, so that's a spent casing.
The spent casing comes out of that ejection port.
But you talk about it can get like stuck standing sort of straight up and prevent the slide from going back and forth.
Correct.
What is the process by which you clear that?
Well, you'd have to pull the slide all the way back, clear the round from the slide, and then, in essence, allow the slide to go back forward to rechamber around.
All right, and so if a bullet is sort of stovepipe here, standing up, you pull the slide all the way back, that releases the tension on the stovepipe and it can be ejected, basically.
Yeah, correct, sir.
Once you've ejected the stovepipe and released the slide, what happens to the bullets in the magazine?
The would then, enter into the, would become available.
It goes from the magazine up into the chamber?
That's correct.
So here is State's Exhibit 4I. Are you aware of the fact that the gun was recovered with ammunition in the magazine?
Correct, sir.
All right, and so this magazine appears to hold 6 bullets because it's got 1, 2, 3, 4, 5, and then you can put one more in, right?
Yes, sir.
All right, and there appears to be 1, 2, 3, 4, 5, 6 bullets in the magazine as it was found by the crime scene detectives and the crime scene investigators, correct?
Yes, sir.
So, maybe the jury doesn't know this. Theoretically, put 6 rounds into the magazine of a gun, put the magazine at the bottom of the gun, like, load the gun basically, rack a bullet or pull the slide back to put one in the chamber. I could pull the magazine back out, which would now only have 5 because one went in the chamber, and I could put one more back in the magazine, right?
Correct.
Like, for example, you carry a firearm. How many does your magazine hold?
I think these are 16 plus 1 or 17 plus 1. So we load it to max capacity, chamber around, drop our mag, put the other bullet in there, and then the mag is at max capacity and there's one in the chamber.
And is that why you call it 16 plus 1 or 17 plus 1? Because it's 16 or 17 in the mag and plus 1 in the chamber?
Correct.
Okay. Mr. Radford also ultimately tells you, we'll get to the interview, but he ultimately tells you that he carries his gun with 1 in the chamber and the mag fully loaded.
He does state that.
So that would suggest 7 bullets.
That would be correct, sir.
And so we are under the impression, all indications point to, we have no reason to doubt that there's only 1 gunshot in this case.
Correct, sir.
So 6 bullets in the mag and 1 that got fired, correct?
Correct, sir.
But if the first one was a stovepipe and you had to clear it, we should have found the spent shell casing, shouldn't we?
Correct, sir.
Did we find a spent shell casing?
Crime scene or the sheriff's office did not locate a spent shell casing.
I mean, there was a whole line search conducted to try and find casings, and we actually found casings for some 40 caliber gun that's not in any way related to this, right?
Yeah, yes, sir. I was advised that.
So you found casings, just not the one we actually needed.
That is correct, sir.
But also, if there were 6 in the mag, and then the 1 in the chamber, the 1 in the chamber stovepipes, 1 from the mag should have gone into the chamber, right?
If it was properly cleared, yes, sir.
But in this case, we found the mag fully loaded, right?
That is correct, sir.
The only way that happens is somebody has to eject the magazine, take the round out of the chamber. You have to eject a live round, and then put a live round back into the magazine, right?
Yes, sir.
I don't mean to suggest that's the most difficult thing in the world to do, but I mean, that takes a little bit of focus and attention, doesn't it?
Yes, sir.
Mr. Diaz, is this a good time?
If you want to, yes, Your Honor, yes.
All right, we're going to go ahead and take our lunch break at this time. Same admonition I always give you about no discussion about the case, no coming to any definite fixed or final opinions on the merits of the case. I will see you back here at 1:15. Enjoy your lunch.
All right.
Okay. We are done for the day. So, tomorrow, what's tomorrow? Wednesday. Karen Reed is Thursday. Tomorrow, we're going to try to get caught up to live on this one. I don't know what we're going to do Thursday. What is all over my computer screen? It looked like I had something coming out of my nose. Oh, I know what it was. I did my nails yesterday. It was probably the dust from the nail stuff. I guess we'll play it by ear Thursday because we're going to have a trial and a hearing, and then my internet's going to be being worked on in the afternoon, so we'll just play it by ear. And Judy, well, I'll talk to you and figure out when you're leaving and all that kind of stuff. So just show up at 9. We'll figure it out. I'll be here. Oh, that's right. Tomorrow. That's Thursday. Wait. I'm so confused. Tomorrow's Wednesday, right? Yes. Tomorrow's Wednesday. Thursday. Tomorrow we're doing this trial. I don't even know. Where's my head? I don't know where my head is half the time. Okay. So tomorrow we're getting caught up to the live on this trial, and then we will jump over to the Griffith verdict if we have one tomorrow. And on Thursday we're gonna wing it. We're gonna do what we can do when we can do it, and then hopefully I'll have decent internet by Friday. And again, we will have the same problem with a hearing and a trial both to cover, but we'll do it. We'll figure it out. We'll get it done. So once again, I'm just left with my OGs at the end of the day. So I love you guys, and replay crew, I love you too. This has been a big mashup of 2 trials and me just being me. And I'm gonna try to separate it out. The last time I did that, I was not able to. The last time I did a mashup like this, I just changed the thumbnail to show that there were 2 different things going on. So I don't know what's gonna happen, but it doesn't matter. I don't know. So I'll see you guys in the morning at 9 o'clock. Bye. Have a good evening. Love y'all.